Good morning, everybody. Thank you for coming out this morning. I know it's an early morning. We got our coffee and breakfast. Thank you all again for joining us and for making the time out of your day to sit with us students and learn what we can around the theme of constitutionalism. My name is Austin Orthagen. If you have any questions, I'm here to help. But I want to pass it off to Dean Nichols and Editor-in-Chief Taylor Daniels to start our welcome for the symposium. So once again, thank you again.
Thanks. Welcome again to all of you. The good news is you get to be a little patient. There's a long warm-up of people that get to say hi and welcome and introductions. That's the way we do it. For those of you, if there's any I haven't met, I'm Joel Nichols. I'm the interim dean here at the School of Law. I'm delighted to welcome you. Students, thanks for coming out this morning. I am really grateful to Austin, Taylor, and all of you for the hard work that's already gone into this, and for what I know is going to come and be a really nice contribution, not only today, but in the publications afterwards. Really look forward to seeing some of that. And one of the great things about conferences and these things, right, is that we get to mix and think hard today, but also do the work of contributing in a going forward basis, that we get to do it as academics. So there's a danger always in letting a dean have a microphone and make any comments, because I'm also a law professor at heart, which means I think I can talk about anything for a long period of time. I'm going to refrain and just try to limit myself and not be an expert, because all of you are, but just really heartily welcome you to this place and this space. And then just make two observations, kind of one on the theme that you're going to unpack a lot more today, which will be of interest, and then the second connecting to what we do here. So the idea of this conference at its core seems to me really about how we structure our collective lives together. I've been interested in this in a long time, right? And I'm naming for the students here. The rest of you think some of these already, right? But I didn't have in my head for a long time what it is that we mean by law, right? And so often still when we think about law, really what we're talking about is how do we want to set up these norms, these regulations, these interactions for each other and ourselves, and then what's the enforcement structure for that, right? Collectively, that is our structure, that is our law. In this conference, we think of that at one step up, right, at constitutionalism, right, and how we just put this together. Sociologists study these same kind of norms, right, how groups interact with one another over time, who's in, who's out, what the enforcement structure may be. Political theorists love to study this stuff, right? Usually in the realm of power, a lot of times in the realm of kind of metrics and who's tracking what. Religion and theology scholars for a long time would study the same kind of thing, right? How do you set up norms by people that are like you, not like you? Kind of who's in, who's out, what does that look like? We lawyers do this, and I like that we've kind of bounced out one level to think about this in terms of constitutionalism, in terms of rule of law. But we get all these tensions, which I know you're going to tease out more today. What does this mean for majority rights versus those who don't have as much power because they're in a minority voice? How do you protect collective needs, but sufficiently take care of individual needs? And how do you balance the need for the steadfastness of law, for consistency over time, even in the structure itself, with the need for nimbleness, flexibility, equity, justice, mercy, those things, right? All that's packaged into this one-day conference, right? And I haven't even mentioned some of the very interesting things, like what does this do in our particular structure of our Supreme Court, our state constitutional courts, right? But I just wanted to give you that kind of that overall thinking as you're heading into it that I find really fascinating. Look forward to your contributions. The one tie I want to make to what we do here at St. Thomas, well, I'll make it two ways because I like to break things out, right? So, but one of them is I think about those kind of tensions and differences, majority versus minority, collective and individual. We want to also make sure we're respecting the full human dignity of every person that's here. How do we fully include them, right? And so part of what we do is know that we all come to this in different ways, but we all have to work together. So part of our project at St. Thomas is thinking, how do we connect across our differences to form something greater than ourselves and to make an inclusive place for everyone here? And that partakes of even the topics of this conference for the day. And then the other thing, which we want to do as a law school, is we really want to train kind of the next group of people that are making contributions to constitutionalism and to rule of law, to shape it, to live into it, and to make it better for each person individually, but also that group as a whole. So again, welcome to St. Thomas. I'm delighted you're here. I want to hand it off next to Taylor Daniels, the editor-in-chief of the JLPP. With her skill and the work of all of you and the able and always clever Dr. Charles Reed, you are in really good hands today. And so I look forward to everything. Welcome again to St. Thomas.
Good morning, everyone, in person and online. I would like to extend my sincere gratitude for everybody that is able to join us today. We have a wonderfully talented, intelligent, and dynamic lineup in store. I have a few things I want to mention before we get started. So first, I would like to thank and recognize our symposium director, Austin Northagen. He actually just stepped out, but he and his committee spent a lot of time ensuring that today goes smoothly. So thank you all very much. Yes. Second, a little plug. We have recently revamped our podcast. Our first episode actually launched last week, where one of our speakers for today, Mr. Jorge Farinacci-Fernos, was interviewed, and he briefly discussed his topic that he will be discussing today regarding updating and replacing the US Constitution. So those links will be on our website very soon, but it's very interesting, super engaging, and please take a chance to listen to that. I really enjoyed when I listened to it, so I hope you all do as well. Finally, please feel free to ask questions as they come up today and enjoy your time with us. So to get us started, I would like to introduce our faculty advisor, Dr. Charles Reed, over on the end.
Thank you for that wonderful introduction. Dean Nichols, thank you for that wonderful introduction also. And I just would like to add, what does constitutionalism mean for me? And when I think about constitutionalism, I think primarily about restraining the powerful. We live in a world where power can be very easily abused. Constitutionalism is about the restraints we as a society put on this power. And we build networks, we build institutions that are meant to restrain the arbitrary, capricious actions by powerful actors. And thereby we make smooth a path for human dignity, we make smooth a path for respect, for the kinds of values we treasure as a constitutional and democratic society. This afternoon, we'll be examining constitutionalism in all its facets, from the medieval world up to the present. We'll be looking at it from a comparative perspective. We'll be looking at it from a nuts and bolts constitutional law perspective. We have, in other words, a very rich, a very diverse group of speakers. And I thank you all for being here, and I look forward to this morning's panel. Thank you.
Great. Thank you, everybody, for those wonderful introductions. Now we can get to the meat and bones of the day. And I want to introduce our first panel of the day. So our first panel, let me back up. There is a schedule, there is paper programs on the way. We will be getting those later in the day. So I just want to provide a layout of how the schedule will go for today. So first we have our first panel at 8:15 on institutionalism, federalism, and the comparative method. And then at 9:30, we'll take a 15-minute break. 9:45, we'll have our second panel on constitutional history. And then 11 a.m., we'll have lunch. And then we will be handing out a book from our keynote speaker who will be presenting at noon, Akil Reed-Amar. And then after Akil, we will be taking another break, or another short break, depending on how much time is left over. At 1 o'clock, we'll have our third panel, the rule of law and the Constitution. And then at 2:15, our last break for the day. And then at 2:30, we'll have our fourth panel on constitutional theory. So those will be our 4 panels of the day. I will be getting those programs later in the day and hand those out to you all so that you are aware of the schedule for the day. But now we will get to the meat and bones. So on the first panel today, we have Noah Chauvin. Noah, he received his BA from SUNY Geneseo, and his JD from William & Mary Law School, where he was the editor-in-chief of the William & Mary Law Review. After graduation, he clerked for 2 federal court judges. Now he is an attorney advisor in the Intelligence Law Division of the Office of the General Counsel at the U.S. Department of Homeland Security. He has published several articles in law journals across the nation, including the University of Richmond Law Review, the University of Florida Journal of Law and Public Policy, the Regent University Law Review, and the University of Memphis Law Review. Second, we have Kimberly Breeden. Kimberly is an assistant professor of law at Ohio Northern University College of Law. Her research focuses primarily on constitutional and international law dimensions of corruption or potential corruption by government officials. She has published articles in several law journals and has presented her work at international and national conferences, symposia, and workshops. Most recently, Professor Breeden presented her paper, Disinformation, Corruption, and International Law at a conference on Nordic perspectives on the international legal regulation of cyberspace. Professor Breeden earned her JD from the University of Cincinnati College of Law and her LLM from Columbia University Law School. And lastly, presenting with us virtually from the United Kingdom, we have Ilaria De Gioia. She is a senior lecturer in law and associate director of the Center for American Legal Studies at Birmingham City University in the United Kingdom. She leads the law school's modules in American constitutional law and teaches the American Legal Practice module, which prepares students for internships in the United States. Her research investigates the role of the courts in setting the balance between central and local governments, and more widely, the various ways in which constitutional law interacts with the political process. She has published and presented research in the United States and Europe on the federal aspects of the Affordable Care Act and the sanctuary cities phenomenon. Besides academia, Dr. De Gioia devotes her free time to public service in her capacity of honorary vice consul for Italy in Birmingham, United Kingdom. And Dr. Reed will be our moderator for this first panel and for all of our panels. So please, let's give a warm welcome to our panelists.
All right, good morning, everybody. Like Austin said, my name is Noah Chauvin. And before I begin, I want to give just a brief caveat, which is that while I do work for the federal government, I am here solely in my personal capacity. Yes, my views don't necessarily represent the views of my employer. And with that, let's talk about Justice Kavanaugh's institutionalism. Now, at first blush, it may seem a little strange to hear me talk about Justice Kavanaugh as an institutionalist. Typically, when we talk about an institutionalist on the Supreme Court, and particularly in the conservative wing of the Supreme Court, we're talking about Chief Justice Roberts. He's a judge who is broadly understood to be deeply concerned both with his own personal legacy as Chief Justice and also with the court's institutional reputation. He wants judges to be viewed as people who are just calling balls and strikes, as he has said. Right? They are neutral arbiters of law, and they are not political actors. And we see this in the manner in which he performs his job. Right? He is understood to moderate his opinions. He has a conservative view of the law. We believe that he wishes to advance that view of the law, but he does so incrementally. Right? He favors an incrementalist approach. He doesn't want to get to kind of his vision of the law in leaps and bounds. He also has been reported on at least one occasion to have changed his vote in a case to avoid what he was concerned would be seen as a politically contentious outcome. However, there's reason to question whether that approach to legitimacy is the best one. And part of the trouble here is that we don't really know what it means when we're talking about legitimacy, right? There's a number of different components to it. Professor Richard Fallon has identified three facets of legitimacy, which are up there on the screen. The first is sociological legitimacy. We might also think of this as political legitimacy. And this has to do with whether the public at large respects a court and is willing to follow its decisions. Next is moral legitimacy. This has to do with whether a court's decisions are morally good. Obviously, this one is going to be the most difficult to qualify, right? It's very much in the eye of the beholder, but certainly at the margins, it can be very helpful, right? I think under kind of any sort of moral framework that you use, the courts of Nazi Germany, for instance, were morally illegitimate. And then last on here is legal legitimacy, and that has to do with whether judges are making decisions using methods that are broadly accepted within the legal community. Now, this doesn't mean that they have to be applying a particular method. There are a number of methods of legal interpretation and judging, all of which are legitimate. But for instance, if a judge is making decisions by flipping a coin in her chambers, that's legally illegitimate. The trouble with Chief Justice Roberts' approach to legitimacy, right, moderating his opinions, occasionally changing his vote to avoid reaching decisions that people might view as illegitimate, is that he is trying to shore up the court's sociological legitimacy, potentially at the expense of its legal legitimacy. And this is because Article 3 sets the parameters under which federal judges operate. And it doesn't give a lot of detail, right, as with much of the Constitution. But it's pretty clear from constitutional structure that federal judges are supposed to be somewhat insulated from political considerations. Those are left to the elected branches of government. Judges are supposed to be making legal decisions about cases and controversies. And so the concern with Chief Justice Roberts' approach is that by changing how he's voting based not on his view of the law or what the law requires, or at least not in full based on his view of the law, but in part based on his concerns about the political impact of a decision, is that he's sacrificing some of the legal legitimacy of the court to shore up the sociological legitimacy. And that's where Justice Kavanaugh's approach to the court's legitimacy differs and is a bit interesting. Now, in his 4 terms on the court so far, Justice Kavanaugh has been in the majority an awful lot, and we'll talk about that a bit more later. But what that means is that he's written a lot of concurring opinions. He doesn't have to, right? But he writes separately a great deal to explain his reasoning. In most terms, he has been exceeded in writing these concurring opinions only by Justice Thomas, who concurs an awful lot because he has a somewhat idiosyncratic view of the law. And in the most recent term, Justice Kavanaugh exceeded even Justice Thomas. And these concurring opinions not all, but many of them follow a very similar pattern. Professor Josh Blackman has referred to them as the Kavanaugh concurrence. And these are typically short opinions, often no more than 2 or 3 pages, in which Justice Kavanaugh will do 2 things. One is to discuss institutional roles, and the other is to focus on limitations, or I should say limits of the majority opinion. And we're going to talk about each of those in a little bit more detail here. So first, in focusing on the institutional roles, that's not necessarily something that's unique to Justice Kavanaugh, right? Like most of the conservative justices on the court, he is deeply skeptical of judicial policymaking and to some extent of executive branch policymaking. Right? But what's interesting in these concurring opinions is that he will often go into detail as to how people who are unhappy with the opinion can nevertheless get relief, right? And often he explains pretty explicitly how there are kind of political solutions, right, that don't necessarily involve the Supreme Court. And so I have a number of examples on the screen there. One of them that I want to draw your attention to is from the Dobbs opinion from this last June, right, in which he went into some detail in talking about how, while the Supreme Court was finding that there was no constitutional right to obtain an abortion, it also wasn't finding that the Constitution forbade obtaining abortions, and that if people wanted protections for abortion or greater protections for abortion, the political process was still very much available to them. The other feature, as I've said, of these concurring opinions, of these Kavanaugh concurrences, is a focus on the limits of the majority opinion. He goes to, again, sometimes, and it's difficult to call them great lengths for 2 to 3 page opinions, but often much of the opinion is taken up with him focusing specifically on what the opinion does not do. And again, there are a number of examples up there on the screen. I want to actually refer at slightly greater length to one that's not on the screen, and that is again from Dobbs. One of the great concerns when the Dobbs decision came out, and particularly following the leak of it, was that the logic of Dobbs could be used later on in a later case to overturn the constitutional right to obtain contraception for married couples, to the constitutional right for interracial marriage, and the constitutional right for gay marriage. And in addressing those concerns, Justice Kavanaugh wrote, "Overruling Roe does not mean the overruling of those precedents, and does not threaten or cast doubt on those precedents." He also spent some time addressing concerns about potentially draconian restrictions on abortion, specifically having to do with whether states could criminalize or prohibit their citizens from traveling to another state to obtain an abortion, or whether states could prosecute people who had obtained abortions on an ex post facto basis. And in both instances, Justice Kavanaugh explained that such restrictions would be unconstitutional. Now, what does all of this tell us about Justice Kavanaugh's approach to the institutional legitimacy of the court? Recall that Chief Justice Roberts, in trying to shore up the court's legitimacy, appears to be moderating his opinions and, in extreme cases, even changing his vote. Justice Kavanaugh, in contrast, doesn't do that. He appears to vote his conscience, right? He's joining these majority opinions, usually in full. But he writes separately to communicate the ways in which people can obtain relief and the limits of the court's majority opinion. This is an approach to maintaining the court's legitimacy that differs from Chief Justice Roberts in that, in my view, it doesn't compromise legal legitimacy, right? In restraining himself to merely trying to explain the limits of the court's opinions in his concurrences, Justice Kavanaugh is comporting with kind of the Article 3 conception of a judge, right, who is not basing his decisions based on these political considerations, right? They're, I think, reflected in how he's talking about the opinions, but not impacting the decisions themselves. And in my view, that's the preferable way of trying to maintain the court's legitimacy, because it more closely tracks with kind of the constitutional conception of what federal judges should be doing. That being said, there are reasons to question this method's effectiveness. The first is that, for the most part, the general public, and I think most lawyers, are not spending their time poring through legal decisions, right? What they see are the end results, right? And the most that they're going to get into the reasoning will be, if it's reflected in a news article or on a hit on a cable news show, right? They're not necessarily going to have a deep understanding of the differences that are expressed in the written opinions of judges. And so if most people aren't going to see the forum in which you're trying to maintain the court's legitimacy, and all they're going to see is the end result, if you're not moderating the end result, most of the public isn't going to know about it. There's also reason to question whether Justice Kavanaugh is the best vehicle for messages that attempt to shore up the court's legitimacy, right? I'm sure I don't have to remind anyone here of the allegations of sexual misconduct he faced during his confirmation hearings for his appointment to the Supreme Court, right? And there are a great many people who believe those allegations and view Justice Kavanaugh as morally compromised, right? Additionally, There are questions about Justice Kavanaugh's the extent to which he's truthful. There are many people who believe that he lied under oath in defending himself against the sexual misconduct allegations. There also, this past summer, were renewed calls for his impeachment based on testimony that he gave during those same hearings in which he said that Roe versus Wade was settled precedent that was entitled to respect. Given his vote in Dobbs, many people believe that he lied under oath when he gave that testimony during the hearings as well. And so if he is viewed as someone who is not trustworthy, who is perhaps a liar, he may not be the best vehicle for shoring up the court's institutional legitimacy, particularly because I expect that many of the people that he would need to convince are the ones who find him not trustworthy. Now, I don't think any of my conclusions there are unassailable, but assuming that they're true, why should we care about it, right? What does it matter? To talk about that, I'm going to refer to this graphic a little bit. I want to make a couple of notes about it. First is that this is something that I whipped up in PowerPoint based off of other people's work, so it's a bit crude and it's not kind of perfectly to scale. The second is that I have Justice Ketanji Brown Jackson up there as a bit of a question mark. We don't know precisely where she will fall on the ideological spectrum of the Supreme Court. I think it is safe to assume that she's going to be somewhere to the left of Chief Justice Roberts. And that means that right now there is a solid 6-3 conservative majority on the Supreme Court. And that's the first reason why it's important to understand the different ways in which the conservative justices are approaching maintaining the court's legitimacy. We have right now a Supreme Court that is much more conservative than the general public. And with a 6-3 conservative majority, there's no way to form a majority on the court that doesn't include at least 2 of the conservative justices. And this means that the differences between the conservative justices in how they approach the law, in how they view their role as judges, and in how they communicate their decisions to the public are going to be even more important than the distinctions between the conservatives and the liberals. The second point is that you'll note that Justice Kavanaugh is the median justice. There are 4 justices on the court that are more liberal than he is, and 4 that are more conservative. As I said earlier, he's been in the majority an awful lot. Since joining the court in each term, he's been in the majority in, I believe it's somewhere between 93 and 97% of cases in each term. In the last 2 terms, he's been in the majority more than any other justice. Previously, it had been Chief Justice Roberts. And this means that his approach in particular is critically important, because if there's a majority that includes 2 of the conservative justices, it's likely that he's in it. And so whether you kind of support the goals of the conservative legal movement or not, right? If you are interested in advancing your interest, your client's interest before the Supreme Court, understanding how the conservative justices, and in particular Justice Kavanaugh, are approaching their role and how they're trying to maintain the legitimacy of the court, right, is going to be critically important. Now, I think we're going to have time at the end of the panel for questions, and certainly, look forward to engaging with you all then. But I will also say that the paper that I'm working on is still very much a work in progress. So I welcome any critiques or comments that you might have. If you'd prefer to provide them in writing, my email address is up there on the screen. And with that, I thank you for your attention.
I'm going to set my timer because, as has already been pointed out this morning, lawyers like to talk and law professors like to talk even more. I also would like to extend my thanks to St. Thomas, to the Journal, to Charles, to Austin, and to everyone who worked behind the scenes to put this symposium together. I know there's a lot of work that goes on that those of us who swoop in and share our thoughts on matters don't see, so I really appreciate your hard work on this. So I am Kimberly Breeden. I'm an assistant professor at Ohio Northern University. Unlike Noah, my title is quite lengthy. I apologize for that, but it's so long, it broke this PowerPoint slides. So I want to talk to you a little bit today about some comparative provisions in constitutions around the world that have adopted various anti-corruption mechanisms. And when I began this project, my initial thought was the more anti-corruption provisions that are expressly entrenched in the constitutional order, the less likely we will encounter government corruption, the healthier the democracy and the rule of law will be. And so every constitution should have express mechanisms to combat corruption. The farther I got into this, though, and it didn't take very long, the more I realized that express anti-corruption mechanisms are not in and of themselves going to be enough to protect democracy and the rule of law. So I started out with several questions. These are a few of them. My work, too, is very much a work in progress right now. I'm in very early stages about how I'm thinking about this. So the end of January deadline is looming large for me. But these are some questions that I wanted to ask. Why should a constitution entrench an anti-corruption mechanism or mechanisms into the constitutional framework? What types of anti-corruption provisions should be entrenched? How should these mechanisms be enforced in the constitutional order? And when the constitutional order warrants entrenching anti-corruption mechanisms. So the first question, why constitutionalize anti-corruption mechanisms at all? I want to take the first two reasons there together. Corruption is an impediment to good governance, and it is frequently associated with autocratic regimes. The most recent international anti-corruption convention, the United Nations Convention Against Corruption, provides an important but non-exhaustive list of core corrupt acts: bribery, embezzlement, trading in influence, abuse of function, illicit enrichment, concealment of another's corrupt conduct, and obstruction of justice relating to public corruption. So public corruption is generally recognized as an impediment to good governance and is frequently associated with anti-democratic autocratic systems. And so experts view anti-corruption measures as necessary for good governance. And good governance practices include things like recognizing fundamental rights, observing the rule of law, strengthening the institutions, and promoting political participation, and encouraging participation in civil society and democracy more broadly understood. So at a time when democracy is declining worldwide, government watchdogs and advocates of good governance also warn about what they call the grim picture of intransigent public corruption globally. And these two trends tend to reinforce one another. So just to take one example, if you have corruption of the judiciary or corruption within the judicial branch, this corruption jeopardizes both the right to non-discrimination and the rule of law, right? So you're looking at things like the right to a fair trial and to equal treatment under the law. And this is true not only for any individual cases that may appear before a court, but it also involves things like bribes of judicial officers or of court staff, and it includes broader institutional and legal frameworks. And so Susan Rose Ackerman has observed that a corrupt or politically dependent judiciary can facilitate high-level corruption, undermine legal reforms, and override legal norms. And so when the judiciary is part of the corrupt system, the wealthy and the corrupt operate with impunity, and they're confident that a well-placed bribe can deal with any legal problems that they may have. On a more granular level, corruption impedes delivery of public services, such as healthcare and education. It facilitates human trafficking, and it enables violence against women. And the failure of a democratic government to provide public services fairly and efficiently, or to protect its citizens from crimes and violence, loses the confidence of the polity in the government's competence and in democracy more generally. The third sort of bullet point here, corruption has an inverse correlation with protection of fundamental rights, has been recognized both by the United Nations Convention Against Corruption, which asserts that corruption is adversely related to the realization of human rights, and by Transparency International, an international corruption watchdog group, also noting that correlation between systemic corruption exists with an institutionalized failure to respect human rights. The fourth bullet point is one that I think is particularly important, and that is that neither core political rights nor any other legally protected rights can be effectively enforced unless there are barriers in place to ensure against their erosion by systemic and institutional corruption. So if institutional corruption is sufficiently widespread, it disrupts the dialogic norms of deliberative democracy, and it subverts the interests of the people to the interests of the corrupted public officials and the special interests they serve. So as a result, public officials may over time start to chip away at or simply ignore both legislated and constitutional rights, including basic human and political rights. So unless the constitutional order provides an enforceable remedy for arresting the underlying government corruption, the governed may have no lawful recourse for redress. And as recent American circumstances suggest, anti-corruption measures that are merely structurally implied may fail to erect sufficiently robust barriers against public graft and corruption. And this is so because an anti-corruption protection, which is merely structurally implied, may lack enforcement mechanisms and identified remedies. Explicit provisions that do not include an enforcement mechanism are equally toothless. And so there are additional difficulties that may relate to standing or issues concerning the scope of application to political office officials or to species of corruption. In the same vein, legislation or codes of conduct that are unmoored from an explicit constitutionally entrenched anti-corruption provision are more likely to be susceptible to manipulation. They're more likely to be susceptible to being ignored. They're more likely susceptible to outright repeal. So for example, we've seen time and time again, democracies that have devolved into autocratic regimes often have political power players in office, and those who are corrupted, who are in power, can and do interpret and reinterpret existing laws to protect their own conduct. They use lawful means to change the laws to make their corrupt conduct fall outside the scope of the proscribed behavior. They openly flout existing prohibitions and systems that allow the flouting to go unchecked. Or they delegitimize institutions that would otherwise hold the offending public officials accountable for their wrongdoing. So what types of anti-corruption provisions should be entrenched? I pulled this list in part from a review of constitutions that have employed various anti-corruption provisions, and in part from some of Transparency International's work. The anti-corruption provisions that I have encountered include both implicit mechanisms, which include textual, that went fast. Textual provisions that indirectly advance anti-corruption goals and values, structural features as well, things like separation of powers, and strong rule of law features embedded within the structure of the Constitution itself. And then there are explicit mechanisms, which include conduct-specific textual provisions that articulate anti-corruption values and principles, and provisions that may create an anti-corruption body. Just to give you an example of I've lost my track here. Sorry, give me 1 second. Just to give you an example of the principles and values category that you may encounter, that there are textual provisions that are included in the Constitution itself, but they only indirectly implicate corruption. If you look at the Constitution of Qatar, not exactly a bastion of anti-corruption, but let's cheer on the U.S. men's team in the World Cup regardless. The Constitution of Qatar provides that public offices are a national service, and the public employee's goal in performing the duties of his post is the public interest alone, right? So public officials are supposed to perform their duties in a way that does not personally enrich or benefit them. Angola, also not a bastion of anti-corruption, is another example. Under the terms of the Constitution and the law, the public administration shall pursue the public interest. Since I am out of time, I guess I'll just kind of quickly make a note that Finland, the Nordic countries, Finland, Sweden, Denmark, and Norway, and Iceland too, routinely obtain top scores for their strong rule of law features, for their anti-corruption cultures, but they very rarely incorporate express constitutional provisions that protect against corruption. And so right now, where I am in my thinking is that express anti-corruption provisions might serve as an additional arrow in the quiver for those constitutions that have less robust rule of law features, or less robust separation of powers, less robust political participation. But I don't think that my initial thesis, my initial idea that anti-corruption provisions necessarily need to be included and necessarily need to have operationalized mechanisms for enforcement in order to obtain very healthy democratic societies with a strong rule of law. So, as I say, it's a little bit of a mess right now because my thinking is a little bit of a mess right now, but I do welcome your comments. I'm going to skip ahead several slides so that if you do have comments, suggestions, or questions, you can reach me at my email above, or I'm happy to take questions at the end. So thank you very much.
Hello, everyone. I have to say it's a big pleasure to be with you today. I am Ilaria Di Joy, and I'm speaking from Birmingham in the UK, despite my accent. I am originally from Italy. I don't have the opportunity to be with you today, so just a few words about the Center for American Legal Studies here at Birmingham City University. You may wonder why an Italian is presenting online in the US and working in the UK. Well, the Center for American Legal Studies is the only center for the study of American law in the UK. So I'm very happy to be here today and represent the center as well. I have prepared a presentation and I am going to share my screen in a moment. Yes. I think you should all be able to see it now. Okay, so I am going to talk.
If you want to go
Can you
full
all
screen
see?
with the slides. Looks good.
Is this okay? Yeah, excellent. Thank you. I am mostly interested in federalism, intergovernmental relations, and I have published mainly about the relationship between central government, federal government, and the states. But recently have become interested in intrastate relations, and I've been looking at local government and the relationship between local government and the states more in general. And I've started really, again, this is a work in progress for me. I started thinking about the recent pushing of cities, municipalities, local government more in general for more power. They claim more power from the states. And the states have responded unfortunately or fortunately, this is what we will be discussing today, preempting those local government pushes for more power. In particular, I've been looking at the phenomenon of intrastate preemption in many areas that you see listed in the slide in front of you. So we have seen many cities issuing regulations of firearms, and on the other hand, states preempting those regulations of firearms. The same goes for rent control, broadband, paid leave, plastic bags. So we see municipalities wanting to adopt ordinances to regulate plastic bags, but on the other hand, states, particularly in the South, stopping this from happening. The same goes for minimum wage with 25 states. And then more recently with the pandemic, we have seen cities pushing for having powers to impose mask mandates or lockdowns, and states stopping them from doing so. So a step back now, when I started reflecting on this, increasing preemption of local power, then I started thinking, okay, but what does this have to do with constitutional law? How do the states' constitution regulate? Is there anything in the state's constitution that regulates this relationship between states and cities? Obviously, the answer is yes. But as you well know, when you do research in the US, you have then to look at 50 different jurisdictions, 50 different ways in which those relationships are regulated. So some states will have a home rule, some other will have other types of regulation of those relationships. What is impressive, though, and this was my first slide here, and what is perhaps interesting to today's audience, is that the US Constitution actually is silent on the power of local authorities. There is nothing in the US Constitution that gives hints as to whether cities, local governments have any power. And you may think that this is obvious, and this is because, of course, as in the case on the slide, cities, municipalities are creatures of the states, and that therefore the regulation of municipalities' power is left to the states. But in a comparative perspective, this is not really obvious. There are some other constitutions, mainly, for example, the Brazilian constitution, that in fact in the constitution itself mentions what the powers of municipalities should be, and in fact the federal Brazilian government has a direct connection with the cities. So the cities are actually not creature of the states, but can have a direct relationship with the federal government. This is true in particular for the big metropolis. So of course, we're not talking about small cities, but for big metropolis that can have, and in fact have, a constitutional relevance. So this was a bit of the background of my interest on local authority, on local government, and in particular, this interest has been triggered by the criticism of the literature on preemption. So I listed there three of the most relevant criticism of scholars around preemption, intrastate preemption efforts. And you see there the first publication actually from Professor Schrager talks about a real attack on American cities. Professor Scharf of Arizona State University talks about an increase in preemption, and she calls it an hyper preemption that has been happening lately. And Professor Briffault that talks about the challenge of new preemption. What have been the causes of preemption? Well, I think we can all agree, and the literature agree, that the main cause of preemption has been the recent political polarization in the US. So generally speaking, you either see red cities in blue states or blue cities in red states that have different opinions on different subjects and therefore push back on a particular specific policy of the state. Now, based on this criticism of preemption and based on the criticism of the fact that preemption is increasing, I started then wondering whether there are alternatives to preemption and whether there are examples of areas in which preemption does not exist or exist to a very less extent, and whether we could learn something from those examples, whether they are possible alternatives, not that we have to use the same identical model, but whether they could teach us something regarding a state and local government relationship. And as you can see in the slide, the obvious examples here, and you may be familiar with this because in your everyday life you may have come across local regulations of alcohol and marijuana in some states. Of course, this is not a general statement. So what we have seen is that in those states that have legalized alcohol after the prohibition era and marijuana more recently, those states have not imposed on cities, have not preempted cities, local government from banning the retail, the sale of alcohol and marijuana respectively, but have actually left local government free to opt out of those policies. Why is this? I started wondering. What is different about alcohol and marijuana? What makes alcohol and marijuana different than guns, for example? So why do states preempt regulation of guns, but not the regulation of marijuana and alcohol at local government level? And therefore, I started researching a bit the opt-out options. And I found that around 18 million of American live in places where the selling of alcohol is illegal, and that as of today, actually the data are not always as updated, but this is the most recent data that I could find. There are 121 communities that still ban the sale of alcohol. And you can see here a map of those communities, in red, the so-called dry counties, and in yellow, mixed, so-called also damp counties, and in blue instead, wet counties that allow the retail of alcohol without any limits. I then started wondering, okay, but I want to look at those opt-out provisions. I want to see how do they play out really in a statute, what authority in a state constitution grants those local opt-out options. And I started looking at the New York Constitution, in particular at Article 9 of the New York Constitution, that seems to grant to local government the power to adopt and amend laws. You can see there in yellow highlighted, to adopt laws and amend laws that are not inconsistent with the provision of the Constitution. So the local government can go as far as it does not encroach on provisions of the New York Constitution, but also, and more importantly, the alcoholic beverage control law statute that gives actually a right to cities and towns to have an election, a ballot, and decide whether or not they want to ban the sale of alcoholic beverages. So actually, we can see that New York, in this case, and I'm hoping to look at other state constitutions, have used statutes really there to grant this power to local government. More recently, as I said, we have seen this phenomenon extending to marijuana. So we believe that the states have been looking at alcohol opt-out options to develop marijuana opt-out options. And as of after the election, so this is a really recent data, we have 19 states and DC that have legalized recreational marijuana, and they've also given to local government, except for one state, New Mexico, the possibility to resolve political conflicts by having opt-out options. In particular, again, I've been looking at New York for consistency, and New York gave a time frame, a deadline actually, it was the 31st of December 2021, to local governments for opting out of the selling of the retail of marijuana within their jurisdictions. What did I find, and where is my paper going? And I would really appreciate here your comments here. So many state preemption laws are necessary. There is no doubt about this. They help consistency, uniformity throughout the states. However, it is also true that some preemption laws have really eroded the powers of local government. So where is the balance? What is the correct balance between local government and states' power? Would a broader use of home rule represent the solution to this? Or could actually opt-out options be used more widely in other fields where the states today preempt local government action? Of course, I will much welcome your thoughts about this to see whether this is a realistic thought, whether you think that opt-out options could apply, for example, to other areas, such as I said, minimum wage, paid leave, plastic bags, gun control, or whether this is not something that could apply because alcohol and marijuana are very peculiar, very specific, and there are other reasons perhaps why the states prefer to give local opt-out options. Thank you very much for your attention. I look forward to the Q&A, and of course, my email address there is on screen. I would really appreciate comments, questions. Thank you for your attention.
All right, well, thank you to our three presenters. I know I learned a lot and I have a couple questions, but I would like to pass it on to our faculty advisor, Dr. Reed. I know you certainly have questions.
I absolutely do. They're wonderful presentations.
Yes, so I'll let you.
The wonderful presentations always stimulate questions.
Yes, so I'll let you start it off, and then we can pass it on to some student questions.
Well, thank you, Austin. Thank you again to the panels. So I will pose a question to each of our speakers and to initiate conversation. And I'll begin with Noah. And I'll ask you, you identify three factors of legitimacy: sociological, moral, and legal. And I'm going to suggest for debating purposes, that perhaps of those three, the most significant is sociological, and that it is especially significant today, because as you point out, we have a Supreme Court that is out of step politically with where the great mass of public opinion resides. And so that you have a steady need to identify points of legitimacy, points of specifically sociological legitimacy, because what the court wants to avoid is a repetition of the New Deal situation, in which Franklin Roosevelt finally decided that the Supreme Court was so entrenched and so out of touch that it should call for a wholesale number of new justices. We've seen some calls for that now. So if you could comment on my hierarchy of factors of legitimacy. Professor Breeden, thank you for your presentation. And I'm going to ask you a question about what is corruption? Is it the crude bribe? I mean, we all know what corruption looks like at a gross level. It is bribery, it is extortion, it is crudeness and force personified. But is the multi-million-dollar gift to a political action committee also a form of corruption? Do we see in large donations the potential for influence peddling? Does it matter that most legislation today is drafted not by Senate committees, congressional committees, but rather by lobbying firms in the employ of special interest groups? Is this really a form of corruption where we have a political order taken over by honeycombed with large interest groups pressing their points? There are words for this. Influence peddling is one such word. Oligarchy is another. Is American democracy really no longer a democracy? Is it an oligarchy? Those are my questions to you. And finally, Professor DeGioia, my question for you is when I look at the urban-state relationship, what I often see is conflicts in values. And the pandemic really brought out these conflicts in values with COVID mandates in particular. But then you also identify a host of other concerns: paid leave, minimum wage. What we're seeing, in other words, is a divergence of an urban reality that is often politically liberal, if you will, politically at variance with larger state concerns, and is playing out in the form of efforts to expand local control to the extent possible. And this leads to all sorts of tensions. I recall I lived in Atlanta for many years, and in Atlanta, people half joked, were half serious. Should Atlanta secede from Georgia? And I'm here with Professor Paulson, who has written on the secession of West Virginia from Virginia. And so I will playfully, in the spirit of playfulness, suggest perhaps some urban centers. I can think of a few in Sunbelt states. Houston comes to mind, Atlanta comes to mind, that perhaps should secede from their states and apply for separate admission to the Union. I suggest this playfully, but again, I'm in the presence of someone who has written compellingly on West Virginia. So anyways, my questions to each of you. Thank you.
Thanks, Professor Reed. Maybe I'll go first here. So I think, broadly speaking, you're right about kind of the hierarchy of legitimacy as you laid it out. But I think part of the question here is kind of, does that hierarchy apply kind of to everyone equally? And so I think, in my view, right, from the general public perspective, from the perspective of a practicing lawyer, Yes, what matters most is kind of the sociological legitimacy of the court system. As you say, that can have kind of dramatic effects. There have been calls for court packing and for term limits for justices and other solutions. Right? President Biden had a commission on the Supreme Court looking at potential court reforms. I think the problem for judges in general here is twofold. First of all, a lot of the questions of sociological legitimacy, of political legitimacy, are to some degree outside of their control. Right, they're somewhat limited in what they can do. A lot of that's going to depend on how the public reacts to them, how politicians react to them, sometimes in a manner that might be motivated, right? How the press reacts to them, things of that nature. I think the other issue is that, in my view, they are somewhat constrained by Article 3 and by the constitutional structure. And which, as I've said, kind of limits and insulates them from political considerations. And so I think for the general public, you're absolutely right. Sociological legitimacy is what's most important. I think from the perspective of federal judges, legal legitimacy remains kind of the most important of the three. Mm-hmm.
Thank you, Professor Reed, for your question. What is corruption? The amount of ink spilled on that question is quite large. I have adopted a fairly limited definition of corruption for purposes of my investigation at this point, and that is simply the abuse of public office for private gain. And I'm treating that particular question in the context of three categories of corruption: petty corruption, grand corruption, and strategic corruption. Grand corruption, I think, addresses the kinds of issues that you're talking about, where there are institutional structures that have been, the purposes of those structures have been corrupted either by money or by pursuit of power or influence peddling, as you say. Interestingly, New Zealand has a very detailed constitutional set of requirements for campaign finance regulation. I think that our own system has failed us in that regard. I think that may be another paper for another day. But one of the other interesting things about the Finnish constitution, I mentioned Finland earlier, is they have fairly detailed conflict of interest provisions within the Constitution itself. And I think that those types of provisions might warrant additional attention to address the kinds of things you're talking about: large donations by corporate entities that are seeking to advance their own particular interests, perhaps at the expense of the public at large. I hadn't thought about the drafting of legislation by lobbying groups or by groups like ALEC, both at the federal level and at the state level. And so that's something I'll have to give a little bit more thought to. But your overarching question, has the U.S. become an oligarchy? I think if we have not already, we are dangerously on the precipice of having public officials, having elected public officials, both at the federal level and at the state level, more concerned about advancing the interests of their donors and of the special interest class over the interest of the public at large. And all you have to do is look at places like Ohio, where a broad majority of individuals, for example, favor some degree of limitations on gun ownership. And yet the Ohio legislature continues to lessen restrictions on gun ownership. The public doesn't want that. But we are so heavily gerrymandered and there is so much voter suppression, again, institutional structures that I think are the result in part of campaign finance and other influence peddling, as you call it, have yielded anti-democratic policy results. So I don't know if that answers your question or not, but you've given me a lot to think about.
Thank you.
Thank you for your comments, Professor Reed. And I'm not sure I understood the question, but I think your comments was really about the politics of this tension, the fact that we're talking about, yes, legal means by which we try to resolve what is essentially a political tension between state and local government. I have to say that I wondered myself what was the role of the courts in assessing this balance, in resolving this balance between states and local government. And I have been looking in another paper at the courts' cases, at the, unfortunately, non-decision, because the courts never actually reached a decision during the pandemic. And in particular, in Atlanta, in Georgia, there had been a lawsuit from the state governor against the mayor of the city of Atlanta that wanted to impose mask mandates. And the governor sued her, saying, okay, no, you cannot really do this. There was an actual case, and I, tried to investigate, to look at the case in itself, but then the case didn't go anywhere because the governor then decided to leave the mayor of Atlanta free to impose mask mandates only in public places. So in a way, and this is not only in Georgia, also in Florida, it was exactly the same. In Texas, there have been court challenges around mask mandates or conflicts between cities and states, but the cases didn't go anywhere because either they have been withdrawn before the decision was made, or there had been actually a political resolution to those cases before the actual legal solution. So it is actually the local government versus states issue is a legal issue that is not well yet been developed by the state courts. It is something that perhaps is left for the future to look at how this equilibrium will be resolved by the courts. And as I said, I look at this in another paper with reference to the COVID mandates. But what came out, my finding was that actually the courts didn't reach any relevant decision. And this is again in sharp contrast with what happened in Europe and in South America, in particular in Brazil, where the courts instead ruled around the relationship between local governments and the states regarding COVID mandates. So it seems that the US is again exceptional in this circumstance. Thank you.
All right, wonderful.
Professor Levinson has a comment.
Yes.
Yeah.
Yes. Wonderful. Thank you all for those answers. Thank you, Dr. Reed, for questions. I do want to open up to the in-person audience first and see if there's any questions. If not, we do have some online questions that we can get to. Yeah, Chase. Oh, hold on. Sorry, Chase. Olivia, if you want to pass the mic to Chase. Yeah. And then Chase, press the power button. Oh, it's on. Okay, go ahead.
All right. Two questions, one for Noah Chauvin and then one for Professor Breeden. With regards to the legitimacy of the court and how Kavanaugh tries to explain it in his concurring opinions of how the system should work, it seems that there might be two very specific things that may need to be addressed. One being stare decisis, especially with the Dobbs decision, right? That it seems to be kind of arbitrary and standard, and providing a lot more clarity to that when past justices, such as Alito in the confirmation hearings, have confirmed the notion that when something is upheld over time, it strengthens its legitimacy, right? And also, second, the Ninth Amendment, right? There's really not a whole lot of clarity around that. There's a whole lot of litigation, but not a whole lot of answers when the Founding Fathers wrote that amendment. So when will that come to a head where Justice Kavanaugh has to explain that, and how can they provide clarity? And then for Professor Breeden, kind of going into that same question from stare decisis, with regards to a lot of corruption, it seems with the past case of Citizens United, a lot more potential for corruption in the United States government has kind of, I'm not going to say directly happened, but maybe indirectly happened because of that case. What potential issues do you see that the court can resolve from that coming up the pipeline, or that the court can take to provide clarity on Citizens United?
So I can start. I think you're absolutely right, and kind of two things that do need to be addressed. On the stare decisis question, it's something that Justice Kavanaugh talks about a bit in some of his opinions. In many of them, it's something that he's not addressing extensively or at length, particularly where he's kind of concurring. And I think that's in part because he is joining, majority opinions in full that do that already. In kind of the opinion that they're writing. He has occasionally addressed it in kind of his own majority opinions, occasionally in concurrences, and sometimes in dissent. But I think you're right. It's something that would merit further attention from him. I think particularly given some of his testimony during his confirmation hearings. Right? As for the Ninth Amendment, I agree. I think that's something. It's surprising to me that it doesn't come up more often, right? I think it's an issue that the court is not kind of often presented with. It's usually not in the question presented. I think you're right. I think there are compelling Ninth Amendment arguments to be made in a lot of these cases. And I think the justices don't fully engage with those arguments because they're often not presented to them.
Oh, and I'll be very brief, Chase, and I'll just simply reference a classical source, Sallust, the Roman historian Sallust. The Jugurthan War writes, Romae vendita omnia sunt. At Rome, all things are for sale. And I think that fairly accurately characterizes Washington, D.C. right now, and the role of special interest groups.
You get that quote from you. So Chase, thank you for that question. So I guess first thing I want to clarify is that I'm not writing a campaign finance paper at this point. But I do think that you've raised some important questions. And I guess the first thing I would point out is that from my perspective, at any rate, Citizens United itself is not the genesis of the problem. The problem has its genesis, again, in my view, in the Buckley v. Vallejo case, which was 1986, I think, which recognized that money is speech. And I think that because a majority of the court has rejected the anti-distortion rationale for limiting campaign expenditures, I don't think we're going to see any revisitation of that anytime soon, not with the current composition of this court. You periodically hear legislators talk about overruling Citizens United. I personally don't see how that can happen without a constitutional amendment, but I am not steeped in the literature, and so I would defer to those who are. So yeah, again, I don't think there are going to be cases that provide clarity on Citizens United in a way that limits corruption. I think if anything, it will, any cases that are on the pipeline, are in the pipeline now, and recent cases that have been decided are going to make it not only easier to make campaign contributions, but also to hide the sources of those campaign contributions. I'm reading the tea leaves. I can't, again, I'm not a campaign finance scholar, so I would defer to those who are. But I think that I think the court erred in refusing to recognize the anti-distortion rationale as a basis for limiting the kind of money that we're seeing in our campaign finance. So thank you for that question.
with Taylor first, and then we'll go to the online speakers.
Okay. Is it on? Okay. Professor Breeden, I know a big issue when we talk about regulating corruption internationally is at what point do we hinder our own ability for our companies to effectively compete in systems where corruption is the norm, or that's really how you only get things, that's how you get things done there. So what is your perspective on having express regulations or implied regulations, or which would be more beneficial or effective for allowing competition, or is that something we don't even want to look at?
Okay, so thank you for your question. No, it's a really it's a good question. It's an important problem, and I think that one of the issues that we run up against is, in fact, that there are cultures of corruption, right? There are certain cultures that just view a little bit of bribery, a little bit of passing of hands as just part of the way you get things done. And there is an argument to be made that my own view is an imperialistic sort of, my way or the highway view, but I actually, I make no apologies for trying to root out public corruption, because I think ultimately public corruption harms the local public. And so I think what we would have to look at is a balancing. And I think even if we are concerned about protecting competitive advantage, I think that ultimately harms the local community if we allow corrupt practices to continue. So I don't have a particular framework in mind for how domestic law should apply to the regulation of businesses abroad. We have the Foreign Corrupt Practices Act. I'm actually taking a more discrete, internalized view of what constitutions should do to protect their own citizens. And I think you raise an important question about how that should accommodate or not business practices. I have tended to avoid that particular issue simply because it's an entire thing, right? So thank you for that.
Wonderful. Thank you. We'll go to Kevin. Yeah, go ahead.
Not to disagree with my esteemed colleague, Mr. Chase Thomas, to a varying degree. However, I look at the inverse example of stare decisis. So if we were to rewind the clock past the seminal decision in 1973, where if we were solely to rely on our Article 3 judges to focus or have a hyper focus on legal legitimacy, wouldn't that have adverse outcomes to certain populations and to certain peoples? So Chief Justice Roberts' decision to incorporate social or political legitimacy could be viewed as a corrective mechanism, because where stare decisis should be a guidepost, it is often interpreted or talked about as a chain. And stare decisis, if that case was wrongly decided in 1907, and just because it goes unchallenged for 100 years, doesn't mean that it's automatically right, or should have, or should be continued. So that's my question for you, Mr. Chauvin. Professor Breeden, one of the things that you brought up in your example is the Nordic countries of Finland, Denmark, Iceland, Norway, and Sweden. One of my chief concerns with that is the homogeneous nature of the population there. And if we consider that, as well as the limited number of population there, if those are the two main limiting factors, how can those principles be effectively applied in other situations, specifically in the United States, where our demographic makeup is vastly different and our population is way more, even taking on a collective total. And then for Dr. Joya, thank you. In your comments, as far as the tension of preemption between cities and states, some of those issues where the state has preempted the city's actions, is that, in your view or a part of your research, a balancing act as far as the average citizen is engaging across state lines, or is your research purely from how states are interacting with other states?
I'll begin. I think that's an excellent question. I think you raise an important point about stare decisis. I think, in my view, and it's part of the reason why I think judges should be concerned primarily with legal legitimacy in kind of reaching their decisions, is that it's one of the benefits of having a branch of our federal government that is kind of insulated from political pressure, right? They can be, as they've been described, right, that the counter-majoritarian branch. They have the opportunity to kind of do what is right, even where that's kind of not something that the majority would want. So I think you raise good questions about kind of stare decisis. Certainly, the kind of longevity of a case shouldn't be the only thing that they're considering. There is obviously value in kind of consistency and predictability. But I think you're right, and it's one of the reasons why I think legal legitimacy is so important, is because if sociological legitimacy is a major factor in the decisions that courts are making, they're going to be subject to kind of the same majoritarian pressures as every other branch of government.
Hi, thank you for making the observations that you've made, because it gives me an opportunity to mention something that I did not make in my presentation. So I really do appreciate this question in particular. I think that no single anti-corruption regime is going to work for every context. I think every country has to chart its own path, given its societal makeup, given its history, given its existing constitutional order. I point to the Nordic countries partly because they do routinely score high on rule of law issues. So where you have a nation that has very robust rule of law features and very robust protections for the minority population, however that is conceived in a given society, then express constitutional provisions may be less necessary. I do think that there is room for express constitutional anti-corruption protections, as I said at the very end of my presentation, as just sort of one additional tool in the toolbox to fight anti-corruption, or to fight corruption among government officials. But absolutely, every society has to create and craft its own path, and I think that it should be a bottom-up approach. I think that whatever anti-corruption measures are adopted at a local level, a state level, or even the federal level, should come as a demand by the people. So thank you for those questions.
And thanks from me as well. I think your question was on whether my research has focused only on intrastate conflicts, or whether I also looked at a relationship between states. I haven't looked at relationship between states, but I am aware of the fact that states do copy each other when it comes to preemptive legislation, and this is also due in particular to the existence of legislative associations that the group state legislators such as ALEC. So, for example, ALEC has provided the model preemption bills for plastic bags. And perhaps if you look at the different preemption bills, you can see that actually the route is the same. They look very similar. So even though my paper is not focused on states' comparative research, perhaps, yes, I should add that I'm very well aware of the fact that states communicate to each other, and that especially when it comes to the extensive use of preemption, this is due to collaboration, legislative collaboration between state legislators. Thank you.
Wonderful. Thank you all. Thank you, Kevin, for the question. I do want to get to our online questions. Olivia, if you just want to read them one by one, we can have our speakers answer.
So we have a question for Noah. In line with Professor Reed's argument, analyzing legitimacy in personalistic terms seems kind of weird. Is it about the rule of law or the rule of the people? What does it say about the very idea of constitutionalism?
Sure. So I think that's a valid point. I think the reason that it's important to look at these things in kind of individualistic terms, at least when it comes to the Supreme Court, is that we've got kind of 9 justices who are there, right? And they are individuals, right? They each have a vote and their own kind of personal view of the law, of their kind of approach to the job, and how they communicate it has an outsized kind of impact on questions like the rule of law. And so I think it's important to understand them from kind of the personal perspective, because they are the ones who are actually making it happen.
We have a question for Professor Breeden. Don't corruption constitutional provisions have simply a constitutional value in the same way that authoritarian countries are called democratic to overcome the deficit? Countries with huge corruption problems make it a constitutional issue primarily for symbolic purposes.
I'm sorry, could you please repeat the question?
Yes. So it says, don't corruption constitutional provisions have simply a constitutional value in the same way that authoritarian countries are called democratic to overcome the deficit? Countries with huge corruption problems make it a constitutional issue primarily for symbolic purposes.
Yes, I think that's true. And I think that's one of the reasons why I have moved away from my original idea that having an express constitutional provision protecting against corruption would in fact operate to protect against corruption standing on its own. I think that a lot of times corruption measures are adopted into newly revised constitutions in response to rampant corruption. And sometimes those are legitimate efforts to protect the population from corrupt government officials, but sometimes they are, as the questioner asks, sometimes they are simply window dressing. Hey, we have an anti-corruption measure. Look at us, we're really great. And that's one of the reasons why I wanted to tie my discussion in part to rule of law features and other sorts of robust democratic structures. So I hope that answers the question or the comment.
We have a question for Ilaria as well. The key question seems to be about the proper loci of political powers, cities, states, or nation states, and if closeness to the individual should have priority. Is this A, the right question, and B, some people think about the constitutional pluralism, different levels of national, subnational, and transnational levels. Which is the one that clarifies the issues? Constitutions do not have one place, but many places.
Yes, I think that this is right. This is the essence, really, of the studies on local government. And for those that do study local government, the question is always what is the proper allocation of power and what powers should local government have. I have to say, and perhaps this is also interesting. For those of you on the other side of the pond, as we say here, that this is a very important question, a very hot issue here in the UK at the moment. The central government is progressively giving more power to local governments here in the UK with so-called devolution deals. And in doing so, it is inspired by the American model. In particular, in the UK, we don't have elected mayors, but we start to have regional elected mayors. Again, we are being inspired by the American model. So yes, absolutely, constitutional pluralism, proper allocation of powers, those are issues that resonates not only in the US, but also in Europe and in the UK more generally. Thanks.
We have one final online question. I believe it's open for anyone, but it says, is there any good reason to accept the Supreme Court's highly limited notion of corruption that seems to focus almost exclusively on quid pro quo bribery?
All right, we will leave it at that. And in the interest of time, we will end this first panel of the day. I want to give another round of applause to our panelists and thank them for coming. Because we did go a little over time, we will start the next panel at 9:50. So you'll have about a 10-minute break and recycle through. So thank you again, everybody. Welcome back, everyone. We're going to get started in the interest of time. So people will be trickling in as we start our second panel of the day on constitutional history. And with us, we have Carrie Netterman, Ken Pennington, Michael Cohen, and Aaron Walliot. So to start out, we have Carrie Netterman. Carrie Netterman is a professor of political science at Texas A&M University. He previously taught at York University, the University of Alberta in Canada, University of Canterbury in New Zealand, Siena College, and the University of Arizona. His research concentrates on the history of Western political theory with a specialization in classical Greco-Roman and early European ideas up to the 17th century. He is also published in the field of comparative political thought. Netterman is the author or editor/co-editor of over 25 volumes and has published over 100 scholarly journal articles and academic book chapters. His next monograph entitled The Rope and the Chains continues his interest in Machiavelli's thought. And next we have Ken Pennington. My apologies, my introductions have gotten all mixed together here. Let's see. Yes. Where is Ken? Ken. My apologies. I have misplaced that paper. Yes, please go ahead. If you want to move the microphone closer to yourself.
Hello, I'm Ken Pennington. I am emeritus. I retired from Catholic University of America in Washington, D.C. 5 years ago. I miss walking into the classroom. I hate to say that, but I do. Actually, I'm glad that I missed the pandemic. I'm not sure I would have enjoyed teaching via Zoom. In any case, my interest is constitutional thought, political theory, the history of Roman law, of canon law, of civil law in general. I'm not so fond of common law, I hate to say. Haven't written much about it and not much interested in it. But I think that's it.
Wonderful. Well, I appreciate it. Thank you for catching up from my failure. And next we have Michael Cohen. Michael Cohen is a research professor in the Department of Government and a faculty fellow in the Center for Congressional and Presidential Studies at American University. He serves as an editor of the correspondence of Zachary Taylor and Millard Fillmore. After earning his PhD in history at Harvard University, Michael worked on papers of Elizabeth Cady Stanton and Susan B. Anthony at Rutgers University and spent 10 years editing the correspondence of James K. Polk at the University of Tennessee. In addition to 3 volumes of Polk correspondence, he has published Reconstructing the Campus Higher Education of the American Civil War and several journal articles on the history of U.S. politics, education, and the editing of historical documents. Most recently, he edited James K. Polk and his time essays at the conclusion of the Polk Project, released in September 2022. And lastly, we have Aaron Wallilat. Aaron is an associate attorney at Tucker Arnsberg, PC. Previously, he was a judicial law clerk for the Honorable William S. Stickman in the United States District Court for the Western District of Pennsylvania. He's a graduate of Emory University, the School of Law, and was the assistant managing editor for the special content for the Journal of Law and Religion. He received his undergraduate degree from Washington and Jefferson College. He's active in legal scholarship, and his work has been published in such publications as the Pace Law Review, the Charleston Law Review, and the Australian International Law Journal. He is currently an adjunct professor of law at the University of Pittsburgh School of Law and a member of the adjunct faculty at Washington and Jefferson College. And with that, those are our 4 panelists for the second panel on constitutional history. And we will start with Carrie Netterman.
Thanks very much, Austin. Can you hear me without the microphone? Oh, okay, that's fine, because my voice tends to carry. And okay. Well, first of all, I want to thank Austin. I want to thank Chuck and the organizing committee for putting this all together. I was very excited to be invited to be involved. And in fact, Ken and I have been talking about the diversity of the panelists, and that it's nice to do this kind of interdisciplinary work. And I've already learned a lot, and I am sure I will learn more. I think it's kind of ironic that I'm giving this paper with Ken here, because the original concern, the original idea for it came out of a seminar in San Miniato in Italy that Ken and I both attended, and we had a conversation, I remember, of some intensity about this topic. You don't remember, but I do. So anyway, it's nice to be able to present this research not only here at St. Thomas, but also in maybe you remember in front of you, Ken. Okay, let's get going. The Roman law maxim, quod omnes tangit ad omnibus approbatur, which is, and I'll do it here, standardly abbreviated as QOT, or numerous versions thereof, was commonplace in medieval political and legal writings, as well as in all manner of institutional and official documents. Normally translated into English as "what touches all must be approved by all," the phrase has achieved considerable scholarly notoriety, and the bibliography on the topic continues to burgeon in recent decades. There exists, however, a quite gaping divide in academic literature concerning the expression's actual meaning, or whether the dictum even has any substantive connotation. For many, and indeed probably for most scholars, QOT expresses a nascent justification of democracy or popular sovereignty, or at any rate, a principle underlying some system of representative constitutional government that served to limit the power of rulers. By the way, one of the people who subscribes to this view is that eminent medievalist John Rawls in Theory of Justice. For those of you who know political philosophy, he uses it. I think it's in the first edition. I think it's page 277. If anybody wants to look it up. Now, I could, and I will in the full paper, cite a litany of those who endorse this position. At the moment, however, permit me to quote just one, a certain Ken Pennington, who remarked that, quote, during the Middle Ages, QOT supported a theory of consent that was a basic element of corporate theory and representative government. I don't know if you remember writing that, but you did indeed. By contrast, others, and references to these also are going to have to await the full paper, regard QOT as a sort of rhetorical flourish, a cipher, manipulated to suit a vast array of legal and political agendas, both practical and theoretical. Now, in a short seminar talk like this, let alone even in a journal article, it's hardly going to be possible to provide an adequate overview of the extent and manner of the employment of QOT. It shows up a lot all over the place. Its initial medieval occurrence in a public law context, the origins of the phrase are in fact Roman private law, has been traced to 12th century canonists. But even in this regard, there's considerable controversy in recent times about precisely where and who within the canonistic tradition, in fact, initiated the use of QOT. Now, I imagine that everyone who's made serious study of QOT, regardless of the positions that I've just sketched, would admit that its application was not strictly uniform. Now, I propose in the next few minutes, and I will get through this as far as I can with respect to time and with respect to my fellow panelists. What I want to do in the next few minutes is to offer a very rough historiographical observation, or really kind of a quizzical musing that might help us to consider how to construct a coherent arrangement out of the many QOT references encountered throughout the course of centuries. And indeed, it's still being used in the 17th and 18th century, as my colleague Bruce Brasington has documented. Specifically, I posed 5 related questions about the words touch and all, and how they're utilized. Questions are this: 1, what does it mean to be touched? 2, who is the all that is touched, or who is touched? 3, how can all these touched in fact approve? 4, can all or even some of those touched disapprove? And 5, what consequences occur if all or some of those touched disapprove? In proper response to each of these questions, and I say this non-facetiously, the answer is, it depends. At the moment, I wish to offer a couple of instances of how the analytic questions I raise may help us to parse divergent ways in which QOT was put to use. My overarching intention here is to highlight the implausibility of identifying any core doctrine, whether of constitutionalism or of consent or of popular rule, that adequately characterizes the dissemination of QOT across the board. All right, how much time have I blown here? About 5 minutes or so?
You got 8 minutes.
I got 8 minutes. I got 8 minutes to get through 6 more pages. Yeah, good luck. So I'm going to try to, fortunately, since I put this together fairly recently, I'm going to try to do this on the fly in terms of timing. Let me start with William of Occam's Dialogus. The work is composed of a discussion between a master and a pupil. In the first part, it was specifically designed to inquire into matters of heresy, especially a heretical pope. At 1685, Occam poses the question of who may legitimately convoke a council of the church in order to examine and judge a papal incumbent who has allegedly fallen into heresy. His solution to the dilemma is to call a general council that has, he says, that has the authority to at least judge the possibility of a papal heretic. And in making this argument, he introduces the QOT formulation and elaborates on it. He says, quote, all whose business it touches are to be summoned. But the deliberations of a general council touch all, because the deliberations ought to be about the faith and everything that pertains to all Christians, unquote. And then he goes on and uses the QOT formula again in making it clear that everyone who is amongst the faithful can and ought to be involved in the deliberations. And he takes this fairly far. He takes it to saying not just the prelates of the church, not just the clerics, but the laity, and that's something that is unusual, and not just the laity, women as well as men, because they are touched as well by these matters. And in fact, Occam very famously said at one point that in terms of the maintenance of the truth of the faith, it wasn't just a matter of those who have a clerical status. It can be lay people. It can be lay people of a common status. It can be women. And he suggests, and I personally find this implausible, it can be baptized infants. All you need is one person who has access to the truth. Okay, so I'm really going fast here. Occam, in fact, suggests that access to divine insight should not be presumed to be confined to the wise, but instead equally available to all who are better, whether they are learned or unlearned clergy or laity, men or women. All right, let me then go back to that taxonomy I mentioned. Consider how Occam's use of QOT fits into the set of questions that I proposed. One is touched in matters, this is Occam now, or at least my summary of Occam. One is touched in matters concerned with the determination of the true faith. 2, every Christian is touched. 3, approval can only be granted by means of a general council of the church, inclusive of all Christians, regardless of clerical standing or gender. 4, majority or even supermajority agreement lacks power to bind all. And 5, those who do not consent, even if only individuals, may indeed prove to be attuned to divine truth in a way that others are not. I left out a lot of the evidence to support that. It should be evident Occam's appeal to QOT undergirds a vision that diverges dramatically from the terms of constitutionalism or representation as we conceive them today. There's not, in terms of modern constitutionalism, there is really not any substance there. Now, the counterpoint to this is the Catholic Concordance of Nicholas of Cusa. What am I doing on time? Okay, I'm going to do this quickly. Cusa uses just an explicit statement of QOT. He says in the Catholic Concordance, legislation ought to be adopted by all those bound by it or a majority of the representatives because it should benefit the common good, and what touches all should be approved by all, and the definition of the common good only comes with the consent of all of the majority, or the majority. Sounds like straight constitutionalism. But in fact, what he says is that there is what is being consented to is in fact self-enslavement. He's explicit. He says, God made most people in a state of servitude, and those people should simply, and in a corporatist way, should simply accede to the rule of the wise and the laws that the wise impose. And I think the phrase he uses here, he says, servitude can be by choice. It is less worthy if by compulsion, and better if freely chosen. And he goes on about this question of servitude and essentially says that the foolish many are consent, and it's not clear he's talking about representative assemblies or what, but consent to the terms of their own enslavement to the wise. Those in a state of voluntary servitude, or at least some preponderant group of them whose agreement has bound all, surrender any measure of autonomy in their act of assent to legislation, the better to assure their submission, which doesn't sound much like constitutionalism either. Now, I refrain from going into the oddities of Occam's view, but let me use that same set of categories or questions in order to summarize Cous's position. One is touched in matters concerned with the maintenance of temporal order and peace, as opposed to the church. Only those who lack the intelligence and self-control to govern themselves are touched. 3, no mechanism for expressing assent is specified. It may simply be you obey the law. The law is the law, as it were, and that simply being compelled to obey the law is sufficient to be conceiving of assent. He's just not clear about this. 4, the agreement is corporate in nature. That is, consent is deemed to be conferred by membership in a communal body that is a totality without overt expression. And 5, should any of the ignorant, in effect, dispute the duly authorized laws by committing disobedient actions, the wise governors are charged with enforcing statute by meting out penalties. Last little bit, and I'm going to kill the conclusion, unfortunately. Parsed according to the 5 standards I've laid out, the contrast between key elements of Occam's and Cous's versions of the QOT maxim are striking. But in my opinion, neither one amounts to a recognizable constitutionalist theory, at least, again, in the modern sense. The latter because the power assigned to a small clique of wise men does not admit of limitation once its possession has been granted as a concomitant of assent to the law on the part of the ignorant. The former because consent lacks binding status on other believers or even on oneself, inasmuch as approval by a general council does not guarantee the revelation of true doctrine, and since sincere dissenters may continue to uphold the divinely inspired veracity of their beliefs. And I go on then in the conclusion and discuss some of the implications of that. But as you can see, 2 things. 1, QOT can mean a lot of different things, very diverse things. And 2, QOT does not have to imply the sort of constitutional theory or system of representative government that is often attributed to it. And that's it. I'm sorry I went so fast.
Okay. It's your responsibility to stop me and yank me off the floor. Hello there. What I want to talk about today is sovereignty and rights. I've spent a lot of my career talking about sovereignty and writing about sovereignty and rights. On the one hand, how sovereignty and the state have taken our rights away. And on the other hand, how sovereignty has sometimes protected our rights. Now, I think that many of you can think about many of the rights that you have had taken away or not supported. But what I'm going to talk about today is property. You all have property in 1L, right? And I suspect in 1L that you talked about eminent domain, right? Well, in Black's Law Dictionary, which most law schools want you to take, Black's Law Dictionary has 9 inches devoted to eminent domain. Next, please. However, in the best law dictionary that you will ever meet, and if you wanted to know anything about the history of any concept in American law, this is the law dictionary in 2 thick quarto volumes that you should have on your shelf. Whoops, we went too far. Right click. There we go. Anyway, Black's Law Dictionary devoted 9 inches to eminent domain. Bouvier devotes 26 pages to the history of eminent domain only in American law. And the point that Bouvier makes, which are absolutely true, is that it's an attribute of sovereignty. It's an attribute of sovereignty, and therefore, you don't have any property rights at all. Sovereignty, the state, can take away every property right that you have, if they want to, if they have a reason to. Oh, we're already in Roman law? That's all right. The Roman state, which is not the most democratic state in the world and didn't respect rights in particular, but the Romans knew very well how to take away your property rights. Next. In the Christian tradition, the whole issue of property is really interesting because in the Christian tradition, and this is an example, Isidore of Seville was the last great father of the church. And Isidore of Seville's definition of what our natural rights are included a natural right of property. And what he says is what you see before you. None of us own anything because all property should be held in common. If you're a decent Christian, I don't know, are you? In any case, this idea that all property should be held in common, of course, we find it in the structure of the church, don't we? The idea that in the monastic tradition, for example, that all property should be held in common and individual monks should not own any property. The Franciscans, of course, are the best example of that. Next. There's a wonderful story that I love to talk about. That is a 12th century story about the Emperor Frederick I and 2 jurists. Frederick I was at a diet, which is a parliament in German. He was at a diet in Roncaglia in Italy, and he's taking a ride. And who is he taking a ride with? He's taking a ride with 2 law professors. Can you imagine that? I mean, Biden and 2 of your law professors? In any case, the University of Bologna in the 12th century was the first law school in Europe. And these 2 law professors, Martinus and Bulgaris, taught at the law school at Bologna in the first century of the law school's existence. They were so important that the emperor himself, when he came to Italy, summoned them to his parliament, his diet, and wanted their advice. And he said to both of them, as they were riding along on their horses, he said, "Am I the Lord of the world?" And Martinez said, "You certainly are, and you own all property. All property rights belong to you," which is more or less what the modern state argues about our property rights. There's nothing, as I said before, that the modern state can't take away. Bulgaris, however, by the way, I'm really fond of Bulgaris, like him a lot better than I do, Martinus. But Bulgaris said, no, you're not the Lord of the world. And the emperor said, well, I'm going to give my great white horse to Martinus because he gave me the answer that I wanted to hear. Is that corruption? In any case, next. It is a true story. Historians love true stories. Historians love true stories. And this, because it was told, or it was represented by two law professors, it got taught not only in Bologna, but all over Europe for centuries. That story was repeated again and again, and the jurists had to take sides. Accursius, which was one of the most important jurists of the 13th century, he agreed with Bulgaris. As you can see, you're going to have to read the English translations, Bulgaris, and he rejected Martinus completely. Next. Jacobus de Arenia, he introduced a new concept. He nuanced it. Well, you can't take everything away unless there's public utility. I'll bet you've learned that in law school already, haven't you? This is he's not the first, but he's one of the first who interjects this concept into this particular problem. And he also says that you have to give the person compensation. Next. Jacques de Revigny, he says that the emperor can do it, the state can do it from their plenitudo potestatis, which was a term which was applied to the Pope and then applied to the emperor. It was an example of ecclesiastical law being applied to secular law. Next. And Baldus Theobaldus then introduced another term to support state sovereignty, potestas absoluta, absolute power. And of course, with absolute power, and if you think about it, that's what the state has today. With absolute power, you can do, as Baldus says, you can do absolutely everything. Next. And this continued into the early modern period. The famous Albertus Gentilius, who was a famous jurist in England, teacher in England, he says that you don't even need reason to make such a decision. You can do it in secret. It doesn't matter. Next. But not everyone. Diego de Covarrubias, he goes back to the old position in part to Bulgaris, and he says the prince, and what you have to read for prince is state does not have the absolute power to take your right of property away. There has to be reason, there has to be compensation, but also utilitas publica, public utility. Next. And then finally, Hugo Grotius, How many of you know who Hugo Grotius is? No, come on. St. Thomas isn't teaching you about Hugo Grotius? I'm going to have to join the faculty. In any case, Hugo Grotius, who's known as the father of international law, big guy, big name. In any case, he then, out of all of this prior back and forth in jurisprudence and the writing of the jurists, he comes up with the term eminent domain. And that's what we have today. And that's what you have to put up with. Thank you.
Here and now.
Let me just set my timer. All right. So my topic is on the constitutionalism of John Adams. I would like to preface that this is a work in progress, and due to time constraints, it came in two parts. The first part was, what is the constitutionalism of John Adams? And part two is, why might it be important today? I'll save that second part for the paper, so you guys can read it. But at first glance, to think about the constitutionalism of John Adams is strange, mainly because during the Philadelphia Convention, Adams was nowhere near Philadelphia. He was our first ambassador to Britain, the first post-revolution ambassador to Britain. And Jefferson was in France, so they didn't really they were sitting there. At the same time, however, I think Adams, and I'm not the first to say it, but Adams' influence in American constitutionalism, I think, is understated, because immediately after independence, 1776, he received a lot of letters asking for tips on how to form a government. And he wrote so many letters that he eventually published an anonymous general pamphlet called Thoughts on Government in 1776. And this document is believed to have influenced the constitutions of, at least the first constitutions of North Carolina, of New York, of New Jersey, of Massachusetts, of course, and quite remarkably of Virginia. And it focused, of course, on the frame of government, not so much the list on their individual bills of rights. And as Judge Jeffrey Sutton has been, or Chief Judge Jeffrey Sutton has been preaching in his recent tours around the country, nothing in our Constitution was new. Everything was borrowed or stolen from the state constitutions. And Massachusetts and Virginia holding a special place in the national heart. But that said, what was Adams's advice in his little pamphlet? Well, the bogeyman that he was fighting was unicameralism, what he called simple government. He feared it. He feared a single legislature, the type of government that was being preached in Thomas Paine's Common Sense. In response, his pamphlet instead advocated a tricameral legislature, interestingly, a lower house to represent the masses, an upper house to represent the upper house, the elite, and a governor, which could be one person or could be more than one person. Now, this seems strange to imagine the governor as a branch of the legislature, but what he kind of talked about in the pamphlet was that the governor, whether it be one or many, have a negative power on legislation, which means a veto. He's essentially talking about a governor with the executive power also has a veto on legislation. And the form is quite familiar to us today. So besides this influence, of course, he's a principal drafter of Massachusetts Constitution, influenced many different constitutions. What is odd about him is that later in his life, he became seen as almost a reactionary force amongst the founding generation, mainly because while he was stationed in London, he began to write pamphlets responding to certain criticisms of US constitutions, specifically of Massachusetts and Virginia and the bicameral structures. Instead, they advocated what we had in Pennsylvania or in Georgia, two of the three states I've lived in, which had a unicameral legislature. Pennsylvania's 1776 Constitution is considered one of the most radical of its time, having a single popularly elected assembly and no executive. It was a collective. So with French philosophers, not just French, but Turgot, Richard Price, the Abbé de Mably, I don't know if I pronounced that right. He responded with a series of essays which defended the constitutions, plural, of the United States. But it's actually more interesting when you look at the audience, because a few of the states did have unicameral constitutions. So what was he defending? So there was kind of a double talk. He was speaking to a European audience as well as an American audience. And this is important because some of the words he uses, which would later form the basis of criticisms of him as a monarchist, may have been done specifically for the audience he was writing to. But getting to the point, Adams's constitutionalism is based on what he saw as coming from his observations on human nature, the constitution of human nature, and what he believed were the foibles and weaknesses, as well as the strengths of human nature that a structure could kind of make allowance for. And his method was interesting. In the defense, written between 87 to 88, we must admit, no one can deny that it was written poorly. It was written terribly. It was unorganized. And he would just start talking about history and then give his own, then all of a sudden he's talking about philosophy and then his opinions and back to the history. It was poorly written. No organization and poor editorial control on his own part. But it was pretty well received, and some modern historians, the preeminent one being Gordon Wood today, notices that would argue that the people who praised it probably didn't read it. But that said, Gordon Wood's student, the historian Brad Thompson, argues that it was legitimately praised by certain readers, where a defender of Adams went over to Patrick Henry, who was decrying it, and said, "Have you read it?" And Patrick Henry, a tail between his legs, said, "No." So what was Adams afraid about a unicameral legislature? Well, he feared democracy in a general sense because, maybe not general sense, specific sense. He believed human nature, and his method was, in the long form, was examining theories of government, a sample of ancient and modern constitutions, examining the design, comparing them with the thoughts of great thinkers and theorists, and then arguing whether they properly meshed with his observations of human nature. He believed people had reason, but they also had passions, and that passions informed people as much as reason. He didn't discount reason. Reason was important, and it couldn't be denied. But there are certain passions that couldn't be denied either. And in politics, the motivating passion for Adams was what he called the spectrum agenda, translated directly to "let us be seen in action." That people want to do great things and to be seen doing it, and to gain respect from their peers. And this comported with a second belief of human nature, a belief that people are deferential. Even though they want to be seen, they become deferential to great men. And while he hoped that these great men would stratify society based on wisdom and virtue, typically these stratifications happen on the basis of wealth, on the basis of birth, on the basis of beauty, is one big thing that he shared. And so Because of this, he feared a unicameral legislature would succumb too quickly to this kind of stratification. His solution, he believed, would be to ostracize the elite into a single house, what we would call the Senate. He argued that by giving this house to them, it would allow, it would maybe satisfy their passions. The hope would be that by balancing these different, the one, the few, and the many, you could kind of control the ambitious while squeezing out the good stuff from them, while in the goal to seek honors, maybe society would get some benefits from the clash of the titans. He feared that the masses represented by their demagogues would conflict with the elite, who would in turn conflict with the masses. And to him, one person kept the balance. Between the many and the few, the one keeps the balance between the two. And you can see where fears of monarchism might have been attributed to him. This was mixed with a belief that a language of signs, a belief that offices should be attributed with honors. That way, the desire for honors and recognition could be lived out in public office. And these honors come with public service as opposed to kind of personal enrichment. One might remember the event where he had tried to get elaborate titles for the president and was castigated as a monarchist or a reactionary. Now, the modern historian Gordon Wood devoted a chapter to Adams' constitutionalism in his book, The Creation of the American Republic, 1776 to 1787. And there he kind of described Adams as irrelevant. He did not grasp on to the democratic spirit of the age. His pessimistic view of human nature didn't comport with the belief that people were rational and were getting better and more democratic, and American exceptionalism as well. And he didn't believe this. He had a very pessimistic view about us Americans, who are as bad as the rest of the world. And because of this, Gordon Wood writes him off as out of step. To conclude, really briefly, Gordon Wood instead advocates Jeffersonianism, which did, he believes, capture the zeitgeist, I guess, of that time, which continues to guide us today. These views of we're rational, we're democratic, progressive, democratic, exceptional. On July 4th, 1826, one of the greatest coincidences in American history ever happened. I'm sorry, I'll briefly. John Adams and Thomas Jefferson, second and third president, signers of the Declaration of Independence, died on the same day, hours apart, on the 50th anniversary of the signing of the Declaration of Independence. John Adams' purported last words is, "Thomas Jefferson survives," which he was wrong, because Jefferson had died hours earlier. Both the Adams skeptic Wood and the Adams defender Thompson notes that while Adams' statement that Thomas Jefferson survives is wrong in the literal sense, it might have been correct in a rhetorical sense. It was Jefferson's ideals that we are progressing, that we are rational, that we are exceptional nation. We don't have the same aristocracy because aristocracy is a spawn of the civil laws rather than human nature, was the Jefferson point of view. These guided America through the age of Lincoln and today. But at the same time, when we look at today and we harp about inequality, about the left and the right harping on about the elite of their choosing and how they're ruining their lives, we find that the fears of Adams, the Adamsian fears, grow like the thorns with the Jeffersonian wheat. And so, to some sense, the statement that Thomas Jefferson survives may be true in a rhetorical sense. It wasn't true in a factual sense. And as any student of Adams or of American history generally knows, facts are stubborn things. Thank you.
Hello, and thank you for having me, especially for welcoming a non-lawyer to speak with you. I hope that the maybe unsophisticated nature of my understanding of constitutionalism won't be too off-putting. I'm a historian and a documentary editor, so I want to start by just talking a little about what that means. It has nothing to do with filmmaking. Documentary editor means I edit historical documents. So we take original primary sources from throughout history, we transcribe them, write annotations explaining the various references in them, and publish these in print or in digital forms so that students, teachers, scholars, and the general public can learn history from these original sources. As Austin mentioned, I used to work at the Correspondence of James K. Polk. I was there for 10 years. It was a project that went on for 61 years, longer than Polk himself lived, to publish his incoming and outgoing letters. And that finished in 2019. And right after that, I started a new project, the Correspondence of Zachary Taylor and Millard Fillmore. I choose all the greats. And they were Polk's immediate successors as presidents, serving together between their two presidencies that lasted from 1849 to 53. And I'm going to talk to you today about what they, especially Taylor, said about the Constitution, because it became a real theme during the campaign when they were running for the White House. To give a little background about them, particularly Taylor, he had sort of two careers before he became president. For one thing, he was a major absentee planter. He owned large plantations at various times in Kentucky, Mississippi, and Louisiana. And on those, he enslaved well over 100 men, women, and children. He made most of his money from those, growing cotton and other crops. But as I said, he was an absentee. He wasn't actually on the plantations. From early in his life, he joined the Army and became a career officer. So he often, with his wife and children, were at various Army forts. And in the 1840s, he became a major general and one of the lead commanders in the Mexican-American War, in which the US acquired a huge portion of Mexico. About half of Mexico became American territory. It's during that time that he became really famous on the national stage, and people started saying, you know, you should be president because you've won a lot of these battles. He was reluctant. He, for one thing, didn't think he was qualified. No one up to that time had become president who hadn't held civil office before. There had been generals who'd become president, but they'd also held elective or appointed offices in government. He had not. And he wrote in many letters, he was convinced there are other people more qualified than I am. Eventually, he became open to the idea. He didn't want to be president, he said, but as he put in one of his letters to a family member, I do not care a flint whether I am elected or not. So, okay, if they elect me, I'll serve, but I don't really want it. It doesn't matter to me. It is unclear whether he voted for himself. Once he did campaign, and I should say he was nominated by the Whig Party. The two parties at the time were the Whigs and the Democrats. He was an independent who leaned toward the Whigs. So they gave him the nomination, and they gave the vice presidential nomination to Millard Fillmore, a more conventional politician. He was a fairly well-known Whig from upstate New York. At the time, he was comptroller of New York State, the lead financial officer of the state. So they start running, and people would write to Taylor asking him for his opinions on various issues, and he generally refused to give them. And he had a reason for doing that. He wrote in a number of public letters. Here's one he wrote to Francis Bronson that was always intended for publication in the newspapers. Quote, I desire it to be understood that I cannot submit, even in thus accepting it, the nomination, to the exaction of any other pledge as to the course I should pursue than that of discharging its functions to the best of my ability and strictly in accordance with the requirements of the Constitution. So he tells people, as president, I'll follow the Constitution, and that's all I'm going to say. In some letters, both public and private, he explained his reasoning for this. He said, "It really doesn't matter what the president thinks. Even if I were president, my opinions wouldn't make any difference. Because legislating is up to Congress. They're the ones who make those decisions. Yeah, maybe the president can suggest some laws that he thinks would be useful, but no more active role than that. Then, unless he has a really good reason, he should sign them. And as long as he has good character, then he'll make a good president. So you should vote for him or against him based on his character, not his opinions." In other letters, he had similarly vague language. He wrote to a son-in-law, a man named Jefferson Davis, who later became famous for his own reasons, quote, "Let us look to the Constitution and preserve and enforce it if necessary, all our rights under it." He told Davis that if he became president, he'd appoint people who were true to the Constitution. And he wrote, "I have entire faith in the good old ship, the Constitution," referring not to the actual ship, but to the document. Now, there were some areas where he did become a little more specific, but he generally did so only in what you might call another rhetorical way, referring to the founders, the people of Jefferson's and Adams's day. A Tennessee committee had written to him about his prospect of becoming president, and he wrote that, if elected, quote, "I will feel bound to serve them, the people, and will do so honestly and faithfully to the best of my abilities, strictly in conformity to the provisions of the Constitution, as near as possible in the way it was acted on and construed by our presidents, two of whom at least participated in creating and putting in operation that glorious instrument," probably referring to Washington and Madison, the two presidents who signed the Constitution, Madison being its main author. But he was vague enough that he doesn't actually say, "I'm going to do what Jefferson did," or "I'm going to do what Adams did," and they interpreted the Constitution quite differently in some ways, so he just left it open. Though he did in some other letters, not when discussing the Constitution, say that he was a big fan of Jefferson, and he supported the Whigs because he believed they were the successors to Jefferson's principles. He occasionally also would use the Constitution as a sort of cudgel. He was one of the lead commanders of the army under President Polk as commander-in-chief, but they didn't agree on much in terms of either politics or war policy, and they didn't like each other very much. Once Taylor heard a report that Polk had died. It wasn't true, and he wrote in a letter to another son-in-law that he didn't think it was true, he was right. Then he went on to say, "I do not take pleasure in the death of any man, but I would be less disappointed hearing about his death than of any other man's in the Union." So sometimes he would use the Constitution to criticize Polk and the Democratic administration under Polk. He wrote to Orlando Brown, quote, "If the present party in power are to rule the country for a few years longer, there will be but little left of the Constitution but its name." Yet still, again, he didn't get into what provisions of the Constitution he thought Polk and the Democrats had violated. Now, Fillmore, as the vice presidential candidate, was called on less to campaign or to express his opinions on these issues. People were less interested in the vice presidential candidate than the presidential one, but it did happen sometimes. And he generally followed what Taylor was doing. He gave these vague pronouncements that I'll follow the Constitution. His tended to take more of a sectional tinge. At this time, slavery was becoming an increasingly prominent issue on the national stage among politicians, and so a split was developing between northern and southern white politicians over whether slavery should be preserved, ended, expanded, left as it is. So he acknowledged that in a way that Taylor rarely did. Fillmore wrote to Erastus Culver, who had asked for his opinions, that the Whigs, he and Taylor, would stand by the Constitution and all its guarantees, whether they affect the North or the South. So acknowledging this sectional tension over slavery, but not actually giving an opinion. One benefit, and this was used by many candidates, both parties at the time, by the candidate not making a strong statement about these sectional issues, that allowed surrogates in different parts of the country to say this person supported different things depending on the audience. They could do great things before television. Now, responses to this vague use of the Constitution were varied. Some people who were really supportive of the ticket from the start thought that this is good. Yes, we should be voting according to character, not according to opinions, not according to constitutional interpretation. The first group that ever wrote to Taylor about his potentially becoming president was a Philadelphia committee in the middle of 1847, so almost a year and a half before the election. And they wrote that he should run, quote, with no pledges but those contained in the official oath at your inauguration, and with the Declaration of Independence and the Constitution as your guides. Others were less amenable to this pro-Constitution but vague on specifics policy or campaign. James Eldridge was a Whig in New York, and he wrote to Fillmore kind of complaining about this. He described Taylor as having, quote, refused to express his views and sentiments on almost all the great and the constitutional questions that have agitated the public mind in the United States for the last quarter century. So he asked Fillmore, so if Taylor becomes president, what's he going to do? What does he believe? And he seemed to anticipate the canned response he was likely to get. Quote, I know General Taylor has said he shall be guided by the Constitution if elected president. But that must be understood that he will respect the Constitution as he understands it. And it wasn't clear what that was. In particular, Taylor being a Southerner, amid these rising sectional tensions over slavery, he was worried about what that might mean for those with more Northern or more anti-slavery or slavery critical perspectives. He continued, have we not had enough of the construction of the Constitution by Southern presidents? And the last thing I just want to say is there was one issue on which Taylor did very clearly express his opinion, but still in a very limited way. And this was the veto. As I said earlier, he thought that the president should have a very limited role in the formation of legislation. And he made that public. He discussed it when he was campaigning. In one of his most famous letters, insofar as anything about Taylor is famous, one of his most famous letters during the campaign was officially to his brother-in-law, John Allison, but was, again, always intended for publication, and other members of the Whig Party helped draft it. So it was very much an official campaign document. He wrote, the power given by the Constitution to the executive to interpose his veto should never be exercised except in cases of clear violation of the Constitution or manifest haste and want of consideration by Congress. The personal opinions of the individual who may happen to occupy the executive chair ought not to control the action of Congress, nor ought his objections to be interposed where questions of constitutional power have been settled. So again, the president should have a very limited role. He should be sort of a constitutional check just in case Congress does something terrible. But for the most part, they will be at the center of deciding constitutional questions and setting legislation. It makes me wonder, after listening to Aaron's talk, I was thinking his is John Adams's constitutionalism. Maybe this is Zachary Taylor's lack of constitutionalism. But I'm happy to answer any further questions. I'll leave it there. Thank you.
All right, well, thank you, everybody. Another very informative panel. We will first move to Dr. Reed with his initial questions. It looks like we have one online, so we'll go Reed online and then open it up to the general audience.
Austin, thank you, and thank you to the panelists. So wonderful set of presentations. And I'll begin with Professor Netterman, and that is some commentary in quod omnis tangent. And that is, I'll begin by characterizing it as a legal maxim. And what purpose do legal maxims serve in medieval canon law? I've been giving some thought to this with respect to a different maxim of law that I'm interested in, and that is no one should lose their rights sine culpa, without fault. And when I'm going to try to reconcile Occam and Nicholas of Cusa, as hard as that may seem. And I'll reconcile that by saying what we are seeing in both instances, and what we see generally with legal maxims, is the emergence of a rules consciousness. And rules consciousness, I'll submit, stands at the foundation of constitutional thought. We must first have a consciousness that we are bound to apply rules. We are bound by certain principles of consistency, and that this emerges, I think, in the legal maxims of the Middle Ages. And I think quod omnis tangent represents this rules consciousness, whether in the hands of William of Ockham or in the hands of Nicholas of Cusa, or the many figures who stand in between those two. And Ken, what I see in your presentation is a conversation that is actually replicating itself over the last 200 years in American legal history. And Anglo-American legal history. I'll begin with Herbert Spencer. Herbert Spencer, of course, is the great proponent of property rights. He turns Proudhon's maxim on its head that government taking property is theft. Property is not theft, but government taking property is theft. And we see this manifest again in the Lochner opinion at the beginning of the 20th century. But then we get a pushback, and I'm going to suggest that Bouvier represents that pushback. And he writes in the early years of the 20th century, and we're seeing at the US Supreme Court a tension in the early years of the 20th century between a kind of all-encompassing notion of sovereignty represented with Edward Douglas White's opinion in the conscription cases, his opinion in the Standard Oil case, the antitrust action. In all of these instances, we see a pushback with sovereignty. We're seeing this again within the last year in some important federal court cases. I'm thinking of the net choice case decided by the Fifth Circuit in September, arguing that social media companies, private social media companies, must give kind of public forum recognition to speech because they exercise a kind of common carrier quasi-governmental function. So I'm going to ask you, Ken, if what we're really seeing is a conversation that simply replicates itself over and over again for the last 800 years, a kind of ongoing conversation driven perhaps by political considerations or social needs. And Aaron, I'm going to ask you about John Adams. First off, did you see, I suspect they are there, any hints that Adams is drawing his sources from the Roman Constitution? I suspect strongly he is. There's a popular assembly in Rome, there's the Roman Senate, and I'm wondering to what extent is he simply borrowing classical categories. We know the founding generation steeped in classical education. To what extent is he doing this? And then your comments about unicameralism, I thought were very, very significant. Unicameralism was seen as perhaps the most popular form of government, and Adams sees it as dangerous simply because the elites will try to dominate a type of government that will use a unicameral form to dominate the entire government, as opposed to simply being given their proper place. And Michael, when I hear the word Constitution in the 1840s and 1850s, I think of William Lloyd Garrison and his attacks on the Constitution. And I think of the language of the Constitution. We shall simply follow the Constitution as simply being driven by a prior commitment to maintaining slavery in the southern states. The word Constitution, when I read some of the 1840s and 1850s sources, I see it standing as a kind of proxy for slavery. We remain committed to slavery. Certainly, we see this in 1860. Stephen Douglas represents a constitutional approach to the slavery issue. And I'm wondering to what extent, when Zachary Taylor simply makes these broad general statements about the Constitution, whether he's simply, the modern expression might be dog whistling. Is he simply dog whistling to a Southern audience that, hey, the Whigs aren't as bad as you think they are? Please.
Are we?
Yeah, please. Yeah,
Responses?
Please,
Okay.
yeah.
I think that the difference, thanks very much. I think that the difference between your approach to this and mine is that I am a political theorist or historian of political thought. So what I'm looking at in terms of, you're talking about rules consciousness, is in fact the substance of the rules. And I think you're offering perhaps a different framework in terms of coming at it from a legal perspective. What I'm interested in is, and you use the word polls exactly as I did in the paper, in parts of the paper I didn't read. I think Occam and his essentially very individualistic approach, and Cusa and his very corporate approach are substantively not defending what we would think of as a constitutionalist position, and what a number of scholars think of as a constitutionalist position using modern criteria for constitutionalism. That idea of limitations of power that was discussed at the beginning, and I don't see there being in either of those two figures the idea of a limitation on power, but coming from incredibly different perspectives. Now, indeed, there are an array of other folks that I'm going to talk about in the published article, the published paper, that in fact take different approaches. Maybe you can get a more modern constitutionalism out of them, but even then I'm skeptical. But I simply wanted to make the point, again, coming from a political theoretical perspective or a historian of political thought perspective, that, calling these people constitutionalists just seems to me to be a inaccurate approach. So in any case, but I think it all goes back to the fact that we're looking at the same text and asking different kinds of questions.
Okay.
Ken, you want to?
As I said, I have spent my life tracing rights, tracing what we call human rights in history. And one of the things I've learned is they've never been the same. We have gained them, we have lost them, we have gained them again. And so you're absolutely right, Charles, that this is another example. I would just point out something that's particularly relevant today that I didn't talk about, and that's the right to move about everywhere that we want to move. The modern state has taken that away. It's also denied people the right to come into this country. Is that right? I don't think so, but you may have another opinion.
Thank you so much for your comments, Charles. I think when it comes to what influenced Adams, especially in that defense of the constitutions, it's hard to see what didn't influence Adams. The work was meant to observe a sample of ancient constitutions, Rome being one of them, and modern constitutions of his time. The historian Brad Thompson suggests that he was heavily influenced by Machiavelli, but not the Prince, the Florentine histories. So I think those aspects certainly do appear. I think he observed those correctly. I recall Thompson saying Adams was impressed with the Roman Constitution in his kind of theorization of the language of science. He didn't really expand too much on that. I need to review that. But another thing, though, that Thompson suggests is that Adams, while some earlier historians and political theorists have argued that Adams might be a classical Republican political theory, Thompson actually rejects that. His theory being that Adams's constitutionalism doesn't heavily rely on a concept of civic virtue. He sees people, a rather pessimistic view, and that rising to the occasion, expressing civic virtue, self-sacrifice, was something quite temporary. So in his So for Adams, he criticized to some extent Solon's Athenian constitution as too democratical. He criticized Lycurgus's Spartan constitution as demanding too much from the people. And Thompson considers Adams to be quite impressed by the Carthaginian constitution of all things, which some argue it was mostly a commercial republic kind of view. And so that's the first part. For the second part, for unicameralism, I think Professor Woods, he was the more critical of Adams. I think the strongest criticism that Professor Wood has against Adams is that he never really explained why the elite would be satisfied with one house. Why is one house enough? And will that keep him, why not get the House of Representatives as well? And I think that does count against Adams. Many different thinkers, and because Adams's thought, and excuse me for my choppy nature of speaking, because Adams' thought, I think, can be rightly called a political science because it applied a methodology and looked at these different samples, kind of inductive reasoning. Without too much explanation, I think many different thought systems can claim him as their own. Russell Kirk and Professor Richard Samuelson at Hillsdale have both considered Adams a conservative for his acknowledgement of human nature and a pessimistic view, and his view that humans don't really progress. Luke Mayville and Richard Ryerson have identified him closer with 20th century progressivism for his strong view of the one, holding the balance between the elites and the many. And I think Joseph Ellis goes the farthest by kind of comparing Adams' thought with a sort of proto-socialist thought, this kind of view of human history as a class conflict. So I think because of that unfortunate fact that I didn't explain too well, anybody can claim him.
Thank you, Charles. And I think slavery is definitely an important piece at the heart of this. I think in terms of the use of this vague language, I'll support the Constitution, it was aimed not just at pro-slavery people in the South, but at all groups, trying to sort of be acceptable to everyone. And even most people who were critical to some extent of slavery at the time did not reject the Constitution. They weren't Garrisonians. They were more like someone like Fillmore himself, who wrote in private letters he didn't like slavery, he thought it was bad, he never did anything to end it, and actually signed legislation that made it worse in some ways and helped to preserve it. So they're trying to be something that their campaigners can use to get support from all regions. That said, they did make special efforts at least in private, sometimes in public, to say that they really do support the continuation of slavery. Their opponents during the campaign actually claimed that Fillmore was an abolitionist. This was false, and we would think wonderful, but that was meant as a slander, and he took it as such, and he vigorously denied that. He was not an abolitionist. He was not calling for the end of slavery. Taylor, in private letters, particularly a private letter he wrote to Jefferson Davis, of all people, he wrote that this union is a wonderful thing. We should do everything we can to preserve it, and people in the North and in the South should be open to expressing their opinions on slavery freely. But if the people in the North go too far, then the union won't be worth anything, and we should break it with arms if necessary. So, and this is a future president and a future Confederate president discussing the possibility of armed secession.
All right, wonderful. Well, thank you for those questions and thank you for those answers, Dr. Reed and all our panelists. I do want to jump to the online question first.
We have a question from online that says, why not assume that constitutionalism means setting out the institutional structure by which we the people can legislate for the general welfare and the establishment of justice? Why focus exclusively on limits of power rather than authorization for the use of power for the common good? I think that was directed at anyone.
Well, I think part of the problem, at least from my perspective, is what's the common good, right? And that has been, in the history of political thought, a constant debate. Common goods can be defined in many different ways, and so that too becomes not something that's self-evident. But rather something that develops into different approaches. I quoted Cusa talking about the common good, but his idea of the common good essentially is a small elite of wise men are ruling over the many who are slaves. And again, that's his word, and are in fact self-enslaved by consent. So, there's a theory of the common good, but it may not be one we would be so comfortable with. Although on certain days, I'm not so sure about that.
In Adams's Thoughts on Government, he begins with a quote of poetry from a Pope, Alexander Pope, indicating, essentially, the best government is what governs best. I haven't memorized the lines, but he argues that that's fallacious. He argues that structures are necessary, and I think I don't think his opinion changed. I think he always kind of believed that people had this negative view of human nature. His first, 1775 source has him describe a constitution as, or a republic as a government of laws and not of men, and described Britain as a republic where the king is the first magistrate. But that said, the second part of my paper kind of compares Adams's thought with a state constitutional initiative process by which the people, through initiative, introduce constitutional amendments, particularly in California as the main example. And in a 2008 piece by Ronald George, Ronald George, the former Chief Justice of California, there he expresses reservations with the use of the initiative power as another form of legislating. It essentially, he talked about how at the same 2008, chickens gained rights while gays and lesbians lost theirs, or LGBT community lost theirs. So I think the danger of that, where the people legislate for themselves, from the Adams point of view, is that it succumbs most clearly to public interest or interest groups, and essentially rallying together votes amongst the many. It kind of, Thompson puts down 3 points to Adams' constitutionalism. One was representative democracy, 2 was separation of powers, and 3 was this balanced government of the many few have described. And I think for Adams, direct democracy, I'm sorry for eating up the time, direct democracy is more susceptible to the human passions as he described in his point of view.
If I can add quickly, Taylor and especially Fillmore did discuss the Constitution as something designed to preserve the blessings of liberty, and I have a quote from Fillmore, our ancestors have bequeathed us a free constitution, heretofore blessing and binding together a united and happy people. These kind of general ideas that the Constitution and the Union, which provides so many benefits to the people, are one and the same. The problem with this was the Constitution, as it was written and interpreted then, only preserved those blessings for some people. And it's, again, the question of who are the people that this is protecting, that this is benefiting. And back then, it was not the 3 million people who were enslaved. It was not women who were excluded from political processes. It was not people without property or those with disabilities who were excluded in some places. In South Carolina, people didn't get a popular vote for president. So there were all kinds of limits on who they meant when they said it's protecting the people.
Well, and perhaps I'd just add what Professor Netterman made the statement about common good. What is the common good in the United States? Do we argue about it? Do we debate it? Do our politicians care about it? My conception of what the common good ought to be, I think, is very different from what the common good is in the United States of America.
Wonderful. I think we just got one more online question.
Yes, we have another question. With regard to secession, don't we have to decide whether or not the Constitution offers a definitive view on the legitimacy of secession, i.e., putting to one side the absolute immorality of the cause triggering Confederate succession? Is it not possible that they were being faithful to the Constitution in arguing that consent of the governed licensed secession when ostensibly sovereign states, if one accepts not only that Kentucky and Virginia resolutions, but even the first sentence of McCulloch v. Maryland, come to the conclusion that the other members of the Union aren't living up to the deal of 1787?
And that was the argument that was going on at this time, right up until the Civil War. And both sides felt that they were upholding the Constitution. The CSA, Confederate States of America's Constitution, was very similar to the U.S. Constitution, just with a very firm protection of slavery added into it. They also started using the Declaration of Independence in both the Union and the Confederacy a lot more, saying, Lincoln famously made the Declaration of Independence more famous than it had been before, but the Confederacy also saw them as doing what Jefferson called on people to do, to alter or abolish a government that was abusing the rights of the people. So it was going into the Civil War, one of the ideological debates, yes, was over whether the Constitution is a compact among independent states that can be broken and should be broken in those circumstances, or whether it was something that ultimately sort of created the states, even though the states had existed as in some form before, so that they couldn't break it. The Civil War for a long time was seen as having settled that in favor of the primacy of the Constitution and the federal government.
All right. Yes, I guess you'll need the microphone if you want to extract that.
Question for Aaron regarding John Adams. And so when you say that like he was concerned about the direct democracy being like susceptible to kind of these inflamed passions, it seems to me there that question is really like moderated by like the time horizon in which he's thinking about it, right? So like in the short run, that may be true, but it seems that if we deny direct representation to a bigger part of the populace, that over time, like the systems will erode and become susceptible to those same passions that he's worried about. So I'm just curious if he ever thought about like time in that way, or if he ever kind of, worried about the long-term implications of his own constitutionalism, like how he characterized the American project. Yeah, I'll stop there.
Do you mean in the sense of kind of initiative legislation, or do you mean like in electing their own representatives?
I think I mean more in a general principle. And so, I mean, I guess if it seems to me that he's worried about the general populace being susceptible to like demagogues, and now we see someone like Donald Trump, for example, in my own view, as like a demagogue that represents the very fears he's worried about, yet we have a constitutionalism that kind of approaches more what he was saying. And so it's like when we underfund, underrepresent, underserve a huge portion of the populace, do we not over a longer time horizon get to the same results that he's worried about? Like I guess my root question is he kicking the can down the road to protect the status quo?
I don't think he thought that way. I don't think so. I think he thought that the people would have their elite, their demagogues, and the elite would have their elite, and they would clash. And sometimes one would get the better of the other, and the other, or maybe the many would, I don't know, ransack the rich, or the rich would oppress the many. And it was the job of the one, whoever that was, to keep the balance. Now, whether that means the many get a demagogue as the one, or it's responded with the elite having a one to do, I'm not sure if he thought that far. I think his view of the one was kind of kingly. I think it was a nonpartisan, have tea with the leaders every weekend kind of thing. Maybe not hereditary, but something like that. So I don't think he thought that far down the event horizon. I think he thought the balance would be kept.
Is it a quick question? We got to have time for lunch too.
We have time.
Okay, go for it.
We'll eat fast. This is open to anyone, but probably directed to you two gentlemen at the end. I'm making assumptions along the way, so please correct those assumptions as necessary. If QOT is something that had been part of the global politic of thought, and then we structure our political, or at least that's on the minds of our founding fathers, how in the world can we achieve a constitution that touches all, but also have consent of all, considering that there was millions that were literally enslaved, not the way that it was used before for the religious purposes, but I mean the black people that were enslaved. That to me, and then also once slavery was abolished, we still didn't get consent for a document that governs us for a way of life that imposes on us without any consideration at the time it was adopted. And then to the intimate domain question, that is one that historically has been going on for years. But yet when we come to this country, we take land. We take land from people that have been using it. That we take land from people that have a very sacred connection to it. Matter of fact, where we are sitting right now. But yet there was no just compensation. And yet they were, the Native Americans or native population that was here has continued to be marginalized. How can that be reconciled with constitutionalism and the American ideals that we supposedly enshrine and entrust that this is our identity? There you go.
Well, I'll just say you're absolutely right. It's a great question, and it's something that we should be thinking about all the time. We think of ourselves as a just society. If you look at the history of the United States of America, as well as before 1775, we have conquered this North American country illegally from a modern point of view of international law. We have taken their property, and we have never given just compensation for what we have taken. And we have practiced genocide at the same time. And every American ought to keep that in mind every time they sing the Star-Spangled Banner.
And I'll also say that I think you're absolutely right, and that there is this problem, historically, as I tried to suggest, of who's all, right? And that it's very, in many of these contexts, it's very exclusive, or the criteria are very exclusive. And that's part of my problem with trying to attribute a substance to a phrase like that, precisely because the questions are all, and whether it's a matter of race or gender, or just simply this idea that you've got a lot of stupid people. That's Kuz's position. The all then becomes the real issue. And I absolutely agree with you that all is can be very, very different, and it winds up being an exclusionary phrase rather than an inclusive phrase, which is the inclusive phrase being what a lot of people want to read into it. So
I just have to add one more thing, and that is, I wrote an article about 45 years ago about the conquest of North and South and Central America, and I made the point in that article that the English law did not protect the rights of indigenous people for a lot of different reasons. I'll give you a citation if you're interested, but the point is, if you look at Central America and South America, they didn't practice genocide for the most part. There were some bad stories, some bad things, but for the most part, the law that governed Central and South America was much more just and much more accommodating, and it prevented the kind of genocide that happened in North America.
All right, wonderful. Well, thank you for your panels or your presentations. Thank you for answering our questions. Thank you for your time. Thank you for joining us here in person today. We're all very grateful for your time and your insight. So looking at the time, we're going to amend the schedule in your program a little bit, and we're going to have lunch now, so that gives us a little more time to eat and enjoy each other's company before the keynote. And then we can give our keynote a little more time to present and answer questions if need be. So we will be back here at noon. Lunch is in the same spot as breakfast was. Please feel free to eat as much as you like. And we will see you at noon. Thank you, everybody. Welcome back, everybody. I hope you had a good lunch. We're able to enjoy each other's company and turn your thinking brains off for a second. But now you can put them back on. As I'm happy to introduce our keynote speaker for today, Mr. Akil Reed Amar. It looks like Mr. Amar, can you hear us? Can you see us?
Yes.
Wonderful. Well, I'm happy to report we were able to get a copy of your latest book and hand it out to all of our audience members. So we all have your book in hand for your presentation. But with that, I'd like to give a quick introduction to Mr. Amar before he kicks off his keynote address. So Mr. Akil Reed Amar is a professor at Yale Law School and Yale University, where he teaches constitutional law. After graduating from Yale Law School in 1984 and clerking for Judge and later Justice Stephen Breyer, Amar joined the Yale faculty in 1985 at the age of 26. So someone my age was teaching at Yale, which is quite impressive. He won the university's unofficial Triple Crown, the Sterling Chair for Scholarship, the Devane Medal for Teaching, and the Lamar Award for Alumni Service. Well, Amar's work has won awards from both the American Bar Association and the Federalist Society, has been cited by Supreme Court justices, and has testified before Congress. He has written for the New York Times, the Washington Post, the Wall Street Journal, Time Magazine, and the Atlantic. He was an informal consultant to the TV show The West Wing and has been showcased on many broadcasts. He has recently launched a podcast, America's Constitution. He is also the author of more than 100 law review articles and books, including the one that we were able to provide you with today. So with that, it's my pleasure to welcome Mr. Akil Reed Amar.
Well, thank you so very much. It's an honor to address such an august assembly. The topic for today is constitutionalism. I'm really grateful that the sponsors of this event have made books available to you. I'm going to be reading several excerpts. Some of you may remember an old television show, Sing Along with Mitch. If you like, you can read along with Akil. I picked a series of excerpts about American constitutionalism, focusing on three episodes and events: the Declaration of Independence, the early state constitutions, and the United States Constitution, the ratification of the US Constitution. So my first excerpt is it begins at page 130. My friend Sandy Levinson just sent something to the chat. He's going to be taking a break from 1:45, but he'll certainly return for the panel. Okay, so I begin at the bottom of page 135, and this is a discussion of the Declaration of Independence. Were the Declaration's legal claims valid when judged by the legal standards of the time? In the narrowest sense, no. Under the British Constitution of 1776, an unwritten hodgepodge of institutions, practices, and principles that had accreted and evolved over the centuries, the most basic principle and institutional practice of all was parliamentary sovereignty. After the Glorious Revolution of 1688, Parliament was the supreme lawmaker and also the supreme judge. In 1776, Parliament did not find Jefferson and company persuasive. Hence, a long and brutal war, indeed another world war, ensued, continuing through the 1781 Battle of Yorktown and until the 1783 Treaty of Paris. And I say another world war because my book begins with what I claim is the first modern world war, which we in America called the French and Indian War, and the rest of the world called the 7 Years' War. And it's going to be succeeded by what we call the American War of Independence, but is another world war, in my view. But parliamentary fiat cannot be the sole test of legitimacy. If British law said, as it in fact did in 1776, that Britain had a right to rule France, surely it might matter what the French thought about this claim. For a law to be truly law, to be true to its own inner logic, to be more than mere force, to be fully legitimate and lawful, legal authorities have to pay at least some attention to the views of those whom law purported to rule, to the consent of the governed, to borrow a phrase. Jefferson and company were not really trying to persuade Parliament. Rather, they were trying to persuade colonists to reject Parliament and British rule altogether. Not all Americans were persuaded. Many remained loyal to King and Parliament. Some loyalists stayed, others left for Canada, Britain, and the West Indies, and elsewhere. Many other Americans tried to avoid choosing sides. But here's the key point. An overwhelming number of Americans in the 1770s did affirmatively choose to side with the Declaration. Modern scholars have estimated that loyalists likely accounted for 20% or less of America's free population. So that's where the literature is before I come along, and I'm going to try to do better than just a guesstimate. And the way I'm going to do it is actually by paying attention to the fact that America is a proto-democracy. It has newspapers, it has public opinion leaders, and I think we actually can do better in guesstimating the relative sizes of loyalism versus patriotism. And so here's my kind of contribution on that. Among America's top political leaders, because you see, Americans have elections, and the people who will call themselves become Americans in 1776, their colonists before, they have elections in these places, and we can actually pay attention to who their elected leaders are. Among America's top political leaders, loyalist ranks seem remarkably thin. The American-born loyalist of greatest ability and accomplishment was without doubt Thomas Hutchinson, who stars in my earlier chapters. Pennsylvania's Joseph Galloway, a friend of Franklin's, once successfully tried to revive a version of the intercolonial Albany Plan at the First Continental Congress, also chose the path of loyalty in 1776. So did Timothy Ruggles of Massachusetts, former president of the Stamp Act Congress, and Stamp Act pamphleteer Daniel Delany, a long-serving member of Maryland's appointed council. Another American-born loyalist of note was New Jersey's William Franklin, a colonial governor who broke with his famous father, Benjamin, but never came close to matching his father's achievement or to winning the love of his fellow colonials, as did his father, Benjamin. William, after all, was a royally appointed governor. Only in Rhode Island and Connecticut did colonists themselves elect governors. By contrast, although Hutchinson did hold many royal appointments over the course of his long career, he had also won electoral triumphs time and again in his native province in the decades preceding the Stamp Act crisis. Galloway in Pennsylvania had likewise won election repeatedly. Indeed, Galloway, and here's my point, uniquely among the most important loyalists, had done so well into the 1770s. So I'm just telling you, there are not very many elected American leaders who actually will end up siding with George III. So here's the point. The Declaration succeeded in its main mission. It won the hearts and minds of the lion's share of America's genuine leaders, from Franklin and Washington on down. The Patriot leadership list included both established notables and newer, fast-rising public figures, and included both those who were in Congress and those who stayed back, the Continental Congress. Men from many walks of life who were admired by their communities, opinion leaders in a modern sense, leaders who were followed by a vast number of Americans who were by definition less notable. See, we don't have perfect polls back then, but I'm saying we can actually learn something by looking at the elected leaders. From north to south, the galaxy of leaders, this galaxy of leaders, these are patriots, they're going to side with the Declaration of Independence, included the Adams cousins in Massachusetts, flanked by wealthy merchants such as John Hancock and Elbridge Gerry, respected artisans such as Paul Revere, and politically active printers such as Benjamin Eads and Isaiah Thomas. So I'm going north to south. Rhode Island's distinguished Stephen Hopkins, a former governor and chief justice with more than a decade of service in these top offices. Connecticut's Roger Sherman, a self-made cobbler politician. Jonathan Trumbull, longstanding governor and the father of the famous patriot painter, John Trumbull. Chief Justice Matthew Griswold and prominent Associate Justice Samuel Huntington. New York's smooth young lawyer, John Jay, and various illustrious Livingstons, who sat atop the colony's social order. New Jersey's preacher, scholar John Witherspoon, of Princeton fame, and ingenious inventor David Rittenhouse. Pennsylvania's lawyer, scholar, and Scottish emigre James Wilson, radical scribbler, and English emigre Thomas Paine, and civic leader Benjamin Rush. Delaware's leading lawyer politician Thomas McKean, Virginia's revered legal scholar George Witt, lawyer orator Patrick Henry, polymath planter Thomas Jefferson, various notable Lees, and the highly respected lawyer Edmund Pendleton, and South Carolina's preeminent politico John Rutledge. So you see, I'm actually going through the colonies and I'm showing you they're prominent people from all sorts of walks of life everywhere who are patriots, not so many loyalists, you see. To this list, we should add various ambitious and adept younger men who flanked the patriot cause and would later achieve fame in independent America, but who likely would have languished in obscurity had the king remained in charge, because these men, despite their talents, were not closely enough connected to the aristocrats and authorities in London who mattered. Low-born genius Alexander Hamilton, a New Yorker originally from the West Indies, surely belongs at the top of this list, alongside Virginia's James Madison and John Marshall. An even younger revolutionary was South Carolina's Andrew Jackson, who would later move west. Other young men whose careers were catapulted by the Revolution include Massachusetts' Henry Knox, who would serve as Washington's first Secretary of War, Pennsylvania's Thomas Mifflin, who would serve for 11 years as Pennsylvania's chief executive, and Maryland's James McHenry, an Irish emigre who would serve as Washington's third Secretary of War. So I'm showing you up and down the continent, a lot of people from a lot of different walks of life are basically siding with the patriots, and they're not very many loyalists. And then have a little discussion of Benedict Arnold, who was not particularly popular in America. And I give you evidence for that lack of popularity. So here's now, I flash forward to page 135. Here's my basic summary about why American revolutionaries basically succeeded in mobilizing the mass of Americans against the British monarchy and Parliament. The British system in 1776 allowed the king to pick favorites. King George III chose to listen to lesser men, arrogant, ignorant, petty, and belligerent grandees who were more geographically and socially proximate to him than were his talented American subjects, who were humbly bending their knees and seeking his ear. The king and his inner circle, trapped as they were in an old world set of institutions and understandings, did not appreciate the democratic revolution exploding in the New World with audacious newspapers, edgy cartoons, essays by anonymous authors, extra-legal and self-selected assemblages everywhere, massive civil disobedience, and grand-scale performance art, like the Tea Party. The king heard Thomas Hutchinson, who was a loyalist, but humiliated Benjamin Franklin. Indeed, the monarch met Hutchinson within hours of the governor's 1774 arrival in London, but never bothered to meet Franklin, even once during Franklin's 10-plus years in the imperial city, when Franklin was widely recognized as one of the world's great men and the new world's greatest man. So do not believe Andrew Roberts, his biography, The Last King of America. George III is this great Enlightenment figure. Bullshit. Okay, he's got one of the world's great Enlightenment figures in his hometown for 10 years. He can't actually even be bothered to invite Benjamin Franklin to share a cup of tea with him. Okay, that's why he loses, because he's actually utterly out of touch. George III never tried to converse or correspond with either of the talented Adams cousins, or with James Wilson, or with any of the leading Virginia burgesses. He evidently did not read American newspapers. And the king was in a position to matter hugely because England was an old world hereditary monarchy. When James Otis became unsound, his neighbors stopped voting for him. Otis is this great patriot. When who goes crazy. When George III evinced mental instability, his subjects kept bowing to him. Put differently, it was the Americans, not the British, who better foresaw the long-term future of the British Constitution itself, as that Constitution worked itself pure. In that future, an evolving set of British constitutional norms and rules would follow American ideas and practices by 1, clipping the military and patronage powers of monarchs, 2, expanding the sphere of action available to informal peaceful gatherings and democratic assemblies, 3, abandoning imperialistic parliamentary claims to rule foreign lands, like my parents' India, 4, embracing a version of the Dominion model, which is going to become the Commonwealth of Nations, 5, improving the actual representativeness of the House of Commons, and 6, rewarding British politicians able to master modern techniques of democratic communication and conversation, especially those future British politicians able to converse well with Americans and attend to American public opinion. That would be Churchill, Tony Blair, Maggie Thatcher, etc. But if law to be truly lawful and legitimate, so that's what I just said is the Americans are better than the Brits, and I'm about to say it again. If law to be truly lawful and legitimate must take some account of the views whom it seeks to rule, what about American women in 1776? What about indigenous peoples, referred to by the Declaration as, quote, merciless savages, unquote? What about American slaves and American slavery? The status of women, Indians, and slaves would structure much of America's constitutional conversation in the decades to come. We shall thus return to these questions in future chapters. So I'm so glad you have the book, because you can read what I have to say in more detail about all 3 of those issues. For now, as we focus especially on the moment of decision in 1776, the Declaration, we should note, here's my key point, that on none of these issues, that's women, Indians, and slaves, on none of these issues were the British better than the Americans, because that's your choice. Moreover, Americans had strong answers, unhypocritical answers, answers that were genuinely defensible given the world they inherited and sought to remake on women and Native Americans. On slavery, however, the Declaration of Independence hypocritically sacrificed justice and truth, self-evident truth at that, on the altar of self-interest, unity, and military expediency. And I'm going to skip over what I say about women and about Native Americans. You can read it. I hope you do. So I'm going to come instead to the slavery issue. And here is basically my direct answer to the 1619 crowd. And I wrote this book before 1619 I wrote this part of the book before the 1619 project had really ramped up. And so I'm now flash forwarding to page 143, if you want to sing along with Mitch or read along with Akil. This is about slavery and 1776 and how to think about it. In an honest way, but that gives the Americans their due and avoids anachronism. If all men were truly created equal, how could some men own other men and own their yet unborn progeny unto the last generation? If life and liberty were unalienable rights, how could slavery be lawful or legitimate in the deepest sense of these words? There were no principled answers to these obvious questions. which laid bare the basic contradiction at the core of the Declaration and of Thomas Jefferson's convoluted contortions. Masters did not virtually represent the best interests of slaves, the way John Adams genuinely and plausibly understood himself to virtually represent Abigail Adams. And I skipped over that. And by the way, Abigail agrees. And I talk about the letter, about remember the ladies. And I say, actually, women are buying into virtual representation at that moment. They'll reject it later on. And I'm saying, but that's not an argument for slavery. Slaves thirsted for freedom and ached to win it whenever and however possible. Newspapers teemed with ads offering rewards for the capture of runaways. Colonists themselves obviously understood all this and more when they referred routinely to objectionable British practices as tantamount to slavery. That's in quotes. So slavery is such a good idea. Why do they say actually the Brits are treating them like slaves? And that's cause for revolting against the Brits. Nor did slaves constitute some different sovereign or quasi-sovereign entity, like, say, the Mohawk or the Oneida or the Seneca. That's my discussion of the Native Americans and the tribes that sometimes wage war against Americans. Slaves spoke the same language and lived in the same cities, towns, and counties, in the same buildings sometimes as their masters. They were part of the same civilization, and they surely were in daily conversation with masters and the agents of masters, again, unlike some of the tribes at the time. The explanation for the beam in the Declaration's eye was geostrategic. To defeat the British would require the unity of all 13 mainland colonies. The snake, that's Franklin's snake, the join or die snake, could not be divided. Unity meant agreement from South Carolina in particular. And the South Carolinians were so wedded to slavery as the basis of their society that they were not even willing to discuss the institution in the 1776 Congress. This is a quote. "If it's debated whether slaves are our property," declared South Carolina's Thomas Lynch Jr., "there is an end of the Confederation. We're walking. If you even discuss the topic, we're out of here." Franklin's serpent had quite a sting in its tail, as it turns out. The tail end is the southern end of the snake. Thus was born a basic contradiction between what Americans professed at their best and what they practiced at their worst. As finally adopted, the Declaration's text muted the contradiction. The document assailed King George for, quote, "exciting domestic insurrections among us," slave revolts, but said no more. In an earlier draft, Jefferson had passionately condemned the international and domestic slave trade, though not quite slavery itself, and had tried to blame the British for introducing and imposing the slave trade on America. And then I have a long quote from Jefferson that doesn't make it into the final cut, and I'm going to skip over that because what Jefferson says is utterly absurd. The king, and here's why. The king and parliament had not generally prevented masters from freeing their own slaves. The master's own greed had prevented that. Nor had the king and parliament mandated that Americans buy and sell slaves domestically. If Americans could voluntarily refrain from buying black tea, why not black slaves? Jefferson's efforts to shift blame away from himself and his fellow masters was clumsy and confused, and Congress wisely excised the entire passage. Okay, so I'm hard on Jefferson, but now let me just turn around and tell you about the Brits. British critics sneered at the hypocrisy of American patriots in the 1770s. The classic line came from a 1775 pamphlet, "Taxation No Tyranny," by the ever-quotable Samuel Johnson. How is it that we hear the loudest yelps for liberty among the drivers of Negroes? It was a great put down, a brilliant proto-tweet from a distinguished Englishman whose opposition to slavery was sincere and abiding. But in the end, the last laugh was on Samuel Johnson himself, who in this reactionary pamphlet obtusely defended all sorts of English abuses. Johnson notwithstanding, the British Empire, here's my key point, in 1776 was every bit as steeped in slavery as were the mainland colonies. The West Indies were even worse than South Carolina, and that's hard to do. True, in November 1775, Virginia's royal governor, Lord Dunmore, promised freedom to certain runaway slaves, the specific gravamen of the Declaration's grievance about royal incitement of domestic insurrections. But the cynicism of Lord Dunmore's gambit was obvious on close inspection. Only slaves of rebels, not of loyalists, would be freed, and only if they served His Majesty's armed forces, fleeing from one servitude to another. More generally, this is my biggest point, we must distinguish between freeing individual slaves, even many of them, and ending slavery as a system. Emancipation, also described as manumission, was not the same as abolition. Dunmore never proposed abolition, nor had any other British official or entity. Most contemporaneous and previous regimes in world history had allowed slavery of some sort. Few governments had ever, in the history of the world, adopted a sweeping and enduring ban on all forms of unfreedom. No major British organization prior to 1775 had advocated for complete abolition. But in 1775, there arose a remarkable civic society that aimed to end slavery itself. The society was formed not by Johnson, not in Johnson's vaunted London, nor indeed anywhere in Britain proper, but rather in Philadelphia, the host city of the Continental Congress. Two of the society's early leaders were Benjamin Franklin and Benjamin Rush, who both in the summer of 1776 added their names to the American Declaration of Independence. The Society for the Relief of Free Negroes, unlawfully held in bondage, was founded in Philadelphia in April 1775. The outbreak of war interrupted its activities. In 1780, thanks in part to its members, revolutionary Pennsylvania enacted a legal plan of partial emancipation and complete, albeit gradual, abolition. In 1787, the organization renamed itself the Pennsylvania Society for Promoting the Abolition of Slavery and the Relief of Free Negroes Unlawfully Held in Bondage, and for improving the condition of the African race. Benjamin Franklin became its president, Benjamin Rush its secretary. Okay, so that's my first take. It's about 1776 at the continental level. Now, my second excerpt is on what's happening actually in the individual colonies turned states. And it begins at page 151. And here's what I say. And this is in the tradition of Sandy Levinson, who reminds us just how important state constitutions are. There's a piece in today's New York Times by, or maybe it was yesterday, Jamel Bowie, giving a big shout out to Sandy on state constitutions, and to Professor John Dinan, who also talks about state constitutions. I think they're very important and write a lot about them. Gordon Wood's dissertation, the creation, also known as the creation of the American Republic, is all about the early state constitution. So here's what I have to say about that. This is a chapter 4. It begins, we, as in we the people. Americans were now on their own, facing a future both terrifying and exhilarating. In mid-August 1776, the British amassed more than 30,000 soldiers, including nearly 10,000 German mercenaries near New York City. If these professional troops could smash General Washington's raw and ragtag army in the vicinity, the war might end almost before it could start in earnest. Okay. So it's looking grim for the Americans. But then I go on. Alongside the overwhelming military and diplomatic challenges at hand, Americans would have to forge new constitutions or constitutional equivalents, locally and continentally, to replace the old provincial and imperial legal order they had just cast off. Unless these new legal systems made life significantly better than it had been under Britain, all the patriots' foreseeable sacrifices of blood and treasure would be for naught. For all their anxiety, Americans also thrilled at the prospect before them. And these are amazing quotations. I want you just to feel them and hear them. We have every opportunity, wrote Thomas Paine in the stirring closing passages of Common Sense, to form the noblest, purest constitution on the face of the earth. We have it in our power to begin the world over again. A situation similar to the present hath not happened since the days of Noah. John Adams, usually far less utopian than Paine, also waxed rhapsodic. You and I, he wrote to a friend in a meditation that soon became a widely read pamphlet, you and I have been sent into life at a time when the greatest lawgivers of antiquity would have wished to have lived. How few of the human race have ever enjoyed an opportunity of making an election of government for themselves or their children when, before the present epoch, had 3 millions of people full power and fair opportunity to form and establish the wisest and happiest governments that human wisdom can contrive. The situation was indeed utterly unprecedented, both locally and continentally. Okay, and now I'm just going to tell you a little bit about locally. On May 17, 1776, John wrote Abigail. And by the way, in an amicus brief I just filed in the Supreme Court with Steve Calabresi and Vic Amar on the independent state legislature theory, we quote this passage because this is what the American Revolution is all about. It's about state constitutions. And the real moment of independence isn't even July 2nd or July 4th. It's actually mid-May when the Continental Congress votes to encourage the individual colonies to adopt state constitutions. And that's this little passage. On May 17, 1776, John wrote Abigail. He had just successfully championed a 2-part resolution urging each colony to form its own government entirely free from any political or legal connection to George III or Britain. This resolution, he explained with a mixture of pride and awe, was tantamount to absolute independence. And then he goes on, a whole government of our own choice, managed by people whom we love, revere, and can confide in, has charms for which men will fight. That's what it's all about, the independence of each colony to govern itself. To find the true meaning of American independence, circa 1776, we must thus look beyond the Continental Congress. We will not find all the answers to the meaning of 1776 in documents that fully emerged only years later, like the Articles of Confederation or the Northwest Ordinance or the Federal Constitution. No, if we are to understand what all the shouting was about in 1776, what the main point of the conversation was, we must first ponder the state constitutions that sprouted like so many daffodils up and down the continent in the springtime of the New World. And then I'm going to tell you just very briefly over the next couple of minutes just what these state constitutions were all about in a nutshell. The essence of these early constitutions did not reside in minute details or even in larger patterns on specific day-to-day substantive issues. The key to 1776 was not that most of these state constitutions born in that year prescribed annual elections, lacked a regular system of census and reapportionment, featured chief executives who had no veto power and were selected by legislatures, specified religious qualifications for public service, and omitted an explicit right of free speech for ordinary citizens. Although all these things were true of most 1776 state constitutions, and none of these things is generally true of state constitutions today, these modern documents, the documents today, nevertheless descend emphatically and directly from 1776. Okay, so I say the most remarkable features of these early state constitutions were certain overarching elements, this is from page 154, that are now so commonplace that we forget how truly revolutionary they were in 1776. Writtenness, concision, replicability, rights declaration, democratic pedigree, republican structure, and amendability. That's the essence, I say. Never before in history had this particular combination of features come together. After 1776, this cluster would sweep across the continent and eventually across much of the modern world. Okay, so the history of the world before 1776 was a history of accident and force. Most people in most places were ruled by brute power or old customs that the populace had never formally consented to in any self-conscious moment of collective choice. Very few advanced societies in or before 1776 could be described as self-governing. The history of the world was a history of emperors, kings, princes, dukes, czars, sultans, Mughal lords, tribal chieftains, and the like, thugs, all. That's the history of the world. Among advanced civilizations, even those few societies that were moderately self-governing never had anything like a 1776 style written constitution existed. In many places, including 18th century Britain, the fundamental rules and norms governing the system had never been reduced to a single comprehensive text, much less a relatively short and readable one, that had been democratically approved in some manner and made generally available to members of society. Okay, so that's the essence of the thing. In state after state, this is page 155, building on each other in self-conscious conversational fashion, Americans introduced to the world an entirely different constitutional model. Representatives, plausibly claiming democratic authority based on at least one actual, if imperfect, set of elections, composed and promulgated a short composite set of basic rules expressed in ordinary language, as opposed to the Magna Carta. It's not even in English, it's in Latin. Ordinary language, easily publishable in state newspapers. There are no newspapers when Magna Carta comes on the scene, really, and easily republishable elsewhere for edification and emulation. This document, an American-style constitution, would typically identify fundamental rights and map out the basic scheme of government power. Whether or not these short documents explicitly said so, these texts quickly became to be understood as generally amendable at any time by a broad popular majority. Building on the great debate of 1763 to 1776, America's first generation of state constitutions was designed for newspapers and those who read them, not just lawyers and not just locals. State constitution. So the basic point is these newspapers are short. They're all published in newspapers, and once they're published in one place, they're republished and copied elsewhere. It's an extraordinary constitutional conversation up and down a continent, and it's unimaginable without a print culture, without newspapers. Written constitutions and newspaper culture in America grew up hand in hand. I'm going to end now with just a very quick discussion now of 1787, how it carries forward this tradition, and then if we're lucky, maybe we'll have 5 minutes for your tough questions for me, your withering questions. So I'm now last passage is a couple of pages from chapter 6. This one's called People, as in we the people. This is when the people take center stage in the world. The year-long debate over the Philadelphia Convention's proposal took the rising system of America's constitutional conversation to its highest level yet. More participants than ever before in world history tightly focused on a clearly defined constitutional question. Do we ordain and establish or don't we? And directly engaged each other in multiple and intersecting ways, in newspapers, in coffee houses, and taverns, in face-to-face public ratification debates, in correspondence and elsewhere, with words and pictures, both simple and complex. The book has all sorts of cartoons and pictures, and so I hope you like them. The composite facts and figures are astonishing, and they're worth summarizing and savoring before we examine the process close up. First, on the number of elections, the Philadelphia proposal aims to come before an entire continent for a two-step vote in each of the 13 states, 26 proposed contests in all. In the initial step, voters in each state would select delegates to a special single-purpose ratifying convention with full foreknowledge of the specific plan on the continental agenda. In the next step, delegates in each convention would discuss the plan in detail, face-to-face, issue by issue, in full public view, with newspapers in attendance before saying yay or nay. Second, on the breadth of voter and delegate eligibility. And this is my critique of Beard and Howard Zinn and that crowd, including my friend Mike Klarman. In 8 of the 13 states, ordinary property qualifications were lowered or eliminated for this special Massachusetts-style ratification process. Massachusetts had done this earlier in 1780. Allowing more persons than usual to vote, this again in 8 of the 13 states, or more persons than usual to seek election, or both. For example, New York waived its standard voting rules and for the first time in history allowed all adult free male citizens to vote on the Constitution. No race tests, no property tests, no religious tests, no literacy tests. Those are not the ordinary rules in New York. They're the rules for the special constitutional moments, to borrow a phrase. 2 other states followed, in addition to the 8, followed standing voting rules that routinely allowed virtually all tax-paying adult male citizens to vote. So that's 8 plus 2, that's 10 out of 13. No state followed stricter suffrage rules than usual. Rules that allowed free blacks to vote in most states and even most slave states. Never in American history, never in world history had so many persons enjoyed the right to vote on any single question, much less the question of how they and their posterity would be governed. We the people, indeed, in actual fact. Third, this is my last point, on the breadth and depth of the conversation, because constitution isn't just about voting, it's about talking, conversing. When the Philadelphia Convention released the document, the proposed constitution on September 17, 1787, nearly every newspaper in America rushed to print in full the proposal's 4,500 words. At least 6 print shops in Philadelphia alone published the complete text within the first few days. Over the next several weeks, republication in full occurred in dozens of other cities and towns, including in chronological order of initial publication. And I give you the list so you can see the diffusion pattern. You can see actually, in fact, imagine the ships going out and the horses galloping from Philadelphia. And so here's the diffusion pattern, culminating in newspaper publication in the following order: New York, Baltimore, Boston, New Haven, Elizabeth, Carlisle, Frederick, Providence, Richmond, Alexandria, Annapolis, Worcester, Norwich, New London, Norfolk, Portsmouth, Hartford, Middletown, Litchfield, Bennington, Charleston, Salem, Poughkeepsie, Northampton, Newburyport, New Bern, Portland, Pittsburgh, Newport, Fredericksburg, and Windsor. Over the ensuing year, Americans along a 1,000-mile stretch directly conversed with each other as never before, and did so because it mattered. Newspaper essayists jousted with each other conversationally with repeated rounds back and forth in tight temporal sequence. Delegates in ratifying conventions likewise conversed on countless points, large and small, and did so in public. Here's an amazing sentence. Many actually listened as well as spoke. Some openly changed their minds and their votes during these conversations. Imagine that. Changing your mind, changing your vote, actually listening. What a concept. In astonishing contrast to prior violent episodes, the Hutchinson riot, the Boston massacre, the multiple instances of colonial tarring and feathering, and the general intimidation of loyalists, many of whom ultimately fled America, and of course the unspeakable carnage of the Revolutionary War itself, here's the key fact. Almost no one was killed or maimed in political struggle during the fateful year of constitutional ratification. You compare that to January 6th of 2021. We should be ashamed of ourselves. Even as tempers flared and passions raged because the stakes were enormous, Americans conversed but did not combat. Conversed but did not combat. The losers in this conversation were not bullied into submission or forced into exile. Rather, the anti-federalists, the name given the naysayers, were listened to. Some of their smartest concerns found their way into the Constitution's first round of amendments, what we call the Bill of Rights. And some of their smartest leaders eventually found their way into the Constitution's highest posts, from the presidency on down: James Monroe, Elbridge Gerry, George Clinton, and so on. Appeals range from the extremely erudite to the stunningly simple. 2 sites of conversation, newspapers and conventions, frame the debate, and the dynamic interaction between these sites, that is newspapers and conventions, to find a truly new world model of American-style constitutionalism. So that word constitutionalism is the last word of my excerpt. It's the title of your of this symposium, and I've got 2 minutes left.
Well, thank you, Mr. Amar. That was very insightful. I know I took a lot out of it. I think my classmates and the audience did as well. I guess if we had time for one question, Dr. Reed.
May I ask a question about the text at page 144? Mm-hmm. And that is your statement that there are geostrategic reasons for slavery.
Yes.
But slavery truly was a deeply embedded phenomenon in colonial American life. New England merchants regularly profited from the slave trade in direct and indirect ways, and the slave trade, in fact, helped build fortunes not only in New England, but even in England itself. Isn't slavery a more deeply embedded phenomenon than simply a geostrategic nod in that direction?
Well, what I say in the book is immediately after 1776, basically slavery evaporates in the North. It's abolished altogether in Massachusetts, in New Hampshire, in every state in Pennsylvania, either immediately or gradually. Basically everywhere north of the Mason-Dixon. So it starts at less than 4 or 5% in Massachusetts. So in fact, here's the analogy geostrategically. The American Revolution and the Constitution are the products of the first modern world wars. And by world wars, I mean the first wars in which you have the great powers of the world contesting simultaneously on multiple continents and multiple oceans, including the New World. So it's born out of World War I, which is started by a guy named George Washington, age 22, in Western Pennsylvania. And it's a world war, and so is the War of American Independence. It's part of a much larger global struggle, including India. When we in my parents' lifetime, there's a world war. America allies with the Soviet Union. It's an alliance of convenience. We have to do it to defeat Herr Hitler, and then we go our separate ways. And now it's us against Putin. It's Cold War. Okay, that's the same thing as the American Constitution. There's not one America. There's several Americas. New England is extremely different from the middle colonies, which are the northern middle colonies like New York, which is different than the upper South, what we call the upper South Virginia, which is different than the lower South. But they form a geostrategic marriage of convenience because they all have to hang together, otherwise they will die, join or die. But they're very different regimes, and almost immediately after the American success of the American Revolution, the Constitution, they start to go in different ways. The North toward abolition, the South, South Carolina toward increasing batshit craziness, and Virginia caught in between. Okay, so I tell that story in great detail. So do not, I'm going to be fierce with you, pick one sentence from page 144, and you got to read the whole damn book. It'll take you a long time, but it tells an epic story about how it's a mistake to read back into history one America. There's not one America. There are actually several very, very different colonies with very, very different visions that will eventually result in a North going one way, a South going another way, and that's going to culminate in another war. And the analogy would be the United States and the Soviet Union creating a geostrategic alliance of convenience, and then immediately after they succeed, they actually go very different ways because it's got very different visions of what they really want.
So in essence, we're dealing with multiple Americas.
Yes, yes. And so the words that made us begins when there is no us. It's a pun on the U.S. In 1760, the newspapers aren't even conversing with each other. Stuff that happens in Boston isn't even being paid attention to in Williamsburg and Charleston. But I show how through newspapers, especially, they begin to converse with each other, create committees of correspondence, and eventually ally with each other. But it's a shotgun wedding. It's a marriage of convenience. And very soon afterwards, to repeat, the North adopts abolition. Everywhere north of the Mason-Dixon, slavery is going to be abolished by, or at least put on a path of abolition by 1800. It may be gradual, but they're getting rid of it in the North. They're doubling down on it in the Deep South.
Well, thank you.
Great. All right. Excuse me. Mr. Marr, do you have time for one more question, or do you have to?
I have as much time as you like, and I'm so grateful that you've invited me, and thank you very much for that.
Yes, of course. Does any audience member have a question? I'd like to open it up to more than just Dr. Reed and myself. Or can we get the microphone? Yeah.
Just a brief question. I'd be interested in how you look at this history and kind of overlay it onto the current conversation around constitutionalism. Where do you see, is the Constitution colorblind? Should it be paying attention to things like race? Can you speak a little bit about this history and how it overlaps with 14th Amendment jurisprudence?
This is the first of 3 volumes, if I live long enough. This one's called The Words That Made Us, and it's upon the U.S. America's Constitutional Conversation, 1760 to 1840. I begin with a tip of the hat to Lincoln. My opening section is called The First Fourscore. This is the beginning, and conversation is really important. I'm saying they're really talking to each other. It's all about newspapers. And when the South shuts down discourse, which it does, makes it a crime to criticize slavery, which it does, tries to prohibit newspapers from circulating in the South, anti-slavery newspapers from circulating in the South, and which it does, that's going to end badly in a civil war. So volume 1 is The Words That Made Us, how we became a we, how 13 very different colonies that happen to be geographically contiguous, but not have that much in common with each other, come together for geostrategic reasons. They're really like the British Commonwealth of Nations in 1930, which is Kenya and Ireland and Canada and India and New Zealand and Australia. They don't have that much in common. They have a common crown. That's American 1760, but they happen to be geographically contiguous, so they actually come together and form an indivisible, legally, nation state. And that's volume 1, The Words That Made Us, How We Become a We, 1760 to 1840. Volume 2 is The Words That Made Us Equal, America's Constitutional Conversation, 1840 to 1920. It's the next 80 years, and it's going to be all about, it's going to begin actually with an anti-slavery convention in London, the world's first anti-slavery convention, where the men kick the women out, and it's going to end with women's suffrage, the 19th Amendment, and yet another world war with a civil war in between. So that's going to be the story of American equality, the words that made us equal, especially about women and blacks. Volume 3, if I live long enough, will be The Words That Made Us Modern, America's Constitutional Conversation, 1920 to 2000. Now, I didn't answer your specific question about the Supreme Court case about affirmative action, but if you want to hear more on that, I've got a free weekly podcast. The next week will be the 100th episode. It's free. It's called America's Constitution. Just put in Akhil Amar podcast. This week's episode are clips from the oral argument in the affirmative action cases, and we're going to have, it's part 1 of 2. So you'll hear my thoughts on the affirmative action cases on the podcast. And there'll be some of that, obviously, maybe a lot of it in volume 2, which, to repeat, is going to be all about the equality theme, the words that made us equal, America's Constitutional Conversation, 1840 to 1920.
Right. Wonderful. We got one online question, and then that'll be it for questions to Mr. Amar. So go ahead, Olivia.
We have a question from folks online asking if your study includes the development of the Articles of Confederation and the process that resulted in the 1787 Constitution.
Absolutely. So the chapter 4 actually takes the story in 3 different ways. There are actually about 6 paths that splay out from the Declaration of Independence, and I trace 3. I tell you about the Confederation and the state constitutions and the story of the American West, the Northwest Ordinance. Those are the 3 stories that I tell, and they're going to come back together in Philadelphia, where state constitutions are going to feed into the federal. That's a Sandy Levinson idea. And the American West is going to be really important. It's what in part holds the North and South together, is their effort, their hope to basically conquer and control the West. So the state constitutions, the Articles of Confederation, and which is the first draft of a U.S. Constitution, and the Northwest Ordinance. So I tell those 3 stories. That's actually chapter 4. Here are the stories that I don't tell, which are standard American Revolutionary stories. I don't tell the diplomatic story, especially with Franklin in Paris. And I don't tell the military story, Saratoga and Yorktown and Trenton and the Battle of Brooklyn and all the rest. So there are at least, I said 6, I meant 5. There are at least 5 different narrative threads that typically come out of 1776. I trace the 3 main legal ones: Articles of Confederation, Northwest Ordinance, and state constitutions. And I don't really follow the military story or the diplomatic story, although they are creating the context, the geostrategic context, in answer to Professor Reed, the geostrategic context framing everything else.
All right, wonderful. Well, thank you for that. Thank you again for your time. Thank you again for spending an hour with us. We really appreciate hearing from you and answering our questions. And I think we'll have to cut it off there so we can get to our other panelists. So
I'm really grateful that you've made books available to people. I would love it if you actually read the books.
For sure. For sure. I think I will try. It is my first book I want to read over winter break. Hopefully some of my friends want to do the same.
Thank you.
So we'll give another round of applause for Mr. Amar. And thank you again, and we'll start the next panel around 1:05. Our third panel of the day is under the theme of the rule of law and the Constitution. And we have 3 panelists for this panel. First, we have Talia Mariu Williams. Second, we have Jorge Fabra Zamora. And third, we have Brian Tamanaha. To give you some brief introductions and backgrounds on our 3 speakers. First, we have Talia Mariu Williams. Prior to joining the faculty at Northern Illinois University in 2022 and as an assistant professor of law, she worked in the litigation department of law firms, including, my apologies if I butcher this, Cravath, Swain, and Moore in New York City, and Wilmer Hale in Washington, D.C., as well as her own firm in Las Vegas, Nevada. While in New York and D.C., she extensively practiced in the area of securities litigation, antitrust, intellectual property, and real estate litigation. In addition, she has extensive practice in consumer rights, employment law, trust and estates litigation, family law, appellate litigation, and white-collar criminal defense. After growing up in Brooklyn, New York, Professor Williams attended Yale University for her BA in English. She received an MA from Brown University and her JD from Harvard Law. In 2012, she was appointed a judge pro tempore in Justice Court, Clark County, Nevada. Second, we have Jorge Fabra Zamora. Jorge is an associate professor of law at the University of Buffalo. Born and raised in Colombia, he earned an LLB from the Universidad de Cartagena, my apologies, of Colombia, and then an MA and PhD in philosophy from McMaster University, Canada. His academic work has appeared in McGill Law Review, the Canadian Journal of Law and Society, Transnational Legal Theory, and several leading Latin American reviews. Additionally, he serves as the editor of several academic volumes covering topics such as Colombia's innovative peace process with FARC, Jurisprudence, Transformation, and Globalization, and a multi-volume encyclopedia of legal philosophy in Spanish. Jorge's work explores the problems of state liability at the intersection between torts, administrative law, human rights, and political philosophy. Lastly, we have Brian Tamanaha. He is a professor of law at Washington University in St. Louis. He authored 10 books and over 75 articles and book chapters. He has also delivered 8 named lectures internationally, including the Kobe Memorial Lecture in Tokyo and the Julius Stone Address in Sydney. Professor Tamanaha's work has been the subject of 4 published symposia, and his books have been reviewed by notable names such as Harvard Law Review, Cambridge Law Journal, and the Washington Post. Before becoming a professor, he clerked for the Honorable Walter E. Hoffman in the U.S. District Court for Eastern District of Virginia. He was an assistant federal public defender in Hawaii, was an assistant attorney general for Yap State in Micronesia, and was legal counsel at the 1990 Micronesia Constitutional Convention. Professor Tamanaha earned his doctorate of judicial science with a focus on legal theory at Harvard Law School. My apologies for butchering some of those names and introductions. But for this panel, we will start with Talia, and then we will go to Brian, and then we will go to Jorge. So thank you, everyone.
Thank you.
Good afternoon, everyone. Thank you so much for having me. That was such a lovely introduction. Thank you. And it's so nice to be here, even though it's snowing. I do not own a pair of boots. I just got a coat before I came here, which I'm wearing, very proud of. Anyway, so my talk is more highfalutin than it really is. I just like the way it sounds. You know, those graduate courses that you take, and it's like, sola scriptura, the magisterium, two contrasting views of constitutional hermeneutics. I hope that you'll see that it's actually more modest than that. So my assistant helped me with my presentation and threw in this horrible picture of me. I know it's his joke. Some of these things I haven't even looked at. But I am a judge, and that kind of informs my talk because I have to talk to the public often about issues, people who don't have the benefit of a law degree or constitutional interpretation or hermeneutic. And one of the things that inspires me as I am a professor now is what can non-lawyers teach lawyers about ourselves? What kind of mirror can we get from people who don't know the law? I'm very interested in that. I'm also interested in how we can change as a result of that, and vice versa. So with respect to the Constitution, I'm no scholar like these people have been up here, so I feel a little sheepish about that. But I think I have an important thing to say here, because I've been really moved by the recent debates that have been really quite strong in the media and among people regarding the Constitution and interpretation. And my modest goal is that I hope that by exploring an analog of the Constitution as a biblical text, as scripture, might be an interesting and fun and useful way of looking at it that might take it out of that. A less modest goal is that I'm hoping to persuade people, especially non-lawyers, that the law is not just politics by other means, and that constitutional interpretation is just a mere pretense. I see the Constitution as sacred, and I'm hoping that a different way of looking at it might stabilize and legitimize the way people look at the court. So the Constitution, first off, what I think is really interesting, a good place to start would be just how similar the Constitution is to the Bible. First of all, people talk about it in very, very holy kind of ways. It's seen as sacred. One of my colleagues at Northern Illinois University, Lori Updike Toller, has been fortunate enough to discover some document by James Wilson. There's still some debate with terms of authenticity, and she talks about it as a sacred thing. Like, I found this piece of scripture, and the other researchers in the room also had a hush kind of come over them. It was reported in the paper, and the hairs on their arm kind of stood up. I mean, there's no question that there's a kind of biblical or scriptural way that we talk about the Constitution in terms of its primacy, in terms of its, even in a sense, its holiness in this original sense of being different. There's something different about it. And we also have a similarity with respect to just the fact that there were people before there was a Constitution. That's very similar to the Bible. The Bible, there was already a church before there was a document that was purporting to govern the church. Now, Professor Amar would say there was no country. He just said that. There was no country. But there was enough to have we the people, and we the people are who ratified that document and then had themselves governed by it. Similar to the Bible, the Constitution is not self-executing in the sense, or doesn't have all the meaning there. It's susceptible to ambiguity, to confusion. It needs interpretation, as does the Bible. So there's already a lot of similarities there, and that makes it a natural fit. Now, another thing that might be different, we should look at in terms of the doctrines with the Bible and with the Constitution, though we don't really have a Constitution there right there, but that's okay. We have the notion of stare decisis, of course. We've talked about that today. With the Bible, we also have, with respect to the magisterium, or the official teaching tradition of the church, at least the entire Christian church, until about the 16th century, infallibility as a doctrine, which also kind of has a stability. So there's this, again, this kind of parallel in the way that when someone says something, when it's been officially vetted and stated, that is the law and that's the truth. That's what it is. And for 1500 years, that worked pretty easily. You could say they did have an originalist perception, the magisterium, composed of clergy, doctors of the church, monks, scholars, who did intend to find out, what did the apostles mean when they wrote this particular scripture? What did St. Paul mean? What did Peter mean? What does God mean? And looking to tradition and authority to state that and to say definitively for it, and then have individuals have it applied to their lives. Biblical hermeneutics are pretty similar to what people who've studied constitutional hermeneutics would probably imagine. There are tools of interpretation, so historical context, the text, the larger text or the context, the study of culture, moral reasoning, genre. For example, Psalms are different than Proverbs, which are different than epistles, which may be different than historical books, which is different than the Gospels. Looking at pragmatism, structuralism, translation, and other items. Hearing that, probably anyone who studied constitutional interpretation would see a lot of parallels there. And certainly they're quite strong parallels. All right. But then along comes Martin Luther and kind of disturbs the whole thing. So Martin Luther, who was a Catholic priest, did take issue with the concept of the magisterium. He insisted there was an absolute right to private judgment. Now, the church had already said there was private judgment, but it didn't trump the public original meaning of the Bible as described by the scribes, by those who were in the magisterium. He said, though, no, this is almost like the beginning of, in the church, a living constitution. We have to change with the times. There's not just a fixed, determinate meaning of what all of these words of scripture mean that are so important to our lives. We have to have some role in saying what they are, and they may change. And it's not just, the people in charge who get to do that. So sola scriptura became a rallying cry. Sola scriptura is the Latin for scripture alone or the Bible alone. Some people would say it would also mean that you didn't need the church at all, just you, the believer, and the Bible. But I think it was probably more, or at least as much, a textual argument that the scripture alone not appeals to authority, to tradition, to the Didache, which was a book that the apostles had written, which were not scripture, but were persuasive in terms of understanding what scripture is. It was written at around the time of the first century. That's not important. It's what each person brings to it. Is that hermeneutics where you bring your own understanding, and that is what you do. So you already see a kind of originalism being supplanted by a kind of radical living constitution with Luther. And I'm certain people some of this is probably known if you've been around people from evangelical faiths and, me and the Lord, my personal relationship with Jesus Christ. You can say some of that, at least that kind of expression of it, certainly that it existed already in Catholic theology as well, but had its full expression with the idea of sola scriptura. It's me. I have the freedom with the sensitivity of the Holy Spirit to interpret for myself. So there's a sensitivity to the times and a sensitivity to the idea of there's a spirit, a good faith, if you will, of understanding, and that is an appropriate way to interpret the document, in this case, the Bible. Well, and we can skip past that. Oh yeah, he got excommunicated. That didn't work out. It wasn't just because it wasn't just because of sola scriptura, although that was a large part of it. He also advocated other kinds of things. He was definitely a rabble-rouser. He also advocated something very interestingly, solo fide, meaning faith alone, in which he proposed that you didn't have to have good works as a Christian. You didn't have to do anything good and do good things. Just having faith was enough to provide for your holiness and salvation. The church did not agree with that. However, it was an interesting moment because it is the first real split in Christendom, I would argue. There had been one in the 12th century with the Orthodox Church, but it really wasn't as much of a split as this one was. This was an actual schism, and it continues. There are these two different sects, and they're quite different. Sola Scriptura and the Magisterium. Well, let's take a step back and look at the Supreme Court here. I think this is an important moment here to look at because we do have really, as one scholar calls it, a ceremonial deism with the Supreme Court. And it is, I mean, look at that, right? I mean, it's kind of godlike. It looks like a temple. It looks like it's a holy place. Marbury versus Madison, taking very much a living constitution aspect in Marbury, saying, doesn't matter what the script says, we are the authority, we are the priests here, we decide what the law is, we have the right to say that. And there is a kind of pre-Protestant magisterium authority that the Supreme Court exercises in deciding what the law is. And of course, with the grandeur and the pomp and circumstance, all of which I really do like, does have that kind of sense that, again, something that Luther would have railed against. And also importantly, it's transcendent. I think that's really important because these could be very fun, just fun questions, but they're serious ones because just like in a spiritual sense, you have metaphysical things that become real. So you have metaphysical ideas of faith or holiness becoming real through baptism or the Eucharist. Here you have metaphysical ideas about, say, one's rights or liberty, or the right to, have control over one's body or one's mind, or to go to a certain school, becoming real or not real as a result of the Supreme Court's pronouncements. So kind of metaphysical becoming real through injunctive or declaratory relief. But interestingly, we have courts that do struggle, interestingly, between kind of the magisterium and the idea of sola scriptura, the idea of the Holy Spirit kind of guiding them as opposed to looking for the original meaning. Chief Justice John Marshall said in McCulloch at least a dozen times, he refers to the spirit of the Constitution. It's not necessarily something in the text or something from the original understanding, but the spirit helps him to understand it. Chief Justice Stone, in a case called U.S. v. Classic from 1941, talks about the revelation of the purpose of the Constitution. The revelation, I mean, that's religious language in the continuing instrument of government. Now, I think dealing with that, Justice Frankfurter, recognizing perhaps that tension, says something very interesting in a case called Board of Education Barnett. He says, but as judges, we are neither Jew nor Gentile, neither Catholic nor agnostic. So there's obviously an acknowledgement that these two spheres could lead to division and a kind of spiritual or civic spiritual partisanship that might be problematic. I think it's more, I kind of skip past that. I think it's more, well, I didn't have the pretty picture that Noah Chauvin had, would it actually be, I wish I had that, gosh, I wish I thought of that. But, at this stage, it does seem that these are a lot of distinctions without meanings. Because, for example, when Justice Kagan was being confirmed, she said, we're all originalists. And I don't think she was being sarcastic or sardonic or cynical there. I think she means it. Originalism, trying to find out what the true text means, is absolutely on the minds of both liberal and conservative justices. I clerked for the Ninth Circuit Court of Appeals, the Ninth Circus is called sometimes. And I clerked for a very conservative judge, Judge Bybee, but we sat with very liberal judges, Judge Reinhardt, for example, and everyone in between, and some more right-wing probably than people would call Judge Bybee. I was really taken by how much everyone seemed really intent on getting it right. It didn't seem to be coming from a position of just rank politicking. It did seem to be coming from, yeah, we're all originalists. But then there's so much confusion with that term. And even aside from the sarcastic law office originalism that people allege against those, perhaps not in goodwill. For example, our friend Justice Roberts Ball and Strikes, who is a purported originalist, perhaps rightly, chose to uphold the Affordable Care Act, saying he's looking to the intent, but there's not very much in the opinion that does seem to invoke colonial intent on insurance exchanges. And Scalia certainly was not impressed and says, no, you're rewriting the law under the pretense of interpreting it. And perhaps that's the point. It's not just about holding on to just one way of doing things. We see that with Gorsuch as well, with the Title VII case, where though he's a textualist, apparently says that sexual discrimination does apply to those of
or homosexual, transgender, although it's not probably a purely textualist argument. As Alito says, this is more of one of humanity and generosity, though he was dissenting. And even Scalia, the great textualist, couldn't be held to that because though he says it's the text and only the text and nothing but the text, the fact is he talked always that context is everything. Well, if context is everything, then it can't be the text. And then he talks about the atmosphere of original text, the atmosphere of original text. Okay, I'm going to wrap it up. All right, so we'll go straight to the end. So I propose more of an ecumenism, okay? Ecumenism. We should reach across, I think, I'm most disturbed, I promise I'll make this really quick. I'm most disturbed by, so I come from a family that was, who lived in Jim Crow, I'm the descendant of slaves. And I'm really taken by Frederick Douglass's speech, What to the Slave is the 4th of July. And he calls the Constitution that glorious document of liberty, even when the Constitution did not care about him, or so it would seem. So just like the Bible might seem to support all kinds of horrible abuses, people of faith don't think that the Bible itself is evil. And I'm trying to say that as well. It bothers me when I hear someone like Elie Mystal, whom I respect. He runs Above the Law. You probably know him. He's a Black lawyer who, anyway, he's on Amazon. He has a lot of books being sold. But he says, our Constitution is not good. It's not etched by divine flame upon stone tablets. It's actually trash. It was written by actual monsters. Why would I care about the original public meaning of the words written by these men? Well, I'm hoping that we believe that there is something there to be seen. As Pelikan said, tradition is the living faith of the dead, but traditionalism is the dead faith of the living. That there's a way for us to look at tradition and originalism and scripture and reconcile these two ways of looking at things so that we still see the Constitution in a holy light. Okay, I'm off.
Brian, you can start when you're ready.
Okay, thank you, everyone. And thank you for inviting me to speak at this conference. I'm sorry I can't be there. I had obligations for teaching here. That was a really interesting talk, by the way, and in some ways I'm going to provide a contrast, hopefully a useful contrast, because I agree with you that we tend to view the Constitution in reverential terms, and I'm going to try to desacralize it if I can. So I've combined, I'm going to amend the talk. It was supposed to be the rule of law and constitutionalism, but I'm going to add these words, rule of law and constitutionalism, yes and no. So the point of my talk is going to be about how in certain respects, constitutionalism manifests the rule of law, and then in other respects, it clearly does not. So there's lots of discussions about the rule of law and what it means, and to cut through all of the theoretical disagreement, I'm going to focus on three themes that are common to most discussions of the rule of law. The first theme is government is limited by law. The second theme is that law consists of general public rules stated in advance, which are certain, stable, applied equally to everyone according to their terms. This is also called formal legality by legal theorists. The third theme is this old saying, the rule of law, not man, which requires that laws be interpreted and applied by government officials, including judges, shorn of influence from their political characteristics, including biases, preferences, and political views. Okay, what I'm going to discuss is that constitutionalism is a robust example of the rule of law in the first sense, a partial example in the second sense, and contrary to the rule of law in the third sense. So in the first sense, interestingly enough, constitutionalism itself is defined by many as the rule of law. So let me give you an example. The Stanford Encyclopedia of Philosophy defines constitutionalism, defining it begins with this statement: constitutionalism is the idea, often associated with the political theories of John Locke and the founders of the American Republic, that government can and should be legally limited in its powers, and that its authority or legitimacy depends on observing these limits. Keith Whittington defines also an entry on constitutionalism, says constitutionalism is the constraining of government in order to better effectuate the fundamental principles of the political regime. any discussion of constitutionalism and the rule of law has to go back to A.V. Dicey. His book, Introduction to the Study of the Law of Constitutions, first published in 1885 and then many subsequent editions, defined the rule of law, or identified in terms of three aspects: that the government could not punish people through discretionary actions, but only in ordinary court on the basis of published laws. That two, that everyone, rich, poor, government official, citizen, is subject to ordinary law. That is, no man is above the law, and that the law is applied equally to all. And then the third is that the rights of the people do not depend on general declarations, but are derived from judicial decisions in private cases before regular courts. Significantly, in this book, he depicts the rule of law as what he calls a constitutional principle, alongside the principle of parliamentary sovereignty. And then in addition, he identifies an essential third element, which I will discuss later in my talk, and that is the existence of conventions of the Constitution. These are unwritten. They include customs, practices, maxims, precepts, and shared understandings, which comprise a code of political or constitutional morality guiding public officials that maintain how the rule of law and parliamentary sovereignty and the law of the Constitution work collectively and how officials properly operate in practice. Okay, so from Dicey we have inherited this idea of constitutional principle. What's interesting about it is it's not entirely clear what that means. The UK Constitutional Reform Act of 2005 states, explicitly recognizes, and this is a quote, the existing constitutional principle of the rule of law, although it doesn't articulate what that means. The Supreme Court has mentioned many times in opinions over the years, beginning with Justice Marshall in Marbury versus Madison, who proclaimed that the government of the United States has emphatically been termed a government of laws and not men, but also in the most recent Dobbs decision, where the majority proclaimed, quote, that is what the Constitution and the rule of law demand, when it struck Roe versus Wade. And the dissent countered, the majority, quote, the majority thereby substitutes a rule by judges for the rule of law. So although there are many references to this, it's unclear what weight, or exactly what rule of law as a constitutional principle is, what weight it carries, and the different aspects of the rule of law incited in these decisions. As we cut through this, I will say that the rule of law, the constitutionalism, the Constitution in particular, is undeniably an example of the rule of law in this respect. The Constitution specifies basic powers, structures, duties, limitations on government, how government officials are to be selected, how states are admitted to the Union, and the obligations of states, the respective powers of the state and federal government, how the Constitution obtains legal effects, and then the relations between government and citizens. So all of this is set forth legally, and in that sense, I think it's an undeniable example of the rule of law in the first sense. Now, let me shift quickly to the second sense. Constitution is a matter of formal legality. And as I said at the outset, this is only partially true. And the reason it's not fully true is because, for the plain reason that many constitutional provisions are not clear rules. I quote Post and Siegel on their essay on constitutionalism, which says, quote, often constitutional provisions are elliptical and incomplete and filled with grand abstractions. In fact, some of the most fundamental doctrines, for example, the Commerce Clause, is itself open to enormous interpretation and has changed over the last 200 years in ways that are unpredictable and actually apparently turn in very clear instances on the views of the justice that decide what the limitations of the Commerce Clause are. And that brings me to the third topic, which is, this is the one I want to spend the most time on, and that is rule of, and the old quote is rule of law, not man, but I want to reframe that to be the rule of people, not law. So Thomas Hobbes, centuries ago, 3.5 centuries ago, was actually skeptical of the rule of law for a number of different reasons, one of which is the sovereign is the source of law, so the sovereign can't be bound by the law. But another reason he was skeptical is because, and this is a quote, all laws, written and unwritten, have need of interpretation. He also argued that since words are ambiguous, laws inevitably are indeterminate. Here's another quote. The written laws, if they be short, are easily misinterpreted from the diverse significations of a word, or two, or if they're long, they be more obscure by the diverse significations of many words. The political theorist Jean Hampton describes, I'm going to quote her description of Hobbes's point, a rule is inherently powerless. It only takes on life if it is interpreted, applied, and enforced by individuals. That set of human beings that has final say over what the rules are, how they should be applied, and how they should be enforced has ultimate control over what these rules actually are. So human beings control the rules and not vice versa. Okay, so I want to continue now and talk about the US political culture, which itself provides very clear indications of a lack of belief in the idea of the rule of law or not man. And that specifically began this initiative, and now I'm talking about the contemporary US political culture, during the early 1980s with the Reagan administration, and has intensified over time, and that is a specific campaign to stacking the courts based on ideological grounds. This was stated by Attorney General Ed Meese, who managed Reagan's judicial appointments. Meese admitted that his intention was to, and this is a quote from Meese, to institutionalize the Reagan Revolution so that it can't be set aside no matter what happens in future presidential elections. This statement was recently echoed by Republican Senate Majority Leader Mitch McConnell during the Trump administration when he stated, quote, I think lifetime appointments, not only to the Supreme Court, but to the circuit courts, are the way you have the longest lasting impact on the country. Now, the strategy for accomplishing this is straightforward. It consists of just two parts. One is to obstruct the appointees of the other party, the other president from the other party, combined with expediently confirming appointments of your own president and your own party. And then the second strategy has to do with the kinds of judges that you appoint, is careful ideological vetting, and pick young people who can sit for decades. And as I said, this was set out by Ed Meese in the 1980s, so it's not, there's nothing secretive about this. The most recent example of this occurred when McConnell refused to conduct a confirmation hearing for Merrick Garland with more than 7 months to go until the election, on the grounds that people should have a say in who becomes the next justice. And then conversely, he confirmed Justice Amy Coney Barrett only 8 days before the 2020 election. So these actions presuppose, it's the very nature of these actions, that they presuppose and expect, and desire that judges will decide cases that reflect their own ideological views. Now, these are not just the actions of our political culture. In fact, polls show that Americans understand quite well and have begun to perceive judicial appointments in this way. A recent, and now I mean just a month ago or 2 months ago, poll by the Pew Research Center found sharp divides in attitudes toward the Supreme Court that line up with their own political views. For example, 67% of Democrats and leaners say the court has a conservative tilt, and 70% say the judges are doing only a fair or poor job of keeping their decisions free of political views. Only 6% of Democratic leaners said justices were doing a good or excellent job of keeping their personal views out of their decisions. Interestingly, even Republicans understood that judges' political views were affecting their decisions. So 33% of Republican leaners found that judges were doing a good or excellent job of keeping politics out of their views. Now, I want to emphasize that these are not new opinions. It seems we might, in the moment, it feels like that. But there's a poll going back to 2005 by Maxwell that found, and now I'm going to quote the findings of the poll, 82% of American public thought that the partisan background of judges influenced court decisions, either some or a lot. This political perception was widely held. The poll found that an overwhelming majority of liberals, 88%, conservatives, 83%, people who attend religious services several times a week, 84%, and people who never attend religious services, 88%, all agreed that partisanship did not switch off when judicial robes were put on. Now, importantly, studies have also been done of judicial decision-making. And a really significant study was conducted by Judge Richard Posner that he published in his book, How Judges Decide. Judge Posner had a study done that examined all federal judicial votes from 1920 to 2002. That's one study. I'll give you the results. And then he compared in the same pool of judicial decisions that was only for currently existing judges. So those were judges that have roughly been since the Reagan appointments up until 2002. They evaluate the ideology of the judge, and then they evaluate the ideological orientation of the decision. Now, there's lots of questions about this, but on a whole, this is how judicial politics studies are done. And this is the important thing. What he found is that in the first group of judges from 1925 to 2002, so that's the larger pool that included judges before ideological vetting occurred in earnest, judges appointed by Democratic presidents, confirmed by Democratic senates, voted conservative at a rate of roughly 50% of the time. Judges appointed by Republican presidents, confirmed by Republican senates, voted conservative roughly 56% of the time. So it's not a significant difference between them. It's roughly 6%. However, the votes of currently sitting judges, that is as of 2002, this had changed. His poll found that the votes of Democratic appointed judges were roughly the same in the conservative direction. That's 50% of the time. But the votes of Republican appointed judges had increased to 67% of the time. So the gap between these two groups had increased from 66% to 17%. And as Posner commented, the difference in votes had become more pronounced, quote, consistent with the strong Republican push beginning with Reagan to tilt the ideological balance of the courts rightward. I'll add as a postscript to this that a recent study was conducted that, now these are about voting decisions and appointees, that found, and here's a quote, Trump has appointed judges who exhibit a distinct decision-making pattern that is, on a whole, significantly more conservative than previous presidents. Overall, his judges are more to the right than those of any recent Republican president, not to mention Democrats. Now I'm going to jump quickly ahead to talk about, well, so what did judges themselves say about the influence of personal views? In the opinions themselves, judges will say, of course, this is determined by the law, and that's what they're expected to say. But judges have also written very reflective accounts of the nature of judging. One of the most famous was by Judge Benjamin Cardozo in his celebrated book, The Nature of the Judicial Process, written in 1921. And he stated frankly, and here's a quote, obscurity of statute or precedent or of customs or of morals or collision between some or all of them may leave the law unsettled and cast a duty upon the courts to declare it retroactively in the exercise of a power, frankly, legislative in function. Cardozo also observed, quote, no effort or revolution of mind will overthrow utterly and at all times the empire of these subconscious loyalties. Statements to this effect have been repeated by many judges over the past 100 years. I'll give another one who was on the same
Brian.
court. Oh, yes.
Brian, oh, sorry, 15 minutes have passed, so wrap it up in the next minute or two.
I will get to the end then, but just take my word
Thank
for
you.
it. I cite another 67 judges saying exactly the same thing. The point is, judges themselves know that they make choices and that their personal views affect their decision-making in instances of cases where the law is unsettled. The bottom line for me is that the quest for rule of law, not man, is chimerical in the context of constitutional decision-making. Nonetheless, it's not hopeless, and I want to now agree with something important that was just said before me, and that is, in my view, there's two crucial constraints that are important. And the first constraint is to strive to rule in accordance with and to come to the strongest, most legally justified outcome. And I believe that is the orientation of most judges. The second point that I think is critical is that we must comply with the unwritten constitutional conventions. And these conventions are what we have been breaching in recent decades. Mitch McConnell's hardball on appointment of Supreme Court justice was a major breach in constitutional conventions. This consistent pattern of obstructing opponents is another major breach. And another major breach is appointing people to the bench who are manifestly unqualified. And what I mean by that is appointing 35-year-old appointees who have had no trial experience to the federal bench. And that's just one example. I will end with that.
All right, thank you, Brian. Jorge, you may begin when you are ready.
Hello, everybody. Hello.
There we
Sorry
go.
about
There
that.
we go.
Yeah, no, I want to thank you for the generous invitation. I'm really happy. I'm honored to be with this distinguished company. I want to thank the organizers for inviting me to participate. When things go smoothly, there is often a lot of hard work involved. So I appreciate Austin, Professor Fried, and all the people involved in organizing this wonderful conference. And my apologies for not being able to be there. Like Professor Tamanaha, I had teaching commitments. But my topic is about constitutionalism beyond the state, and I would like to begin right away. So this is part of a larger project, which is an attempt that I have been trying to do to create a theory of law inside and beyond the state, something similar like what Professor Tamanaha has intended in his own work. So in this work, so for the purpose of this paper, this is what motivates me. So when we talk about constitutionalism, we talk about constitutionalism in the context of the state, including sub-state constitutionalisms, provinces, states, and so on. But when we think about constitution, we think about the constitution of a nation state. However, there is a lot of important literature suggesting that the idea of constitutions or the idea of constitutionalism has application beyond the state in transnational, supranational, and perhaps global contexts. While the idea is often accompanied with a substantial theoretical support, there is an important intuition that I think is worthy to explore. For some people have suggested that a Copernican revolution have occurred. While state constitutionalism is seen as the central of the global universe, so some people have suggested that actually are the transnational constitutions that should play this role or maybe are in this role. And we have these sorts of arguments. So my role here, the role of this paper is to provide a taxonomy in which we can start to think about these questions better and to start to, more importantly, to clarify what they mean by constitution. So my paper have only 6 slides. So the first one is about some theoretical building blocks. What do we mean by constitutionalism? And I'm going to distinguish between 3 different senses, and I hope they have the time to do so. Some constitutionalism is about some alleged constitutional rules. Other sense is the constitutionalization of transnational normative orders. And a third sense is the idea of a global constitution. Each of these 3 senses, and this is the summary of the paper, they mean very different things when they have constitution in mind. So the first part of my paper is a theory of non-state legal phenomena. I'm just going to briefly mention it here because this is in the published version. This is a backdrop of what comes later. So the central idea is a theory about norms, an idea about normative orders, and I pretty much depart from other theories in analytical jurisprudence. But I would like to distinguish between norms and norms that are norms, and I think about norms in collectives of norms that I'm going to call normative orders, and grammars, which are non-normative components. The idea of grammar, I take it from Hubert Schweitzer, who says that we have to distinguish between, for example, chess, which is a set of norms about a game, and the grammar of chess, which has the non-normative component that make chess. So, for example, the grammar of chess is victory, but we can imagine a different kind of chess as a religious rite. So they could have the same norms, but they could have these different grammars, which are values, aspirations that make certain practice intelligible. So with this backdrop, so that's piece number 1. And piece number 2 are the idea of constitutionalism. Constitutionalism is using 3 different senses. In a weak sense, which is the sense that most people use it in analytical jurisprudence, is a constitution is the basic rule of a legal system, of any legal system. And that's the simplest sense of legal system, of constitutionalism, sorry. And in this sense, every legal system is going to have a constitution. In a formal sense, some people think that constitution exists only if you have a written document and concerns the application of that written document. And a third robust sense is a grammatical sense. So is that constitutionalism is a grammar of liberal principles that include separation of power, respect for human rights, judicial review, democracy, and these three senses are used in the literature of transnational constitutionalism differently for different purposes. So, and now my account of the three big branches of constitutionalism. So the first one, this is the taxonomy. The first category are so-called intercommunal constitutional rules. This is a label I created, and it's based in a different line of my work, in which there is the possibility that there are some norms that exist from the convergence of different practice. So what makes them legal is the fact that different states apply the same rule. So some argument of this kind has been advocated by Jeremy Waldron in Party Laws of My Kind. I have a very different reading from Waldron's readings, but the idea that different norms that the different states come to agree in certain norms, for example, the prohibition of death penalty of minors, make them law, and their existence as law is independent from it creates a new norm that is independent from the domestic norm. So I think that's the key insight. And some people like Ann Peters have further suggested that some of these norms have constitutional nature, and they have. What do they mean by constitutional here is a bit unclear, but we could exemplify them. So, for example, the principle of proportionality, that it is applied, for example, in economic sanctions, it is applied in international law, it is applied in constitutional law, and they think this kind of cross-fertilization of constitutional norms and international norms create constitutional norms of the international community. So this is a first sense of constitutionalism, and it's worth exploring what it means by that, and it has an important application in the use of foreign precedents, for example. But something really different about constitutionalism is what you find, for example, in the work of Nico Krisch, of Gunther Teubner, and what they mean is that non-state normative orders, for example, the WTO, the International Criminal Law, what they believe is that they have gained the grammar of constitutionalism, or the best way to think about those norms is in the terms of principles that are intrinsic to domestic constitutionalism. So for example, we should apply the principles of separation of powers to something like the United Nations, and to consider it in that way. My take here is that in order to, so the paper expands how this notion applies different senses of constitutionalism, and how it's actually the extension of grammatical components of domestic constitutionalism in a non-state context. And the final, and perhaps more perplexing in my view, idea of constitutionalism is the idea of global constitutionalism. The idea of global constitutionalism is very common. It's very unclear what it means there, but some people have made the argument that explicit that that international law is the constitution of the global community, of all citizens of the world. Bardo Fassbender has made the most explicit claim of that argument. In this view, the UN Charter is the organic part of the Constitution, and the international human rights treaties are the Charter of Rights of international law, and we have to take it as that. What does it mean when people claim this way? So, using the tools I have built, I hope to say that this idea of global constitutionalism is the claim seems to be that there is a supra-state, a super constitution that regulates not only states, but also international organizations, not state actors, transnational legal order, and private citizens, and that this inescapable constitutional order have a role in regulated in all the subglobal, including nation states. So, but there are two claims here, as I see it. So first, this claim presupposes that there is a global legal order, meaning a constitution in the formal sense, but also that global legal order has to embody the norms and grammars of domestic constitutionalism, or to some extent. The paper will argue at greater length that one can be recognized, we can identify a rather weak sense that there is some kind of global legal order given the structure of provided in the first section. But secondly, the idea that there is a global legal system embodying some constitutional principles or embodying the grammar is dubious, and we should be careful. So this second claim is not warranted, and there is no empirical evidence that we can support the claim that these global principles have reached a level. So in the interest of time and to keep my talk on time, so I have a general conclusion. What do we mean when we talk about constitutionalism beyond the state? Three things are meant. On the one hand, the emergence of intercommunal constitutional rules, such as the principle of proportionality. Second, the idea that certain transnational legal orders, like the WTO or NAFTA, embody constitutional principles. And third, the suggestion, the intimation that there is a global constitution. And these discourses are very different, and they conflate different senses of weak, formal, and robust constitutionalism. And we should be wary of some of these claims because we don't have sufficient evidence to support it. So that is pretty much what I have the summary of my paper, and I appreciate your questions and comments. You can find my email here. Thank you so much.
All right, thank you to our three panelists, another very informative panel, and I hope we have some questions ready. I know Dr. Reed has questions ready.
I have questions for each of the panelists.
Yes.
That's true.
Go ahead, you may kick us off.
I'll begin with Professor Williams, and actually I have two questions. The first is, when I look at, I'm going to teach constitutional law for the first time this spring. And when I read cases, I'm realizing there's a kind of conversation going on. I understand the sola scriptura argument, and I understand the magisterial argument. Those are two traditional poles that we can see debate occurring within. But I'm going to add another element to this too, and that is, perhaps I'll characterize this as the rabbinic element, because a Supreme Court case law is both conversational and disputatious, which I take to be characteristics of rabbinic thought. They're conversations occurring over 200 years, and they're disputatious. Sometimes they're quite fierce and not necessarily capable of resolution, perhaps even inconsistent with one another. But I see that as an element here also. But then let me also ask, this is perhaps this is a very different question. When I see sola scriptura, and I see, and I'll pose this to Professor Paulson also, when I see sola scriptura, I see textualism emerging as a form of constitutional interpretation. I wonder, to what extent is textualism simply an outgrowth of a sola scriptura means of interpreting the Constitution? So those are my questions to you. Professor Tamanaha, thank you again for your presentation. I'm going to focus on the last of your three elements here, and that is the constitutionalism as the rule of persons, not law. And the ideological point is well taken. But I also wonder if you want to develop more the personalist dimension of this. You mentioned Gene Hampton. I might mention John Noonan also in this. John Noonan made the point over and over again in Persons and Masks of the Law and other sources that the rules are inert, that persons empower rules, and how then do we tell the difference between an abusive application of the rules and a good faith interpretation application? And he looks to basically number one, a sense of goodwill, and then number two, a sense of respect for the lawgivers as persons themselves. We respect the Constitution makers because they are persons with as much entitlement to respect as anyone living today. A community of respect for both the living and the dead. So those are my observations, Professor Tamanaha. And Professor Zamora, Fabra Zamora, thank you for your presentation. I've written several, I don't know whether they're chapters or perhaps prospective law journal articles dealing with the emergence of transnational norms from a jurisprudential standpoint. And I look at this from the standpoint of the emergence of war crimes from the 1940s up to the early 2000s, looking at the war crimes tribunals established after World War II, then after Rwanda, the former Yugoslavia. And I see in this the emergence of a kind of global constitutionalism. And then I look at what has happened in the last 5 years, 6 years, and this is why I've not published anything here. And I see the emergence of non-liberal states. I mean, we can just reference most immediately the 20th Party Congress of the People's Congress in China, which reinvigorated a kind of Marxist interpretation of Marxist worldview. We see the emergence of a kind of malignant nationalism in Russia. We see nationalism and traditionalism emerging in other states. And I wonder to what extent the liberal principles that you assert a global constitution depends upon, to what extent are they actually quite fragile at this moment? Well, those are my questions to the three of you. Thank you.
Okay,
Professor Williams.
Thank you. Thank you so much, Professor Reed. That was very, very helpful. It's wonderful when questions actually help you think more. It's like, whoa, I got all these things to write down. I think that the issue of the rabbinical element is a really interesting one, because I was just starting to look into something called midrash, which is a kind of Talmudic interpretation that I think, from what I've been able to gather, have just started on this. Starts very broad and then goes very narrowly, but it doesn't try to resolve, as you said, and find just one singular truth, as I think biblical scholarship would, or as I think constitutional interpretation tends to want to do. But I struggle with it because I think about Dworkin. I saw this interesting speech of his, and he thought that was extremely cowardly on our parts to have this, he thought, relativistic kind of, well, there's no truth, come on, that sounds crazy. He says to him, it would be like if you were a judge, ruling on someone's life and saying, well, I could be wrong. This is my interpretation of what the law has me do. And so I think about that, and I think that's the reason, but I think I should be more comfortable with the idea that maybe this is a conversation and disputatious. And one way I think that could be resolved, I have a background in theater and literature. I have a master's in theater literature, and literature doesn't try to come with just one settled meaning. Moby Dick, yeah, it's about a whale. It could be a cetological study, or it could be about, man's hubris, or it could be about, relationships. Phyllis Wheatley wrote this really beautiful poem in which she talks about the diabolic dye. Well, dye could be her color, being seen as black, diabolic color, or the diabolical dye, as a game of dice, like chance, that made her come into these bad situations. And it would be really kind of absurd to say, well, which is the right answer? Which one is it? Well, sometimes poets mean both and at the same time. So thank you for that. I will be looking at that. Also, I want to hear about Professor Paulson. I'm not sure which one is Professor Paulson. Okay, yes. You know what? Because I had a crisis when I was preparing my talk, because I said, at first, because I was influenced by the media and all the pundits that, okay, well, a textualist is an originalist. But as I went through it, I'm thinking, no, I think a textualist is sola scriptura, a sola scripturist. They're forging out on their own. Perhaps and we put it in, we collapse it with originalism, the conservative side, so to speak. But is it? And it seems with particular justices kind of finding a refuge in textualism, they do seem to go away from just the party line, referencing Professor Tamanaha. Because if you think about it, Gorsuch kind of broke with tradition, or broke with the ranks to make that decision with the Title VII case. Justice Roberts certainly did with the Affordable Act, and he claims to have used textualism. And I think there may have been other instances. It might be interesting to check that, but I'd love to hear. Maybe Professor Paulson would be, I don't know, want to take away from my...
We'll be talking in the next panel.
Oh, okay, all right. Fair enough.
So Yes, thank you. Thank you for your question. I think Judge Noonan was right. So in the end, and this I think is ultimately, law is just words on paper, and ultimately it has to be filled in, and often filled in by values. I need to, condition what I was saying a little bit. So I'm talking about uncertainties existing at the highest level. There's lots of very clear laws. People apply them. All the judges apply them, whatever their political views are. It just so happens that constitutional issues, and in the Supreme Court in particular, are precisely those situations of high salience where there's disagreement. So the expression of background views comes through in that particular subset of cases more than any other context. Now, let me just add a couple of reasons why I think this is inevitable to law. In other words, it cannot be eliminated, and it's healthy for us as a polity to understand that. One reason is because of the generality of law. Law is just general rules written in advance, and those general rules don't anticipate all situations. They apply in ways that people didn't really understand or expect. And we see a good example of this in the Constitution. The Constitution was written 200 years ago under wholly different socioeconomic and political circumstances. The other reason this is irreducible is the tension between law and justice. This is an eternal tension, right? There's what laws require, and then there's a sense of justice, and you can identify whether it comes from natural law or a community sense of justice or any other source. And it's when that tension occurs that judges feel torn by two different norms or requirements within law, right? The identification of following the law, and then the identification of law with justice. And that is another tension that I think can never be eliminated. It's in the nature of how law and morality relate to one another. And then the last factor is changing social, political, economic situations over time. And that's why these problems are exacerbated the longer a particular set of laws entrenched. So yes, I believe law must be filled in by human judgment, but this is precisely where the people matter. And in response to Judge Williams, there are various theories of constitutional interpretation. So originalism is one, textualism is another. They do not always line up together, but now we're seeing the history and tradition of the society. And then we have Breyer's pragmatism, balancing. We have Dworkin's rights theories. The thing is that there's no one theory that answers every situation, and no one judge applies the same theory consistently. So Scalia admitted that he was a faint-hearted originalist. And that's precisely the problem. And I'm not blaming him. I'm saying this is the dilemma. And it's precisely because of that, and now I'll just end, that it does matter who is appointed to these positions. And not only does it matter, we all know it matters. And I think it's important for us to recognize that and try to contain our temptation to overly politicize what is a position that ultimately will involve political influences. And that is the danger I feel that we have gotten into in recent years. That if you hone in on that and then maximize every opportunity to do that on the side of your team. And by the way, I should mention the Democratic senators and presidents are doing exactly the same thing on the other side. Then we have, I think, a general loss of faith in how this whole thing operates in some recognizably legal way. And by that, I mean more than just citing legal justifications. Everyone can do that. I mean by recognizing that law, by and large, is determining it, even if we at times have to go beyond that.
So thank you so much, Professor Reed, for your really, really interesting question. And it allows me the opportunity to rehearse a bit better what I'm trying to do. I'm not trying to say that there are global constitutional norms. What I'm trying is to clarify the taxonomy of what is discussed there in the literature. And what you find there is precisely the problem you have identified. There is a lot of people saying that this norm exists or this norm, but what you see there is a confusion between agenda and legality. So this is my agenda. This is what I would like the world to be. And as a result, there is this global legal system, there's this global legal right. And what I try to do in my paper is to provide an apparatus that allows us to distinguish between agenda and reality, or perhaps between legal fact and legal fiction. And so I agree with your claim, and that's partly what I'm doing. Because I have the dictatorial use of the microphone, I would like to have, I have two questions, one from each of the other speakers. Can I do now?
You have questions for me?
Yeah, for the two speakers.
For the panel, yes, please
For
go
the
ahead.
panel.
Go ahead.
Okay, so one is to George Williams. I mean, the idea of equanimity, this is a very good project, but how does it work? There is something, I mean, it's good to say, I can have a bit of here, a bit of there, but sometimes the two theories of interpretation are competing. It's like, it is not A, it's B. And I mean, and to say it's like, I take a bit of this and a bit of that doesn't, I don't know how much does it help us. And to Professor Tamanaha, you mentioned constitutional conventions. And my question is about the role of constitutional conventions in presidential systems. So when Dicey was talking about constitutional conventions, he had something as an unwritten constitution in mind, like the UK, and those are kind of weird in the way you execute them. And secondly, when you have constitutional conventions, you might have like a different variation of the same problem, an iteration of the same problem. It's not about who interprets the text. Now it's who interprets the convention. And because they are based on honors or this abstract feeling, I mean, the problem even increases. So I don't see how can they be a solution unless there is something else that I'm missing.
I'll go first. I don't know if it can be heard. That's a great question, and you caught me. Yes, it's true. I mean, it's a bit pie in the sky, but I think it's still an important enterprise, this ecumenism, the same way I think it was for John Paul II. And I think a good example of it, first off, yes, is definitely going to be some kind of a pastiche. I think, though, that judges do that. I think that's something we should acknowledge that happens and maybe encourage judges to feel good about that. I take to heart what Professor Tamanaha says too. Honestly, you are bringing a lot of your own values to judging, and I'm very conscious of that. You try to put that aside, but you honestly cannot. And maybe it makes more sense to embrace it and then consciously bring in other items so that you don't get entrenched in one way or the other. Instead of thinking, as I think people believe, they are either, I'm going to put on this hat, and I've been ordained or appointed to put on the hat of originalism. Okay, I must find this. Throw that out. You can use a little bit of everything, just like lawyers do. You're magpies. You're picking up a little bit of this, a little bit of that. You're putting it together and kind of, calling it justice. I think a good book that inspired me with respect to Christian ecumenism, and I am a convert to the Catholic Church. I was raised Baptist, so that's already like kind of, me wanting a little bit of this, a little bit of that. My family raised me both ways, so I went to Mass in the morning and then like Baptist church. Can you imagine how crazy that is for a child? Like Mass in the morning and then Baptist church, the call and response, the actual stomping, speaking in tongues, the whole thing. I had it all. And it's like, oh my gosh, But I think that book, Mere Christianity by C.S. Lewis, was really inspiring for me. Now, some people may say it's a little bit, mild, but I think it's radical because he kind of says, is there some level of abstraction in which we can all agree? Is there something that is merely Christian, regardless of the 40,000 denominations that there are? What if there is a mere interpretation? I don't know. Is there something that we can all unite? Okay, we all agree with this. And I think is that the Constitution is sacred. Let's start there.
Thank you for the question, Jorge. Yeah, of course, just like rules have to be interpreted by people, conventions have to be maintained by people. And so there's no sort of magic thing that we can bind ourselves. Conventions can be broken at any time. And Dicey, as he identified conventions as customs, practices, maxim, precepts, also shared understandings. It's a set of assumptions. And what he meant was there's certain things that are unthinkable, like people won't think of them. But then occasions come along and someone thinks of it and someone does the unthinkable. And then by doing so, they break the convention. But he'd made another point, and this links up with some of your comments, that conventions are sociological. That is, they just carry on. And as he said, this is a quote, they're respected quite as much as most statutory enactments and more than many. And this is why I used, and this will give you an example. This is not an abstract discussion. I think many people were shocked that McConnell refused to bring Garland's appointment to proceed with it for a vote. Now, it's done. What's done is done. But here's my question: it's no longer unthinkable. And that's why I think it was a bad convention to break. For example, let's say the next president is a Republican and the Senate is controlled by Democrats. Now, Democrats can come up with a justification for not proceeding on a Republican president's appointment, and 2 years ahead. What's to stop that? And that's what I mean. My concern is for the system to function as a legal system, even at the highest levels, like the Supreme Court interpretation of constitutions, we have to respect a certain set of ideas about what it means to be a judge, what it means to have judges rule in accordance with law. And I believe that's fundamental to the functioning of our system. And we've seen in recent years that it's become more and more frayed.
Wonderful. Thank you both for your answers, and thank you, Jorge, for the question. In the interest of time, we could have one more question if there's any from the audience members or online. Yeah, you want to? Yeah, thank you. The microphone.
Yeah, this is okay.
Yes.
This is just a quickie when you were talking about what it is to be a Christian and given all the denominations and sub-denominations and so forth. But the one thing that occurred to me is the Nicene Creed. The Nicene Creed, which, I've always thought is, the defining characteristic that doesn't matter whether you're a Baptist or a Catholic or a Presbyterian or whatever, defines what it is to be a Christian in some united kind of way, which would kind of make that the analogy to what you want to say about the Constitution.
Yes, I think that's correct. It's a great insight, and I think I will steal that. I will also say that the funny thing is, though, again, with this kind of, I guess, partisan thinking, I think Presbyterians, Baptists, Lutherans, Methodists, you have Assemblies of God, all of them would agree with the Nicene Creed, but they won't agree that there's a Nicene Creed because it was a Catholic authority that wrote it and put it into effect as though it were a law. And that's what they would have problems with, the idea of a magisterium saying this is but they would agree, I think, with the content. So maybe we'd have to unpack that part. I can hear you. Oh, that's a microphone, yeah.
Just real quickly, I was raised Presbyterian, and every Sunday we recited the Nicene Creed and didn't worry about whether its origins were the Council of Nicaea or not. So I don't know if that's the case for every denomination, Protestant denomination, but certainly has been my impression that is, to the extent that Christianity is a unity ultimately.
Yes.
Right. That's the statement that everybody can basically get around. Now, whether, Baptists recite that during services or not, I don't know, but you would.
I think the further you get away from sort of Lutheran type denominations, the less likely they are to agree with the idea of the creed. Even if they believe everything in the creed. So we would agree with the creed completely, the Baptists would, but not necessarily say it that way or call it that way. Okay. But I think you're right. I think as a general rule, though, it might have to be a shorter one, because I do think the creed ends with, I believe in the Catholic Church. Doesn't it end with that? Doesn't it?
No.
At the end? Apostolic succession in there? Not at all in the Nicene, does it?
No.
Okay, then maybe that would be abstracting enough mere Christianity that I think pretty much most of them would. Yeah.
Okay, anyway, it was just a thought off the top of my head.
No, it's a great thought. Thank you.
All right, wonderful, thank you. And with that, we will close out our third panel. One last round of applause for our panelists. Thank you so much. We will return at 2:30 for our last panel of the day. Thank you, everybody. All right. Hey, everybody, we're going to get our last panel started for the day. All right, if I can get your attention, please, we will get started on our fourth and final panel of the day. So I'd like to thank everyone again for a great day so far. It's been very engaging, lots of questions. Really appreciate the engagement and the questions and the interest in the symposium. It means a lot to myself and the board and the journal and the speakers. So going into our fourth and final panel, we have it will be on constitutional theory, and we will have 5 speakers for this panel. First, we have Michael Paulson, then we have Garrett Ebbs, Lucas Clover Acolia, Jorge Faranichi Furnos, and Sandy Levinson. So to provide a quick introduction for each, we have Michael Paulson, my former constitutional law professor 1L year. Very happy that he was. I learned a lot in that class, so I was very lucky to have a great professor. So Michael Paulson, he's a distinguished university chair and professor of law at the University of St. Thomas. He received degrees from Northwestern University, Yale Law School, and Yale Divinity School. From 1991 to 2007, he was a faculty member at the University of Minnesota School of Law, where he served as professor and associate dean. He has been a visiting professor at various institutions, including Princeton University and Georgetown University. He's also guest lectured at Harvard, Yale, Columbia, Princeton, Stanford, and many other institutions. In 2018, he was a fellow in the James Madison Program in American Ideals and Institutions at Princeton University's Department of Politics. He's authored more than 90 scholarly articles and book chapters on a wide variety of constitutional law topics, which have been published in law journals, including the Harvard Law Review, the Yale Law Journal, and the Stanford Law Review, and the University of Chicago Law Review. Secondly, we have Garrett Ebbs. He spent 15 years as a professional writer and novelist working for the Richmond Afro-American and the Washington Post. He is an award-winning author of two novels, The Shade Treatment and The Floating Island, A Tale of Washington, and 5 works of legal nonfiction. His journalism has appeared in the New York Times, the New York Review of Books, the New Republic, and the American Prospect. After graduating from Duke Law School and clerking for Judge John D. Butzneer Jr. of the Fourth Circuit, Garrett spent 16 years as a professor of constitutional law in Oregon. From 2008 to 2020, he taught constitutional law at the University of Baltimore and covered the Supreme Court for the Atlantic Online. In 2020, he returned to Oregon, where he's professor of practice at the University of Oregon School of Law and the legal affairs editor of the Washington Monthly. Next, we have Lucas Clover Acolia. He's a lecturer at the University of Otago School of Law in New Zealand, where he teaches wills and trusts. He was previously a postdoctoral associate at the Shimian, my apologies if that's incorrect, Scheiman Institute on Conflict Resolution at Cornell University, where he designed and taught a course on alternative dispute resolution. His research includes trust, property, dispute resolution, and legal theory, particularly the historical approach to law and Catholic legal teaching or theory. Lucas obtained his undergraduate law degree from the University of Aberdeen in 2010, his LLM from Edinburgh University, and his doctorate in law from McGill University. Lucas has published articles in the McGill Journal of Dispute Resolution, the Journal of International Dispute Settlement, the Chinese Journal of International Law, the Pepperdine Dispute Resolution Law Journal, and the Contemporary Asia Arbitration Review, among others. His doctoral thesis, The Arbitration of Trust Disputes, was published in 2022 by the Edward Elgar Publishing. Next, we have Jorge Faranichi Furnos. He is a visiting assistant professor at the University of Buffalo School of Law and an associate professor at the Inter-American University of Puerto Rico Law School, where he teaches constitutional law, legal history, administrative law, and legal writing. He received his BA, MA, and JD from the University of Puerto Rico, his LLM from Harvard Law School, and his SJD from Georgetown University Law School. He has also published several articles he has published articles in the Southwestern Law Review, Hastings International and Comparative Law Review, Tulsa Law Review, Kansas Journal of Law and Public Policy, Montana Law Review, Barry Law Review, and Vienna Journal of International Constitutional Law. His most recent book contains a detailed first impression analysis of the Puerto Rican Bill of Rights. And lastly, we have Sandy Levinson. Since 1980, he has been a professor of law at the University of Texas Law School. He holds the W. St. John Garwood and W. St. John Garwood Jr. Centennial Chair in Law and is also a professor in the Department of Government at the University of Texas. Sandy has authored approximately 400 articles, book reviews, and commentaries. He's also written 6 books and edited or co-edited approximately 9 books. He has been a visiting faculty member of the Boston University, Georgetown, Harvard, New York University, and Yale Law Schools. Additionally, he has taught abroad in programs of law in London, Paris, Jerusalem, Auckland, New Zealand, and Melbourne, Australia. So that is our 5 panelists. We will start with Michael Paulson, then move to Lucas. We will start with our in-person speakers first. Then we will go to Garrett Ebbs, then Jorge, and then Sandy will finish us off. So Michael, you may start when you're ready.
Thank you, Mr. Northagen, for that flattering and borderline perjurious introduction. I'm going to go back and revise his C- grade and move it up to like a C+ and everything. I'm honored to be here. I'm delighted, and I very much want to thank the organizers and the students in the JLPP, and especially Austin Northagen, and commend you for sitting through, some of you all day, 18 law professors and 8 hours worth of academic presentations. It's more pain than any law student should have to really bear. And thanks to my colleague, Chuck Reed, who along with the JLPP students succeeded in assembling such a stellar panel of scholars and speakers. And thanks to the invitees for coming, for participating, for braving our bracing and shockingly early, even for us, Minnesota winter. As I was explaining to some of the guests, this is what we in Minnesota call fall. So, now, I have to confess that when the conference organizers first approached me and with the invitation, and they said that the theme of the conference was simply constitutionalism, I thought, really? Constitutionalism? What is it next year? Law? Right? Isn't it sort of impossibly broad and vague? What could I possibly say about constitutionalism in 10 or 15 minutes? But then I thought about it and I realized that though I'd written a fair bit on various aspects of the Constitution and on constitutional interpretation generally, I'd never really given any careful or systematic thought to constitutionalism as an ism, right? And I was thinking, what exactly is constitutionalism? What defines it? And how does an understanding of what constitutionalism is play out with respect to written constitutionalism and to the enterprise of interpreting a written constitution, the game I've been playing for like 30 some years. And so I decided to attempt some definitions. So I'm not sure these are perfect, but here goes. It seems to me that at the core of constitutionalism is some version of the idea that a society's or a political community's governing institutions and powers and the rights of its citizens are or ought to be to some degree prescribed, defined, determined, and fixed in advance. They are fixed in advance by certain prior agreed binding rules or principles that operate as superior or higher or more fundamental law, limiting the scope of other more ordinary law. Or put a tad more succinctly, constitutionalism is the idea that present policymakers are constrained by prior rules. One could fairly say that the essence of constitutionalism as an ism is ruled to some degree or another by the dead hand of the past. Now, if indeed that is the essence of constitutionalism, ruled by the dead hand of the past, then the essence of written constitutionalism is ruled by the dead hand of the past in the form of a written, authoritative, binding legal text that dead hand or set of dead hands wrote. And that fidelity to such a written legal instrument as a set of prior binding rules limiting present governing choices. In other words, the enterprise of being faithful to what written constitutionalism is, requires that such a written document be understood and applied in accordance with the objective original meaning of its words,
phrases, structure, logic, and background embedded premises. That is, written constitutionalism consists of seeking to ascertain the objective meaning the document's words and phrases would have had to a reasonably informed speaker and reader of the English language reading a document like this at the time it was adopted within a particular political society. So the title I've chosen for my remarks is Dead Framers Society. And I have a little handout flying around. You can use it to see if I'm anywhere near getting done in my 15 minutes. My thesis is that American political society, operating under a specific written constitution, is a dead framers society. We are ruled, at least to the extent we think ourselves governed by a written constitution, by the original meaning of words and phrases written and adopted by long dead writers and political actors. We have chosen, for better or worse, to be governed to some substantial degree by the dead hand of the past. We are a dead framers society. Now, I take my title from a 1989 movie, a wonderful movie called Dead Poets Society. Anybody seen it? Oh, you have. I'm actually surprised. I was going to tell you, did you notice? I just rewatched it with my wife a couple of weeks ago. I think it was on Amazon. It's just $2.99 with Prime membership. But it stars a young Ethan Hawke. He's one of the students. But the main star is Robin Williams. The late, great Robin Williams. If you don't know him from Dead Poets Society, you might know Mrs. Doubtfire. And I think he won the Academy Award for Best Supporting Actor in Good Will Hunting. And depending upon your age and what your parents did to keep you out of trouble when you were little kids, he was the voice of the genie in Aladdin, right? So Dead Poets Society is set in 1959 at an elite New England all-boys prep school. And Robin Williams plays the exuberant, irrepressible, inspirational young teacher of English and American literature, poetry, who dares his initially skeptical students to seize the day, carpe diem, and, quoting Thoreau, to suck the marrow of life and not just live passively, content to accept for their lives a destiny prescribed by others, by social convention or by circumstances. And the vehicle for these life lessons, which is really what he's teaching, not literature, is to teach the boys to study, appreciate, and embrace the very much alive works of now long dead poets. And the boys form, or actually reform, a Dead Poets Society after the example of their inspirational teacher who had once formed such a society when he was a student, and they learned that he had been a student by looking at his yearbook, and they see what his activities were. They sneak out of the dorm at night and go to an old Indian cave and read poetry. Now, the focus of their society, this Dead Poet Society, was of course not the dead poets themselves, it was the poetry. It was the works of the poets, the meaning or meanings of their words as literature. Now, if one were to make a Hollywood film about written constitutionalism, you should call it Dead Framers Society. And instead of set in a quaint New England town in the late 50s, I imagine the setting be, one of the up-and-coming great American law schools, perhaps set in a middle-sized Midwestern city. Now, I'm not sure exactly who should be cast in the role of the exuberant, irrepressible, inspirational, even if not quite so young, originalist constitutional law professor committed to inspiring his students to passionately pursue, seize, and suck the marrow of original meaning from the Constitution's words, words that, though written by men now long dead, give life to our constitutional practice of written constitutionalism. So I'm not sure who could play the role, but I have some ideas. We can discuss that later. But the film would depict young men and women under the tutelage of their iconoclastic but humble teacher, earnestly studying law, living in and embracing fully and rigorously the system of true written constitutionalism under which they live.
aspiring to be faithful to the Constitution of the United States as the supreme written law of the land, and therefore devoting themselves fervently to discovering the objective, original meaning of the document's words and phrases in their appropriate social and linguistic context, taking into account any background premises and accounting for any specialized usages or legal terms of art, and reaching only correct, sound inferences from the Constitution's structural logic and the ordering of the system as a whole. In interpreting and faithfully applying the written Constitution, the students would, of course, take fully into account the nature of the document that they are studying and to which they are seeking to be faithful. That is, they would attend to the document's genre as law. The Constitution is not a poem. The Constitution is not literature. The Constitution is not Moby Dick. It is not even scripture, except in the sense that both sets of texts seek to be understood as authoritative and binding on their particular communities. But mostly, it's important to remember the Constitution is not a poem. It is not a collection of verses for which different readers might perhaps be permitted to supply their own subjective, idiosyncratic, perceived, or desired meanings. A constitution is a set of prior rules for the government of government, supplied by a single, defined, determinate, written legal text. So the students would thus unite as one in disavowing any hermeneutic under which they might simply project their own political or policy desires onto the text. What blasphemy that would be. And as a testament to their passion and commitment, the law students formed for themselves, half seriously, half ironically, a Dead Framers Society, an informal student club designed to study in greater depth, not the framers for their own sake, because the object is not framer veneration, any more than the object of a Dead Poets Society is the study of the poets themselves, nor even to focus on the framers' subjective intentions or expectations about how the Constitution would be applied. For the enterprise is not one of seeking authorial intent or discerning anyone's in particular's original intentions concerning the meaning of the document. Rather, the Dead Framers Society would embrace the study of proper originalist sources for the light they might shine on the enterprise of ascertaining the objective original meaning of the terms, phrases, and structures contained in the Constitution as they would have been understood by informed English readers and speakers of the language of reading a document of this type at about the time it was adopted. Always this object of inquiry would be the Constitution itself, the text, the work, not the author, the composition, not the composer, the song, not the songwriter, the play, not the playwright, the poem, not the poet, is the ultimate object of inquiry. So briefly then, what would be the proper rules of proceedings for our imagined Dead Poets Society? If the project is faithful interpretation of our written Constitution, then one must take that written Constitution on its own terms. One must seek to ascertain and faithfully apply the meaning of its words and phrases in their known original sense. This is the only method consistent with taking the Constitution on its own terms as a binding written document intended to function as supreme law. It is the only method consistent with the very idea of written constitutionalism. If what one is doing is interpreting a written constitution intended to serve as governing law, as opposed to engaging in some other perhaps interesting project, one must take that constitution literally on its own terms, understood as it would have been understood by readers at the time and in the political community where it was written and adopted. Any other approach is pure anachronism. Now, there's an objection to this. The objection that is typically thrown at originalism as a method of constitutionalism, constitutional interpretation, is that it amounts to rule by the dead hand of the past. Why, the objection goes, should we be governed by the rules set down in a document written 235 years ago by now long dead privileged property white males? That's a good question. And the Constitution doesn't answer it. It is a question not of constitutional interpretation, but of political theory or political science or political morality. In short, it is a question of politics extrinsic to understanding the meaning of the Constitution. For what it's worth, there might be different, better ways to run a society than being governed by a written constitution. Our particular written constitution might not be an especially good one. Historically, it hasn't been in many important pertinent respects. It might contain defective arrangements or flawed provisions that are really not for the best. Reasonable people can differ over such things, and they might make different political judgments about whether it is a good thing or not such a good thing to be governed by this or any particular written constitution. But the enterprise of interpreting the Constitution is distinct from the question of deciding whether or not you wish to be bound by it. Interpretation precedes evaluation. Before you know whether you wish to be bound by this Constitution, you have to ascertain exactly what it means. In the end, the objection that is raised of the dead hand of the past is not really an objection to original meaning textualism as a method of interpreting and understanding a written constitution. It is an objection to written constitutionalism at all, as a political arrangement. More than that, I submit it is actually an objection to constitutionalism of any kind, to the idea that certain fundamental decisions made by some group of persons or actors at one time constrain or should constrain the political actions of later groups of persons or actors. Constitutionalism is ruled to some degree or another by the dead hand of the past. And written constitutionalism is ruled by the dead hands that wrote and adopted the written Constitution. As I wrote for a different law review symposium a little over a dozen years ago, written constitutionalism is the idea that we should be governed to some degree by the dead hand of the past. It does privilege the dead hand of the past. That is what writing constitutions is all about. Entrenching certain decisions and choices against present and future popular choices to the contrary. The argument for constitutional judicial review is a dead hand of the past argument. Everything about the written Constitution as supreme law, trumping current practices, policies, or preferences inconsistent with it, is dead hand of the past reasoning. So if one objects to original meaning textualism as a method of interpreting the Constitution, one is objecting to written constitutionalism. And conversely, if one embraces and accepts as our governing law a written constitution, then one is agreeing to live, move, and have their being in a dead framers society. Thank you.
So, I will not be by far the most eminent speaker, but I will try to be the most controversial because that's what I do best. And luckily, I picked a pretty controversial topic, common good constitutionalism. Again, I will not be anywhere near as eminent as Adrian Vermeule, but I'll try and be a stand-in. So, I argue that constitutionalism is America's national sport. Probably don't have much right to say that as a non-American, but hey, I think it's true. I think it's pivotal to American life. There's probably no other jurisdiction in the world in which the selection of judges dominates news cycles for weeks, months, maybe years, and the same goes for court decisions. There are numerous organizations which exist to advance particular views on constitutionalism. I'll put a couple of them on the screen. And the two political parties are pretty transparent about their views on constitutionalism. You can usually guess what they mean when you ask them that question. Now, judicial philosophies. Today, it's pretty much been a two-horse race. So we have living constitutionalism. The meaning of the Constitution evolves over time. I think it's fair to say that's usually in line with progressive views. I wouldn't say always. And originalism, which this is a simple explanation, but anyway, the meaning of the Constitution was fixed at the time of its enactment although its application may evolve over time due to changing technologies. I think that's roughly right. Someone can correct me if I'm wrong. Now, there is what I would call a dark horse, which Adrian Vermeule has introduced, shall we call, common good constitutionalism, which is the new contender for the throne, which broadly speaking says law should be ordained towards the common good and read in the light of the classical legal tradition. And that legal tradition theoretically goes back to some of the Greek philosophers, but more realistically to Roman legal scholars. Now, it takes as its starting point substantive moral principles that conduce to the common good, principles that officials should read into the majestic generalities and ambiguities of the written constitution. It defines the relevant common good, and this is Vermeule's definition. I think he's tweaked it since because he publishes a lot and he has blog posts and so on, as the flourishing of a well-ordered political community. The common good is unitary and indivisible. There are theological arguments about whether it's unitary, whether it's divisible, and so on. He thinks it's not. It's not an aggregation of individual utility, so it's not utilitarianism. It's not what produces the greatest good for the greatest number of people. In its temporal aspect, it represents the highest felicity or happiness of the whole political community, which is also the highest good of the individuals comprising that community. So the good of the community, the highest good of the community and the highest good of an individual, in this view, is the same thing. They're not opposed to each other. It's not intended to be novel, although it seems novel in the American tradition. It isn't. It's rather a modern adaptation of the classical legal tradition. And for that reason, I'll use common good constitutionalism and the classical legal tradition interchangeably. Vermeule argues the classical law reads the law of a particular jurisdiction, the jus civil, in light of the jus gentium, which is the law of nations or peoples, and the jus naturale, the natural law, which the civil positive law is taken to specify or determine within reasonable boundaries. Counterintuitively, and Vermeule is pretty clear on this, he doesn't believe that the issue of unjust laws is an important one. He states, and I quote, "They're a sideshow, a case to which the classical theory paid and theoretically needs to pay relatively little attention." What he's very interested in is the idea of specification. How do you understand what the words mean, and how do you apply them to situations which maybe those that wrote the document didn't conceive of? This marks a pretty big difference between him and classical legal theory. Vermeule's definition of jus and lex broadly accords with classical legal theory. So Francisco Suarez, who's a scholar, theologian from the 1600s, held jus and lex are comparable as a genus and species. Jus is the genus, whilst lex is the species. You can think of that as broadly equivalent to his idea that you read the law of a particular jurisdiction against the law of nations and against natural law. Isidore Seville, who's, I think, 7th century, jurisprudence is a general term, and law is an aspect of jurisprudence. It is called jurisprudence jus because it is just. All jurisprudence consists of laws and customs. A law is a written statute. A custom is usage tested by age. Unwritten law, for law, lex, is named from reading, legare, because it is written. Again, roughly equivalent. Vermeule doesn't go into much detail, at least not yet. I've looked, I haven't found it, concerning the relationship between the jus naturale, jus gentium, and jus civil. But what he does say seems to be broadly compatible with classical legal theory. Broadly, not necessarily completely. So Isidore, when he talks about natural law, it's probably one of the earliest definitions that we have. Common to all nations, and because it exists everywhere by the instinct of nature, it is not kept by any regulation, such as the union of a man and woman, the children's inheritance and education, the common possession of everything, etc. And he gives several other examples. A key issue for both Vermeule and classical legal theory is the generality or vagueness of natural law. So Suarez, in a passage which is pretty similar to Vermeule, says that natural or the divine law is of a general nature and includes only certain self-evident principles of conduct, whereas in addition to such points, many others are necessarily involved in the case of a human commonwealth, in order that it may be preserved and rightly governed, so that it was necessary for human reason to determine more particularly certain points, a determination that is effected by means of human law. Some of those general points pretty much would come from the Decalogue. Don't steal, don't murder, so on, things that we all think of as self-evident. This determination is what leads to the jus gentium and the jus civil. So the jus gentium, in theory, is those things which are derived from the law of nature as conclusions from premises. So it shouldn't involve much reasoning, it should just be immediate. Kind of like 1 + 1 = 2 in theory. Just buying and sellings and the like. And this comes from Aquinas. And the civil law consists of those things which are derived from the law of nature by particular derivation, according as each state decides on what is best for itself. For example, what side of the road should you drive on? How should you decide who governs you? These kind of things. And therefore, there's variety among them that you don't see in the jus gentium, because those things can differ. It's not necessarily obvious that it's not the same thing driving on the right or the left side of the road. It's not the same thing as don't steal, don't murder. These are pretty blatant things that we can usually agree on. Vermeulen and the classical natural law do differ on whether the issue of unjust laws is an important one or not. That didn't necessarily come out in his original work, but since he's been responding to some unsurprisingly pretty strident originalist criticism, he makes this quote that I said earlier, that he doesn't basically think that unjust laws are an important issue for natural law theory, which for those of you that have studied natural law theory is probably a little surprising, because this seems to be the intuitive attraction of natural law theory, that it can deal with those issues of unjust laws in a way that strict positivism, which is really what originalism is based on, it is a strictly positivist theory, cannot deal with. For classical lawyers, unjust laws were an important issue. So Suarez says, law is a measure of rectitude, but an unjust law is not a measure of the rectitude of human conduct. On the contrary, an action which conforms to it is unjust, therefore it is not law. Somewhat formalistic reasoning. Aquinas likewise explains that unjust laws are acts of violence rather than laws, because as Augustine says, a law that is not just seems to be no law at all, which is probably the one quote, if anyone knows anything about natural law, this is the quote that will come to mind. And there are others that really discuss that for unjust laws, we actually need to resist them and so on. Now, Vermeulen is correct. He says in a footnote to one of his papers, so he really does mean what he says when he says that he doesn't think that unjust laws are an issue for natural law theory, because he deals with it in a footnote, not in the body of his text. One may have to obey unjust laws if necessary to avoid scandal and disturbance. This isn't really a controversial thing. Aquinas and others have said it from a very early stage. And you have some authors say that necessarily, if the government orders something, opposing it will cause scandal and disturbance by necessary. If we all decide, some people decide they want to drive on the left and others decide they want to drive on the right, we'll find out in about 30 seconds that it's not going to end well. So it will cause scandal and disturbance. Or if you decide that stealing's fine and the other person doesn't, it's not going to end well. But he omits one key distinction, and I think that this may be because it's mainly responding to originalism, which is that classical lawyers believe that if a law was wrong in substance, it was on no account permissible to obey the law, not even for the sake of avoiding any damage or scandal whatsoever, since it is never permissible to do wrong for the sake of any end. And this is a classic point of Catholic moral theology. It is not permissible to do wrong that good may come of it. And Domingo de Soto similarly explains that laws contrary to the divine good, such as the laws of tyrants inducing to idolatry or anything else contrary to the divine law, must no wise be observed, because we ought to obey God rather than man. And he even goes as far as saying that actually when it goes against the divine good, which would usually be the Decalogue, theft, rape, all these kind of things, we actually have to publicly denounce those laws, and even if it would cost us our lives, we should oppose them. He says it would be shameful to not oppose those laws, and the idea that there's eternal life and so on, it would be so absurd to worry about giving up your life when actually, theoretically, you're going to live forever anyway. So why would you disgrace yourself in that way? So there's pretty strong language from the classical legal theorists. And Gratian states, one who disobeys bad ordinances laid down against the will of God should be rewarded. So there's this distinction that Vermeulen hasn't yet made, that yes, if it's just an issue of a human good, I don't know, they want to tax you too much. Not popular, but let's say it's a human good. You may have to obey that to avoid scandal and disturbance, even if, for the sake of argument, let's say it's unjust. But if the law positively said, I don't know, we can kill all people that are right-handed or left-handed or whatever it might be, that is not a law that you could obey. It would be contrary to the divine good. And that really does have to be brought out. Otherwise, what type of classical legal theory are you dealing with? So kind of switching aside from the more theological side of things to, well, does this system actually exist in the United States, or is originalism the original version of constitutional interpretation? There are numerous eminent common law authorities which extensively discuss natural law. I will not go into them because I don't have enough time, but they are in the article. I didn't make this up. They do all discuss natural law in various degrees. Usually Saint-Germain, who is actually, I think, more of a theologian, although his doctrine student is widely used, he goes into the most detail. But you find it as late as Blackstone. He does talk about natural law quite extensively, and the idea that the common law is based on the natural law. There are quite a number of early English and US cases which use natural law in their reasoning, particularly when it comes to family law and to public law. So in this case, it stated that by law of nature, parents are to provide for their children. And later, in another case, it stated it's a mother's undoubted right, if there is no father living, to have the company and care of and the control over her own child. That is a law of England founded on the law of nature. Somewhat more disturbing species of legal problem. The laws against incest are justified effectively on natural law basis, both in the United States, in certain states, and in England. And the idea was that marriage between the ascending and the descending line was in infinitum, was incest against the law of nature, because it tends to the destruction of the natural will of the Creator, which designed the preservation and continuance of such inhabitants of the world as he originally created, and so on. In the United States, this kind of sayings are mirrored. So in the case of the Etna, this was to do with a drunken father who was so violent to his children that, to quote the case, they flew out of the windows to escape from him. And he was claiming that he had the right to the money that was earned by his child. And if he'd not been an abusive parent, he would have had that right. And the court said, the father is bound by the dictates of natural law to support, protect, and provide for the well-being of his children according to the measure of his ability. And if the law invests him with the right to control over their persons, it is only for the purpose of enabling him to perform more effectually and completely those duties which are enjoined, as well by the instincts of nature and the dictates of reason as by the law of the land. Whiteman against Whiteman, which unfortunately again deals with the issue of incest, it's much more clear this is based on the law of nature. And the judge there says, by the law of nature, I understand those fit and just rules of conduct which the Creators prescribed to man as a dependent and social being, and which are to be ascertained from the deductions of right reasons, though they may be more precisely known and more explicitly declared by divine revelation. Parental rights is another issue which has come up. The parent has the right to the care, custody, and assistance of his child. The duty to maintain and protect it is a principle of natural law, and the municipal law should not disturb this relation except for the strongest reasons. There are similar cases in England as well. Public law, less so in England, but more in the United States. So in Day against Savage, which quoted a case of Lord Coke, Dr. Bonham's case, if any of you have ever come across it, an act of Parliament made against natural equity as to make a man judge in his own case is void in itself. For jure naturae sunt immutabilia, the laws of nature are immutable, and they are leges legem, the law of laws. This tradition fizzled out in England. We very much embraced legal positivism, for better or for worse, but it did continue in the United States. We find in, let's say, the mid-1800s, a court saying that the legislature did not possess the power to destroy the natural rights of a citizen, to declare innocence a crime, or on their own volition to take the property of one and give it to another. Inhibition against such acts was unnecessary because they were inhibited by the law of natural right. And this was not something that was explicitly stated in the state constitution at that time. This was them reasoning from natural law. Unsurprisingly, given the American relationship with property, there are a lot of natural law cases which deal with property. So in this pretty early case, the right of acquiring and possessing property and having it protected is one of the natural, inherent, and unalienable rights of men. Men have a sense of property. Property is necessary to the subsistence and correspondence of their natural wants and desires. And this is pretty close to the natural law justification for property, that it's necessary to live to be able to provide for yourself and to be able to provide for your family. So from the case law, I would say, although I have to dig to find it, originally there was heavy reference to natural law, or what often amounts to reason, and reason was often held to be, when jurists in that period of time talked about reason, they very often were talking about natural law. So there's the idea that the common law was based on reason, and reason was nothing else than natural law. So sometimes they'd say the law of reason, and what they meant by that was natural law. And you find this in some of the eminent scholars where they'd say, well, that's what natural law is. Briefly, 42 out of the 50 state constitutions also reference natural law in some form, and common good constitutionalism has been applied in one case. Unfortunately, it's not a very pleasant case, but it does exist. So I would just ask, is originalism original? I don't think so. So thanks for listening, and look forward to your questions.
Wonderful. Thank you so much to both of our in-person speakers. To go over for the virtual speakers, well, we will have Garrett, Jorge, and then Sandy is the order we will go in. We have a 15-minute timer set for presentations, so once the timer goes off, I will interrupt you apologetically to let you know that 15 minutes has gone. So with that, Garrett, you may start. Garrett, you're muted.
All right.
There we go.
All right. Hear me now. Okay. I want to thank the University of St. Thomas School of Law and the editors of the Journal for this invitation. I have to say I'm honored to appear aside a number of these scholars whose attainments honestly render me struck. I won't list them all, but I will say that I'm very tickled to discuss this topic at this conference in the virtual presence of Professor Levinson, one of my beloved mentors, who once accused me of Constitution worship after I wrote a column suggesting that progressives should not cede the mantle of constitutionalists to the Tea Party or now the MAGA movement. And I bring this up not to pursue that scholarly quarrel. Professor Levinson's observation was not only fair, but it was quite generative and constructive in the sense that in the more than a decade since, not a week has passed without my remembering his caution and asking myself whether I really am smart enough to know the line between approving the Constitution as a tool and venerating it as a stone idol, between actual constitutionalism and what I will call cargo cult constitutionalism. I will say that at this moment, I retain somewhat more optimism about American constitutionalism than the current political situation would suggest. I think we may salvage this Constitution. My optimism may stem more from a sound digestion than a sober assessment of the facts. I want to start with an anecdote that's like a parable, not important in itself, but it frames the current situation of popular constitutionalism. In March 2016, Glenn Kessler, the Washington Post fact checker, wrote that a considered judgment of mine and of dozens of other scholars deserved 3 Pinocchios. Now, Pinocchio's nose signifies that those who wear it are lying. And our supposed lie was the suggestion that when President Obama nominated then Judge Merrick Garland to the Supreme Court, seat left vacant by the death of Justice Scalia, that the Senate had a constitutional duty to give or withhold its advice and consent. Kessler questioned their truthfulness and wrote, "It's a matter of opinion whether refusal to consider a nominee is a dereliction of constitutional duty or walking away from a constitutional responsibility, but the Senate majority can, in effect, do what it wants." I tell this story not because this particular constitutional dispute is important in and of itself, though it may arise again in the future. But I think that this interpretive dispute raises the question of whether a constitutional claim can properly be anything more than a dispute over the literal meaning of a few, and often very few, words on a printed page. Because in practice, that is where constitutionalism in our time seems to be headed. Now, as far as the Garland thing, the Constitution says the president, by and with the advice and consent of the Senate, shall appoint judges of the Supreme Court. It conspicuously does not add what I will call a boy howdy clause. And a boy howdy clause would say in so many words, this means that the Senate has to sit right down and consider a president's nomination and can't just throw it in the wastebasket because boy howdy, that would be unconstitutional as all get out. So really, no kidding, do the job you were elected to do, okay? Good talk, okay. The omission of such language led a number of conservative commentators, perhaps inspired by a proprietary interest in Scalia's seat, to argue that the Senate can constitutionally just ignore a presidential nomination and leave a vacancy on the court because, as one of them wrote, there's no duty to consider it in text, history, or practice. The argument leads irresistibly to one advanced by Ilya Shapiro, then of the Cato Institute, who chimed in with a helpful suggestion at a time when he thought Hillary Clinton was going to be president, that the Senate could simply refuse to confirm any justice to the court at all. As a matter of constitutional law, the Senate is fully within its powers to let the Supreme Court literally die out. Now, I and many lawyers far smarter than I are of a contrary opinion. Is our opinion, the opinion that a boy howdy clause is not needed to create an obligation on government to behave in conformity with the outlines of the Constitution, is that false in any useful sense of the word? Or to put it more clearly, is there really a form of constitutionalism under which the opposite argument, no duty, is in any useful sense of the word true? Does the Constitution actually allow part of the government to refuse to do a task its text assigns to it unless the text of the Constitution contains a boy howdy clause? Would it be thus, as a matter of constitutional law, to use Shapiro's phrase, be fully within Congress's power to refuse to consider the president's budget and indeed refuse to pass any budget or appropriation at all? Would it be fully within the Senate's power to refuse to confirm any nomination of any kind and block the employment of civil servants as well in order to let the government itself die out? Does the patent absurdity of these questions suggest to you, as it does to me, that much of our current political dialogue and constitutional discussion is no longer within the boundaries of constitutionalism at all? Again, we all have to revert to this question: what is constitutionalism? As we've seen today, the concept is one that invites dispute and destruction. I actually believe and have written that the Constitution must sometimes be read as one would read a poem. But I was heartened that despite our disagreement on that point, Professor Paulson's definition and mine aren't that different. Mine might be, quote, the idea that government should operate according to a fixed and known set of rules and should obey those rules even when doing so makes achievements of its goals more complicated. But there is another meaning, and one that Professor Levinson has warned us all against, a meaning that suggests it is that more of our current constitutional dialogue suggests than seems entirely comfortable. And in that sense, constitutionalism means fetishization of a set of words, often very few, read without any resort to context or consideration of their purpose or their real world implications. Does the Constitution, by its lack of boy howdy clauses, empower government actors to do or not do anything that is not explicitly forbidden or commanded? Now, a lot of smart people have told me in no uncertain terms that if I don't embrace the new original public meaning school of interpretation, I am a living document heretic, that there are only two positions, and that unless I'm an originalist, I am, as Ken Kesey used to say, off the bus of constitutionalism and operating in some other field altogether. Justice Scalia famously said the Constitution had to be a dead document. I don't agree with that, but I do think we are closer than I would like to actually pinning the Constitution in that killing jar once for all. A larger and larger share of contemporary constitutionalism reminds me of the story of the great warrior Rodrigo Diaz del Vivar, known to history as El Cid. The Cid's widow, Doña Jimena Diaz, the Lady of Valencia, supposedly strapped Rodrigo's dead body to a horse and sent the horse out riding blindly as a way to inspire the troops during the siege of Valencia. There is a good deal of El Cid constitutionalism going on in our country. And my reaction to it is that it gives us a meaning of the term constitution with which I'm not comfortable. My reaction is like that of Flannery O'Connor, who had a brief, and I think only one-time conversation with Mary McCarthy. McCarthy was a lapsed Catholic, O'Connor was a devout one. And O'Connor later said that McCarthy said she thought of the Eucharistic host as a symbol, to which O'Connor answered, well, if it's a symbol, to hell with it. The Constitution, if the Constitution is a corpse on a war horse, to hell with it. Trumpism represents the supreme extension of the idea that this Constitution or any other has no meaning other than the bare words interpreted in the sense most convenient for those with power. And this has produced more echoes than I would like to know from people in our business of constitutional interpretation. Shapiro's conclusion that the Senate is within its power to let the Supreme Court die out is only a few steps away from, I have an Article 2, and it says I can do whatever I want. The country as a whole is about to hear some people who, in my opinion, should know better, argue that the Constitution doesn't have to permit repayment of the national debt in defiance of Section 4 of the 14th Amendment, because 14th Amendment doesn't say, boy, howdy. When we say the validity of the public debt shall not be questioned, that means even if a later Congress passes a debt ceiling statute, one party doesn't get to destroy the national economy for partisan aims. And there's not much of a firebreak between popular and judicial constitutionalism. The Supreme Court, in a month, will seriously consider the argument that the word legislature in Articles 1 and 2 of the Constitution because it doesn't say, boy, howdy, the word legislature here is used in its proper context, meaning procedures followed by a legislative body governed by state statutes it has passed and the constitutions created by the people of the state, and must instead, because the words is right there, legislature, mean legislators without anybody to check on them, except by a bizarre coincidence, the 9 members of the Supreme Court. Is this constitutionalism? To be honest, I'm not sure it's even law. That concludes my remarks. I hasten to assure the editors of the Journal that I will submit a transcript of this talk to Glenn Kessler for approval before allowing it to be published. Thank you.
Great, thank you. Jorge, you may start when you're ready.
All right. So, hello to everybody. I would have wished to be there, but the weather said otherwise. So I'm coming for you from snowy Buffalo. Hopefully in 2 weeks, I'll be in sunny Puerto Rico. So that will be a nice change. So today I wanted to share what is mostly a paper within a paper. It's part of a larger project about progressive state constitutionalism. And it's about the interaction, the role that modern state constitutions have and play in the future development of constitutionalism in the United States. So let's start with, why are we here in this conference? What's the problem? Why are we concerned about the current state and future of constitutionalism in the United States? Well, I want to focus on part of the problem. There are many problems, but I want to focus on one. There are others, like the deterioration of the political culture and institutions, the direction of the federal judiciary. But I want to focus on this problem. How do we develop modern constitutionalism using an 18th century federal constitution? That seems a little awkward, in great part because the US Constitution is not truly a modern constitution. It predates what we now consider to be modern constitutionalism. It is at best a proto-modern or early modern constitution. So let's look at some of the components of constitutionalism in the United States. And we can see this list, right? There's the US Constitution, there's the decisions of the Supreme Court, the practice of institutional actors, but this list is incomplete. There's an obvious piece missing. And if we only had these tools, we would be ill-equipped to continue on the road to modern constitutionalism. The US Constitution falls short with that task. So what's the missing piece? Well, it's the obvious, right? State constitutions, which have been mentioned many times today, and which many scholars, like my former LLM professor who will speak after me, have dedicated so much effort and study. But in particular, I want to focus on state constitutions that we can describe or characterize as modern. And many of them tend to be, in turn, progressive. I will try to see if I can address this distinction and see how it fits. I'm going to use the concept of modern constitutionalism. I am very uncomfortable with the liberal-illiberal dichotomy. I think that's too narrow. There are other forms of constitutionalism out there. There's post-liberal constitutionalism, there's socialist constitutionalism. I'll just bundle them up in the concept of modern constitutionalism. So what's my proposal? That modern state constitutions, particularly the ones that we can characterize as progressive ones, are vital ingredients for the future development of constitutionalism in the United States. For two reasons, right? I am on the side that thinks that the US Constitution will need to be replaced at some point if the US wishes to be still a modern constitutional state. And there's two important roles that state constitutions can play here. One, as examples of how to write a constitution for the modern world. And two, in the meantime, because the US Constitution will fall short on many instances, the state constitutions will act as a fail-safe for those gaps. So where are we now? Well, we're in a terrible situation right now. I think we have a terrible combination. We have an 18th century constitution in the hand of 18th century minded judges. And therefore the gaps, insufficiencies, and deficiencies of the US Constitution are starting to show dramatically. If we had at least a 21st century constitution, we would maybe be in a different situation. So what are these gaps, insufficiencies, and deficiencies? Well, we can see three types. First of all, the way in which the US Constitution was written may have been good for the time. It would not pass muster today. That's not how we write constitutions right now. They can be done by secret, elite, privileged members of the population with the exclusion of a large segment of the population. With regards to its content, well, the US Constitution is obviously an 18th century production that reflects an 18th century worldview that protects mostly the interests of the privileged classes. And again, it was done in a pre-modern constitutionalism world, and therefore it has gaps by a modern standards. And structurally, right, there are democratic insufficiencies in the US constitutions, from the composition of the Senate, the first past the post system, and so many others we could discuss. In fact, what's going on right now is that American people have looked and are turning to state constitutions as the preferred vehicle for the protection of their rights and the achievement of policy goals. We can see just last Tuesday how the people of Michigan amended their state constitution, and not far behind, the people of Kansas addressed their constitution. And we also saw the use of state constitutionally created democratic mechanisms like the initiative tools to pass minimum wage provisions, to Medicaid expansions in South Dakota, and many others. So what do I want to focus on today? Well, we need to quickly deal with three issues, right? What makes a constitution modern or progressive in the 20th and 21st century sense of the word? Two, can any US constitution be characterized as such? And three, what role can they play with regards to the development of modern constitutionalism in the United States? So what makes a constitution modern? I don't have, unfortunately, the time to go into detail as I would want, but there's maybe at least an element of substance and an element of process. With regard to some substance, we refer to a broader view of the quantity and scope of rights. If we look at the U.S. Bill of Rights, that's a very short list. And I think modern constitutionalism requires a broader set of rights, and that has a broader scope of effect. For example, new political rights in terms of privacy, personal autonomy, environmental protections, labor protections, enforceable socioeconomic rights, and even the notion of transcending state action and the horizontal effect of political rights. With regard to policy, right? Most modern constitutions address important issues such as the death penalty, legislative priorities, etc. And one of the points of modern constitutionalism is to bind legislatures, right? We're setting off the last remnants of parliamentary sovereignty, the notions that we, the people, want to bind our representatives. And that includes on policy matters, particularly in situations like the United States that has had a history of elite capture of legislative processes where economically powerless majorities are unable to wield political power. This brings us then to the matter of process, right? That modern constitutions are written democratically, which means that there's a connection between drafters and their constituents. It's public, so therefore it's transparent, it's accessible, which avoids elite capture, self-dealing, corruption, self-representation. It's supposed to be we the people, not we the elites on behalf of the people. It's supposed to be participatory, of citizens engaging and direct involvement in the drafting of their constitution. And it's got to be popular, right? It's got to be a nature of the constitutional body, and its composition has to reflect the society it purports to govern. Now, what would make a particular modern constitution progressive? Well, I think this is just an extension or maybe a little push or byproduct of what is a modern constitution in the first place, right? It tends to address social justice issues with the distribution of wealth and power, not just public power, but private power, which can also be a source of oppression in the modern world, and the democratization of politics through many possible mechanisms. For example, most modern constitutions talk about labor. They talk about employment conditions. They talk about limits on corporate power. They talk about protecting the environment, a broader view of political rights, which are obviously missing from the U.S. Constitution. In terms of process, these constitutions are normally written in moments of great historical importance, where there's a social mobilization and engagement by the public, and therefore it tends to be highly democratic and participatory. And we've had state constitutions in the United States that fit this bill. Many were written during the populist movement, the progressive era, the New Deal, the civil rights movement, and the Great Society. And again, there's a mistrust that representative politics will cure all ills, that sometimes the people have to self-govern and bypass what could be disconnected legislature or hostile courts. And we come to popular agreements on the basic elements that maybe those legislatures have failed to address. Now, are there any state constitutions that can fit this bill? Well, I'll propose a few candidates, not perfect ones, but at least a few suspects for our analysis. The California Constitution of 1880, New York's People's Convention in 1938, the Puerto Rican Constitution in 1952, and Illinois in 1970. So let's quickly talk about these. So California, what were the historical circumstances of the 1880 Constitution? Where it was a popular revolt against the power of the railroads. Specific mention must be made to the Working Man's Party of California, which was an offshoot of the First International, and that dominated that convention. And there was this great concern about elite capture, corporate capture of the state legislative process. What about the drafting process itself? Well, the social composition of the convention was very interesting. Not only did it have a lot of lawyers, it had farmers, it had plumbers, it had clerks, it had journalists, it had ordinary people serving on them. What about the substance of the Constitution that came out of 1880? Well, it curtails corporate power. It includes labor protection. The current articulation of the California Constitution includes explicit protections on privacy. And obviously, we know that the California Constitution has been amended about 400 to 500 times. So there's some of a weaker connection between the original Constitution and the current one. But the exercise stands to reason. So in 1976, for example, the voters of California, using one of the direct democratic mechanisms, the initiative process established by the Constitution, amended the Constitution of California to include important labor protections. that 1976 process checks many of the boxes that we have mentioned so far. What about New York's 1938 People's Convention? Well, it was in the height and the energy of the New Deal. Again, there was this concern that the state legislature and state courts were being captured by elites, so the people had to literally take power in their own hands. That's why we call the 1938 convention the People's Convention. So who drafted? Who were there? Were there ordinary citizens, member of labor groups? Women, for the first time in a New York convention, participated in the drafting body. So again, it was this highly democratic and participatory environment. Well, what about the substance? Well, the Constitution of New York has important protections for labor rights, including, for example, a provision that states that, quote, labor of human beings is not a commodity nor an article of commerce and shall never be so considered or construed. Though that's modern language right there. Anti-discrimination provisions, not only in the workplace, the private workplace, and in renting, in rental and housing practices. So therefore, an anti-discrimination provision that transcends the need for state action and can have also horizontal effects. What about Puerto Rico in 1952? Well, it's not a state, right? But I think maybe can sort of fit the bills in a way. Even though the fact that Puerto Rico is still subject to a colonial relationship with the United States means that the U.S. Constitution is hardly a modern document. I cannot think of a modern constitution that would allow colonialism to continue. But anyway, so what was the historical circumstances, 1952? Well, it was a moment of great progressive energy after the Second World War and the new international human rights regime. There was a moment of great class mobilizations, matched with great social ills, and a social consensus by the people of Puerto Rico that the Constitution of 1952 would be the best shot they had to address these ills. What about the drafting history, the drafting process? Well, again, the social composition of the convention speaks volumes. There were farmers, there were labor leaders, there were journalists, there were teachers, there were actual members of the public there, not just lawyers and the elites. People submitted their own proposals and were considered by the convention. There was a robust public debate, which explains why 82% of the electorate finally approved of the Constitution. And with regard to substance, well, the Puerto Rico Constitution has an explicit privacy clause, an explicit ban on the death penalty, an enforceable human dignity provision, justiciable socioeconomic rights like labor protections and education guarantees, etc. And finally, we have the Illinois Constitution of 1970, which was written at a moment with environmental and feminist movements had great political power. The drafting process was led by after delegates that were elected in a nonpartisan election. There were dozens of hearings across the state. Thousands of citizens participated in those hearings. And with regard to substance, the Illinois Constitution has very interesting language. Let's just, for example, focus quickly on the preamble, which states that one of the goals of the Constitution is to eliminate poverty and inequality and to assure legal, social, economic justice. That's a stark contrast with the U.S. Constitution. There are other constitutions that we could use as examples, maybe in Montana, Hawaii, and others, but these are the ones I focus on. Now, and one last point, what has been the tragedy here is that these state constitutions have been the victim of judicial under-enforcement. Courts have been the main obstacles to realizing the full potentials of modern state constitutions. Courts sometimes forget they have a majoritarian role in making sure that the people's commands are enforced. It's sort of a reverse activism, to borrow from a previous speaker. If only state courts were really originalists, maybe those state constitutions would have a fuller life. So what is their potential? Again, what can they teach us? Okay. Well, first of all, yes, this is literally the last slide.
Okay, fantastic.
Yeah.
My apologies.
I tried to time it. No, mine. So the U.S. Constitution cannot do anything, cannot do everything. It cannot continue us on a path to achieve the modern tenets and changes in modern constitutionalism. We would need state constitutions to share the weight there. And first of all, I think eventually the United States people will come to the realization that we are a little overdue on Jefferson's 19-year suggestion that we change the Constitution. And these state constitutions serve as proof of concepts that a modern constitution can exist in the United States. And also, in the meantime, while we do that, they are going to be our best bet in making sure that modern constitutionalism still has a place in the United States. Thank you.
Thank you so much. My apologies again for interrupting you. And now we will go to our last speaker, Sandy Levinson. It's all yours. You may start when you're ready.
Okay. Thank you very much. I'm particularly glad that I'll have the opportunity to read the extended papers in the forthcoming issue, and my remarks, for better or worse, will certainly be elaborated. This last year, I was asked to contribute to a symposium that appeared at the international blog site Verfassungsblog on, quote, what coping strategies courts around the world have developed to safeguard their institutional autonomy against attacks and structural interventions by governments, unquote. No doubt most readers almost intuitively feel that such institutional autonomy, captured, I suppose, by the phrase judicial independence, is essential to a liberal constitutional order. This means, does it not, that we as academics devoted to such an order should rally around courts and judges when they come under attack, and especially the threats of, quote, structural interventions by government. This latter could include presumably threats to pack a court through expansion or to unpack it by forcing the resignation of objectionable incumbents. This is undoubtedly an important, even an urgent question, as is true, though, of almost all legal questions, especially questions of constitutional design. Its answer depends very much on specific context. The discussion in Verfassungsblog was provoked, no doubt, by developments particularly in Hungary and Poland. In these particular countries at present, but not only in these countries, it is not difficult to decide which team one wants to root for, as between an independent judiciary and an authoritarian parliamentary party eager to defang the judiciary as a potential threat to its ambitions for total control. This is probably the case in Israel right now, with Benjamin Netanyahu preparing to take power once more. But the problem for constitutional theorists is whether this is a contingent fact based on the concrete identity of the parties, or instead the expression of some universal truth. Should we always and without exception root for judges against any potential adversaries? I doubt it. There is, to be sure, good reason to believe that any legal order will need people called judges to adjudicate disputes, and it will be vitally important that these judges be trusted so that the losers will be good sports in accepting verdicts that they might otherwise lament. But this does not entail, I would argue, any particular fine-grained theory of independence, especially when decisions have wide ramifications for the society at large, going well beyond the identities of the actual litigants. Several years ago, Stephen Burbank and Barry Friedman edited a collection of essays, Judicial Independence at the Crossroads, the first chapter of which, by Charles Cameron, was titled, quote, Judicial Independence, how can you tell it when you see it, and who cares, unquote. He asked whether the concept was too ambiguous, amorphous, or confused to be truly useful analytically. If one rejects that somewhat dour possibility, it still requires very, very careful presentation as to exactly what one means by the term and why it is, in fact, both empirically and normatively important and desirable. Cameron, for example, noted Louis Kornhauser's own essay in that volume, which made the point that judicial independence is not an end in itself, as is true of everything in the Constitution of the 1787 Constitution, especially prior to the Bill of Rights. Everything that comes after the preamble should be viewed as simply instrumental to the preamble. We write a constitution not because we want to elect a president, not because we want to have inauguration day on any given day, or even to have a Supreme Court, but because we want to establish justice, provide for the general welfare, and things like that. So the question is, to what extent extent particular conceptions of judicial independence at given times in history are in fact functional to achieving the great purposes of the preamble. And if they're not functional, then, why bother, or why invest so much energy in rallying round the concept or the judges? Similarly, Linda Greenhouse, introducing in 2008 an issue of Daedalus, the publication of the American Academy of Arts and Sciences on the topic of judicial independence, titled her introduction, Independence, Why and From What? Noting that the term, quote, is a concept easier to salute reflexively than to grasp fully, unquote, especially if the example being considered is, let us say, justice administered by a party boss instructing a captive judge how to rule. It is not very difficult to say we don't want the local boss, whether Frank Hague of Jersey City or Vladimir Putin, to be able to call up a judge and say, decide the case in this matter. But that, quite frankly, is not a truly interesting example or a vital example of the kinds of controversies that are much more frequently likely to arise. In my own book, Framed, written in 2012, I suggested that there were a variety of different rationales for so-called judicial independence, all of them resting on highly contestable assumptions. One might support judicial autonomy, for example, because one treated law itself as both entirely separate from politics and just as importantly believed that there was something that is sometimes referred to, especially in Europe, as legal science that allowed its adepts to apply the law in a way, for example, that we might expect trained engineers to apply the laws of physics or material sciences in designing a bridge or a skyscraper. Of course, one must presumably believe that it is desirable to privilege law over what might be disparaged as political decisions. Ronald Dworkin, for example, liked to describe at least his preferred conception of the judiciary as, quote, the form of principle, unquote. This, I think, had the effect, which I regard as thoroughly unfortunate, of contributing to the notion that all of the other institutions of government are not really to be taken seriously, that only courts are the form of principle. Forget it with regard to Congress. Dworkin also famously believed that there were uniquely right answers to legal questions and that we should expect principal judges, and why would we want any other kind, to enforce these legal requirements without fear or favor, regardless of the consequences for society at large. I suggest that few of us, and so far as us is concerned, that includes myself, believe in legal science or the reality of singular right answers. I do happen to believe, incidentally, that the current Supreme Court is probably the most Dworkinian court in our history, because I do think that, and I'm quite serious about this, I do think that one way of reading the current majority is that they view themselves as Herculean figures who do in fact know what the singular right answer is and who are fearless in imposing their notion of singular right answers on the rest of us. I think that is a rather mad view of jurisprudence, but it is a version of what Professor Dworkin was arguing for the past 50 years or so. Moreover, as one of the earlier speakers pointed out, this elides the question of whether a right answer could also be a dreadfully immoral answer, and whether right-thinking judges should be concerned with that sort of question. Dworkin notably dodged that question. He notably never, ever wrote any deep examination, let us say, of the role of American judges in enforcing slavery prior to the 13th Amendment, nor, to my knowledge, did he ever write anything serious about South Africa. As Holmes argued long ago, the life of the law is experience, not logic. And experience in this case includes beliefs about the ways that society does and should operate in order to arrive at such contestable ends as establishing justice. So even if judges do offer explanations for their decisions, which is sometimes different from senators or even presidents, what if one disagrees with them? Is there any recourse, or are we obligated under the right theory of the rule of law, or under the right theory of constitutionalism, to submit to judicial decisions under the rubric of independence? And it's quite obvious, I think, that is not likely, or I think it's not ultimately tenable. I also want to point out two other justifications for judicial independence or a strong judiciary if one rejects the idea of legal science and a certain version of legal expertise. One of them is simply that judges are wiser than other people in society. I find that wildly implausible for a variety of reasons, including what I increasingly regard as the warped nature of legal education in too many respects with regard to producing genuinely wise lawyers instead of technically talented lawyers. I think law schools do a good job, all things considered, the latter, but I don't think it's the same thing as wisdom with regard to the way society should be structured. The other possibility is that we really want judicial independence, but what independence means is unaccountability to the people, unlike presidents or legislators. And this, I think, is attached to the Dworkinian view that the people, at the end of the day, aren't really to be trusted, whereas lawyers and judges, for some reason, are. So what this means is that in my own case, I always want to ask, which judges are we being asked to write blank checks for in the name of some ideological notion of judicial independence? So with regard to the Ravasin blog, I was not answering the question from the perspective of somebody in contemporary Poland or Hungary or Israel, where I would be very happy to defend the living judges against the depredations of the authoritarian parliamentarians. But I answered the question from the perspective of a citizen of the United States. And I will simply say that I am not very taken these days with the Supreme Court of the United States as the ultimate interpreter of the Constitution. I think they have made a number of truly dreadful decisions in terms of the future of this country. No doubt we would be at each other's throats if we really talked about Dobbs as exemplary. I am even happier, though, to talk about the New York gun decision, which I think is indefensible on every ground, even though I happen to believe that Heller was rightly decided. I don't object to the idea that the Second Amendment protects some kind of right to bear arms. I do think that the New York decision is just remarkable. This attaches to the earlier presentation, Professor Fairness's presentation. I am thrilled that he brings to our attention the fact that the American constitutional tradition includes 51 constitutions, and that the United States Constitution, the national constitution, is an outlier in all sorts of respects. One of them, of course, is the degree of judicial autonomy. You get to the US federal courts, you're there forever. You're stuck. with them. There is no real way of getting rid of a judge whose judgment, or for that matter, even his or her legal competence, you tend to doubt. For better and maybe for worse, that is not true in the overwhelming number of states. My state of Texas elects every single judge, every single member of the court serves only a 6-year term. Now, for a variety of reasons, I'm open to criticisms of the way that we in Texas elect judges. 6 years is actually too frequent. They're elected on a partisan ballot, which raises the really ugly issue of financing elections. I certainly do not want to defend what is going on in a number of states, even as we speak, with regard to elected judiciaries. But then I don't particularly want to defend a process whereby partisan presidents pick judges that are then either rubber stamped by partisan senates or, as with Judge Garland, simply rejected on a willful partisan basis. All things considered, even if I think Texas is not quite the model, I'm quite happy by looking at other states that present, I think, much more attractive notions of trying to achieve some balance with regard to getting trustworthy judges, where trust is a mixture of professional competence, wisdom, and willingness to stand up to a mob if there is a mob that needs to be stood up to, and accountability. Whether the accountability is retention elections or the ability of state legislatures even to impeach and the like. The last thing I'll say, because I expect I've come to the end of my 15 minutes, is that I don't think that general references to judicial independence are likely to be very helpful, that one really does have to get into the weeds of providing specific details, including empirical data, as to why one thinks that one's particular conception of independence is going to be all that helpful.
Wonderful. Thank you so much. All right. Thank you to our 5 panelists for our final panel of the day. Olivia, is that a question in the Q&A? It is. All right. We'll answer that question quick.
We have a question.
Oh, sorry. My mistake. Yeah, Dr. Reed. Yes.
We should. I have questions for each of the panelists, and I'll begin with Professor Paulson. And I actually have a 3-part question for Professor Paulson. And that is, we'll begin with asking you to compare your presentation to Professor Tamanaha's observation that rules are inert until given life by persons. And this is especially, I think, perhaps applicable when we look at open-ended terms of the Constitution, such as the Due Process Clause, the Commerce Clause, which were controversial even in the 18th century, uncertain of meaning even in the 18th century. Then I have a question related to this reading. The first question is the question of the relationship of rules and persons. The second question is the act or the art of reading. Reading is always an act of recreation. We always recreate meaning. Reading is, again, a response to words on the page, but it's always a fresh recreation, a fresh response to words that in the case of the Constitution are now almost 250 years old. But it's always an act of recreation. My third observation is regards the historical enterprise, where I think originalists might go astray. The historical enterprise is the past is a strange place. It is a different place. Professional historians know to emphasize the discontinuities between the past and the present. originalists seem to avoid the issue of discontinuity altogether with a kind of hopefulness that things have not changed. But I mean, look at, for example, the differences that prevail between the founding period and our own period regarding state structure and state responsibility and position in the world. And finally, just another observation, what is the founding period anyways? Is it 1789? Or is it the post-civil rights amendments? Professor Amar will argue it's the post-Civil War amendments. I have some questions for Professor Epps. And my question for Professor Epps again is to draw attention to Brian Tamanaha's observations regarding the unspoken customs, the unspoken constitutional principles that are out there. And I'm going to give that a term that he did not use, but I'm going to coin the term now. Are there meta principles of constitutional law that simply should govern the way we react to a written constitution? Are there meta principles that govern our conduct under the Constitution? And if there are, what are they? My question to Professor Farinacci is, I mean, my goodness, should we embark, I mean, one question is, should we embark upon a new constitutional convention and simply scrap the old rag? I'm not, I'm not sure that's a wise course right now, because I can imagine the political discontent that would give rise to. And if that's not our alternative, then what is our alternative? Is it to return to a form of living constitutionalism that modernizes and updates the Constitution? We saw this particularly clearly historically in the Warren Court. The Warren Court intended to update the Constitution on issues like civil rights, Brown versus Board of Education. If you look at some of the Warren Court statutory decisions in the area of labor law, where I teach, the issue of a number of interesting, important labor law decisions came down during the Warren Court. We saw again the emergence of democratic self-governance as a norm in the Warren Court with Baker versus Carr. Should we therefore turn to a living constitutionalism in lieu of the horrifying prospect of having red versus blue engage in a pitted civil war over the new form of a new constitution? And finally, Professor Levinson, judicial independence. I will pose a question where I think judicial independence might serve a valuable function, and that is to take what H.L.A. Hart calls the open texture of law. The open texture of law is basically where problems remain unsolved, where the courts are called to respond to new and novel questions. And do we want courts that are too beholden to politics when we are resolving questions of open textured policy? Now, one could argue that perhaps these open textured questions of policy should properly be put to the legislature, and maybe that's what your argument is. But absent that, do we really want the courts to be beholden to political interests, or to have some degree, and maybe independence is not the right word, maybe integrity is the right word? Those are my questions. Oh, Lucas, I forgot you. I've got a question. I skipped that page. I must ask Lucas some questions. So why should we be bound by classical legal theory? It's not in the text. So do we make a conscious choice to be bound by classical legal theory? Or alternatively, if classical legal theory is indeed natural law, then perhaps it immediately binds us whether we know it or not. Does it work like gravity, in other words, which binds us whether we ever heard of Isaac Newton or not? Anyway, those are my questions.
Wonderful. Well, we'll start with Professor Paulson.
I was going to appeal to you. Do you really want to keep people from their happy hour for, okay. As I counted, Chuck asked me 7 questions. I will try to give 2-sentence answers, bullet points. He says rules are inert until people apply them. I think that's right. The Constitution is a dead piece of paper. It is words on paper. The question is, what is the task of interpreting and faithfully applying the Constitution? And that's the project that I'm engaged in. The second part of his first question was, aren't there open-ended constitutional provisions? Well, some there are and some there aren't. And there are rules for interpreting a provision. I actually disagree with Sandy Levinson that there are no, I actually think there are single objective right answers to constitutional questions. I don't know all those answers, but I think I know the method for getting at them. Sometimes the answers are simple. How old does a president have to be? 35 years. Sometimes the questions, the Constitution has a range of meaning and a range of uncertainty and a range of ambiguity. But I think there are default rules for when you are uncertain. When you cannot say that the Constitution supplies a rule or principle that governs a case, it has to default to some other source of law, and that's typically democratic self-government. So there are rules for ambiguity, and there are disputes as to when something is ambiguous or not. I think ambiguity would be lessened significantly if people adhered to the original meaning. Chuck says reading is always an act of recreation. I'm tempted to say no, it isn't. But it is to some extent. There's always a reader, but the strong version of his deconstructionist attack is that there is no intrinsic meaning to words, or that the interpretive enterprise is futile, and I don't think that's right. I think the words have meaning enough. When he said reading is always an act of recreation, I was tempted to say, well, I'm going to recreate your question and ignore it. He says the historical enterprise is difficult. The past is a strange place. The past is a strange place, but it is actually, there are available historical sources that are useful for plumbing original meaning. There's the document itself. There are 18th century and 19th century dictionaries. There are legal dictionaries. There are the records of the debates of the Constitutional Convention. You can see what they were thinking and talking about and how they changed the draft. There are the records of the Constitutional Convention, ratifying conventions, debates. There's a wealth of evidence. It's not just something that you just make up by the case method. There is historical materials to be looked at, and that's relevant, and that's what we should be teaching in law school. What is the relevant founding period? For the 1789 Constitution, it's 1789. For the 1860s post-Civil War amendments, it's the 1860s. You're always looking to the original public objective meaning the words would have had at the time they were drafted and in the community they were adopted. Oh, okay.
Wonderful. Thank you. Lucas.
So thanks for the question, and thanks for inviting me here and for organizing this. I realize I omitted that through rushing my presentation. I think there's a difference between classical law and the classical legal theoretical approach. I think one answer is that a lot of the aspects of modern common law is based on classical law, and we just don't realize it, particularly when it comes to property and things like this. The second issue is to the extent that it is natural law. There's a bigger theoretical debate, which I won't get into because people fall asleep, but between primary and secondary rules of natural law. So the primary rule of natural law, which is also one of the most famous quotes to do with the civil law, that the classical law is good is to be done and evil avoided. And that's something that we're all bound by, whether we want to be or not. We pursue our good. Aquinas would say as part of our nature, we pursue what we perceive to be good, and we avoid what we perceive to be evil. The secondary rule, so don't steal, don't rape, don't murder, in certain exceptional circumstances, that might be obscured. So Aquinas gives the example of Caesar discusses it, Julius Caesar, of the Gauls, that they stole things because they thought theft was not wrong. And theoretically, they should have known that it was wrong because it was inscribed on their hearts. So I think the primary rule binds us. Secondary rules normally bind us, unless we live in some crazy society. Maybe we do. So I think that's why we should.
And so the Constitution is necessarily a natural law document.
I think in order for human laws to be legitimate, they have to be based on natural law. That would be the classical theory approach. We don't just, law doesn't come from nothing. We're not God. We didn't create the world from nothing. And therefore, in order to be a just law, it has to be deduced in some way from the natural law. And therefore you can't have a law that says go kill people, go murder, because that is clearly not deduced. I mean, the natural law says thou shalt not murder, and you then murder. That's not a deduction, that's a distortion. That's my attempt at an explanation in 3 minutes or something.
Well, we can go to Garrett and then Jorge and end with Sandy again.
I'm about, we're about 9 questions in, and so I may not remember my question, but I think it was, are there meta constitutional rules? And, sure. I would prefer to call them, as they have been called in constitutional theory for quite a long time, conventions. And I think that conventions, like constitutional provisions, are to be interpreted in line with the nature of the Constitution and its purpose. And I thought Sandy saying, everything after the preamble is instrumental, I think is spot on. The Constitution doesn't exist because, the person we used to call Mr. Jefferson, where I grew up, or whoever was so wise that we just have to act like him now because we're not that wise. That's not why we have a Constitution. A Constitution is a tool that we have that is given to us like a tool. I have some tools that belong to my father that's given to us in order to achieve the aims of the preamble. And I certainly think that the forging of constitutional conventions, beginning with the very first constitutional dispute in American history, which was about the removal power, since the framers forgot to put into the Constitution that the president can fire members of the cabinet, they have to be worked out exactly the way the Constitution itself has to be read. And that is purely instrumental as tools to achieve the goals that are set out in democratic moments for society. Now, the reason I don't want to call them meta is they don't come from the brooding omnipresence of reason. They are kind of the cloud of witnesses that come with the specific provisions in the Constitution because, and this was the point of my presentation, if you sit down and try to read, the 14th Amendment, Section 4 of the 14th Amendment without any sense of the background and the aim, you're liable to come up with some gibberish. And there's a lot of gibberish being talked today. When I say today, I don't mean here and now, I mean in the world.
Yep, go ahead, Jorge.
Okay, perfect. So I think, at the very least, before we talk about how and when to replace the federal constitution, I think we should at least pronounce it dead from the perspective of modern constitutionalism and start planning the burial and eventually the replacement. But in the meantime, we do have these state constitutions that are alive and therefore can step up and do many of the things that the U.S. Constitution cannot, which actually brings me to the issue of why on earth would we allow ourselves to be governed by the Framer Society? Well, I think there's 2 criteria for that. Number one, do we feel bound by the way it was created? Do we think that the way it was adopted generates legitimacy or authority? And 2, do we agree with what they did? Those are 2 basic components. That's why peoples around the world replace their constitutions. Now, I think the U.S. Constitution fails on both questions. I don't think it was adopted in a way I would consider legitimate, and I don't think the content of it reflects a modern society. So therefore, that brings me to 2 conclusions. One, I am not an originalist. With regard to the U.S. Constitution, give me a democratic and modern U.S. Constitution, and I'll be an originalist. And with regard to state constitutions that do check the boxes, my call is for state courts to be originalists, which they tend not to be. They're only originalists with an 18th century document. They are not originalists with the 21st century documents for some reason. So I think that sort of brings me back to the main point with regard to what about the future of constitutionalism in the United States. And the current US Constitution may have some pulses like the Ninth Amendment that could give it artificial life, and we haven't been able to make full use of it. But at least to recognize the role that modern state constitutions now have, not just as a constitutional safety net, like a plan B. The plan B has, in many instances, become the plan A. And I think a final note with regard to the actual question of when should we have a second convention, I think we're on our way in the following sense. The circumstances are horrible, I agree. But if while the average US citizen starts to learn that their constitution really doesn't have a privacy clause, really doesn't have the right to association, the right to vote is actually implied, that you really don't have a right to education, that you really don't have a right to this, the eventual conclusion will be, well, damn, we need a new one. And I think what they are doing with state constitutions and putting privacy rights there and putting educational rights there and putting environmental provisions there means that there's a thirst for modern constitutionalism in the United States. Right now, the main vehicle are state constitutions. Let's enforce them. Let's put them in their proper role, and then maybe we'll have a critical mass. And who knows? We could have finally a 21st century constitution for a 21st century society.
Wonderful. Thank you. And lastly, Sandy, you may.
Drawn from the immediate I strongly support a new constitution, new constitutional convention, and I strongly support, therefore, the need for a quite drastically revised constitution. Where I somewhat disagree is that I don't really care all that much that the national constitution doesn't have a specific right to privacy or specific right this, that, or the other, because for better, and some of you may think for worse, we do have a living constitutional tradition where judges will read these fundamental notions into the Constitution. And so when I look at the Constitution and say what's wrong with it, it really has almost nothing to do with the rights provisions. It has everything to do with, let us say, the United States Senate, which I think is no more legitimate than was slavery in 1787. I use that advisedly because both compromises were necessary to get a constitution in the first place. And thus, I don't really necessarily denounce those framers who were anti-slavery, who said, you know, we really do need a constitution because we're surrounded by countries and indigenous nations that don't wish us well. And if we want to survive into the 19th century, we're going to need to unite. And the only way you unite is by compromise with slave owners, in the same way that the only way to defeat Hitler, which was highly desirable, was to ally with Joseph Stalin. But nobody would say, oh, we really do have to think better of slavery because after all, the framers did. That's a crazy argument. And it's crazy not only because the 13th Amendment invalidates it, and I think it's also crazy to say we ought to be stuck with the Senate. Now, I certainly am no originalist, but I do find myself at times as a mindless textualist. That is to say, I don't think the U.S. Senate is unconstitutional. What part of 2 do you not understand? It's simply indefensible. And therefore, and incidentally, I strongly supported your former governor, always identified as the maverick, Jesse Ventura, because he wanted to emulate Nebraska, another state that I really admire, because they got rid of their totally unnecessary Senate in 1934 because they had the opportunity of initiative and referenda. One of the things I really dislike about the national constitution is that for all the talk about we the people, it is designed in such a way as to eliminate any possible role for actual governance by the people under any circumstance. It's all done through representatives, and that gets us a thing. One final point. With regard to Professor Reed's questions, you know, Goldilocks is right. Goldilocks is my favorite political theorist. You're always looking for some point in the middle. And I really don't think that courts should be entirely subservient to politics. That being said, I also don't believe that we should lightly accept a notion of judiciary that is not politically accountable at all. One of the things I elaborate in the longer remarks, and that will certainly be in my article, is that if you really believe in a strongly independent judiciary, then you ought to adopt what I call the French Academy model of judicial selection. That is, when one of the immortals dies, the other surviving immortals pick the successor. Le Monde might write an editorial, but Le Monde, the French president, nobody else has any say except the surviving members of the Academy. So you can imagine, in fact, if you look around the world, you do find some systems in which the judges pick their own successors. That is real independence. Now, for better and for worse, it's not or, it's and. We have a thoroughly politicized process by which we pick members of the federal judiciary. I'm not going to defend every feature of the current thoroughly political process, but I would suggest that over the years when I have offered the French Academy or the Harvard Corporation as the model for how to pick judges, there are almost no takers. People like the idea that political decision makers pick judges in part because they are presumed to share overall visions of the kind of country we should be. And so, you know, that's why I think you really have to get into the details, into the weeds. And why we're always looking for Goldilocks points, and we're going to disagree on what the Goldilocks point should be, but I'm quite confident that relatively few people listening to us today really think the French Academy presents the right model, just as almost nobody would say, oh yeah, I'm really very happy with the idea that boss Frank Hague or Vladimir Putin should simply be able to pick up the phone and tell the judges how they should rule, or to fire a judge who, you know, the day after the judge makes a, quote, wrong decision, unquote.
All right, excellent. Well, thank you all for those wonderful answers. If there, one last call for questions from the audience members. I don't want to leave you all without the opportunity since you have arrived in person. If not, I do want to provide a list of thank yous to a number of folks who helped us put together and run this show today. I first want to thank Xander for helping with IT. You have been phenomenal. Let's give him a big round of applause. Second, I want to thank the Symposium Committee. They've been excellent in being right along beside me and helping me organize this. So another round of applause for them. Another round of applause for our Editor-in-Chief, Taylor Daniels, and our faculty advisor, Dr. Reed. Thank you both for helping get such a robust panel today and robust speakers. It's been a delight. And lastly, to all the speakers who came in person, we are thrilled that you're able to join us today and share your insight, share your wisdom, share your knowledge. I've taken a lot out of today, and I hope you have as well. So let's give one last round of applause to our speakers. And to the journal members, thank you. It's been a long day. We appreciate your enthusiasm and engagement all day today. So please take the night off and get some rest. Two last things. Please return your name cards to Mr. Kevin Green and Mr. Faranici. Mr. Furnos has left us, but he did a podcast with us. Oh, he's back. He's back. Yes. Thank you again for doing the podcast. If you haven't listened to it already or not yet, please do so. It's a phenomenal podcast. You can find it on Spotify and our website. So yes, thank you again. That is all I have. Have a great night, everybody.